I have a very
application criminal matter of the other bench. Yes, other bench. Yes,
my lord. I have a very
hearing, my lord.
not right now. Call.
my lord.
Order put on, my lord.
My lord.
I have one in the
My
lord.
one who is
my lord. My very extremely urgent matter, my lord. This matter is directed. My lord.
one who is appearing.
Yes,
what is that? Child has been returned.
Yes, he is here, my lord. Only, my lord, before your lordships, my lord, kindly take into consideration certain.
So, Basu, as far as we can recollect, we directed visitation of the.
No, my lord, first of all, the court's order must be
Taking-
complied with
taking-
under any
we understand those high words.
No.
But taking advantage of the court's order,
No,
you cannot
we
take away
did
the
not
child.
take any advantage, my lord. Your lordships were never, my lord, kindly see, my lord, kindly have the charity to consider. Your lordship, on the basis of this application, my lord, on 3rd August 2026, my lord, yesterday, your lordship had passed an order, which is, my lord, a sequel to an order application for recalling. My lord, kindly see, my lord, kindly allow me, my lord, only I will take, my lord, only 5 minutes time. Now, my lord, kindly, before, my lord, comes to a final decision, kindly, my lord,
Sir,
the child
Basu,
is here.
We don't want an exhibit here.
No, I
We
don't.
direct the child. The mother can take the child.
He is here.
Mother can take the child, return back the child.
Yes, mother is here.
Mother
Yesterday-
cannot. We don't want the mother to see the mother.
No,
Mr. Basu, no. You cannot take advantage of our order.
I did not. We did not take any advantage.
Return the child then.
Yes, my child is here, but the question is.
We don't want the child to
No,
see the child.
no,
Return it to the father.
Kindly, kindly, give us one opportunity. Kindly, in camera, kindly talk to him. Only 5 minutes.
First, he has to be returned. No,
Return, here. Child is here.
no.
Kindly,
Don't create a scene in court, Mr. Basu.
Kindly, otherwise,
No, our order was specific. We gave liberty to the mother to visit the child, to take the child also.
Right,
Under the trust that the mother would return the child then.
right.
You have broken the trust,
No,
Mr.
Milord,
Basu. And
we
we are
did not.
seriously thinking whether we'll recall the right of visitation also.
Only,
No, no.
We did not get any
Mr.
opportunity.
Basu, please return the child first.
Yes, today he is here.
Return him.
Yes, but kindly, he's
Yes.
apprehensive. His life is at stake.
No,
Kindly,
cannot.
kindly have the kindly.
Mr. Basu, no. We directed
No.
visitation
Right.
for a limited period. The mother took the child.
Mother did not take.
Mother
the
had
child.
to return the child.
The child, had taken a decision out of his own volition. He went to the Netaji metro station, and then he asked his mother that
You file a proper application for modification of our order, we will consider. But first return the child.
In the meantime, if the child faces, he has
What will
some
he face?
difficulty.
He
That
was
is
with
why-
the father.
That is not the climate reality,
Mr. Basu, he was with the father.
He was with the
As
father.
per our direction, you have got the child.
Kindly.
No, you have to honor that order.
Yes, I
No,
have
Mr.
to.
Basu. Sorry, no.
I have to.
No,
honor.
this is contempt of court.
Yes, contempt. Kindly says, but every.
Mr. Basu, whatever you say, first return the child, file a proper application, we'll consider.
The
No.
business of your lordships are.
No, what? No business. There's no. You are violating the order of the court. You are taking undue advantage of the order of the court in not returning the child. It cannot be, Mr. Basu.
Child.
Very sorry. No, whoever appears. No. Return the child first.
Yes, the child is here, and
We don't want to see the child. This is not an atmosphere for the child. This is not innocuous. You have violated the order of the court.
I did not violate. The child did not want to stay with the father because.
First return the child, then we'll consider. File a proper application, we'll consider. No problem. First return the child. Mr. Basu, as far as we can recollect, Mr. Basu, if this happens anymore, we'll direct police production.
Milord, kindly sees the what happened.
Mr. Basu, you cannot take advantage of the order of the court. No, no, no. We have directed the child was with the father.
Right.
We, as per our order, we directed under the trust on your client that your client would take the child and return the child.
Yes, absolutely.
This cannot be the situation
Absolutely.
that no, first return the child,
Yes,
child has to go back to his father, then we'll consider file a proper application. We may grant you visitation, we may grant you custody even. But now you have to comply with the order of the court. You cannot violate the order of the court of your own whim. No.
No, I did not. The child will out of.
Sorry, Mr. Basu, we refuse your prayer. First return the child goes back, then we'll consider file a proper application, mention it, we'll definitely consider whether to keep the child with the father or to return.
Child is saying he is not. Child is not.
Thank you, Mr. Basu. We are passing our
Yes, I have the audio recording.
The child has been brought in court, Fullstop Learned Counsel for the respondent wife vociferously submits that the child does not want to return to his father. Fullstop, however, we take note of the fact that the custody of the child was with the father, that is the appellant, all along during the relevant period when the order was passed. Fullstop, it is only by dint of our order that the mother got a right of visitation. full stop. However, comma, taking undue advantage of the same, comma, the mother, that is the respondent, is not willing to return the child to the father on the ground that the child himself does not want to go back. Full stop. Next para, the orders of the court are passed in trust on the parties. Full stop. If such trust is broken, comma, the faith of the court in the conduct of the litigant is lost. Full stop. Next para. Thus, comma, to restore such faith, comma, we direct the child to immediately be returned to the appellant father. Full stop. In the event there is an issue of the child remaining with the father, comma, the respondent will be at liberty to file a proper application in that regard to seek modification of our earlier order granting visitation. Full stop. If such an application is filed, comma, an advance copy of the same will be given to the appellant to give an opportunity to the appellant to controvert the same in writing. Full stop. This court assures the parties that it will definitely look into such application, comma, if filed, comma, and pass appropriate orders, comma, if necessary, comma, taking into consideration the welfare and the wishes of the child. Full stop. Next para. However, comma, at this juncture, comma, we are staring at a gross violation of the order of the court in the child not being returned after the mother took visitation. Full stop. Hence, we direct the child to be returned immediately to the appellant father, comma, subject to further orders which may be passed if an application is filed in that regard. Next.
And my lord, in September, my lord, midterm examination is to be held, my lord, and by 6 months.
We'll consider that if an application is
Yes,
filed,
yes,
we'll consider.
yes. I am deeply obliged.
Next.
No, ওটা তো submission.
Yes. Why is it appearing as to be mentioned?
Time for the respondent number one.
Why was it appearing as to be mentioned? Just
Yes.
reminder.
There is a correction is required to be done.
Correction.
by us. Yes.
What is the correction?
But at page 6 of the judgment, paragraph 15.
Yes.
Yes, in his cross-examination, DW1 admitted. It would be my lord PW1 actually.
Oh, acha, acha.
That is all.
Yes, he's right, probably. You are for the respondent, right? Mr.
Time for the respondent,
Page number one and-
respondent number 1 and 2.
Yes. Learned counsel for the respondent numbers 1 and 2 rightly points out that in our judgment dated July 8, 2026, comma, in paragraph number 15 thereof, comma, instead of double inverted PW1, double inverted close, comma, the word was transcribed as double inverted DW1, full stop. Let the said judgment be deemed to stand corrected accordingly, comma, by reading double inverted DW1, PW1, double inverted close, instead of DW1 in the first line of paragraph number 15 thereof. Thank you.
If it's read as a whole, it says when a plain.
Yes, yes, the rest of it, yes. You're absolutely right.
I'm good.
Sorry for this, yes.
No, no.
Yes. Thank you. Next. এগুলো আগে সব order হয়েছে? This is the second occasion when none appears for the parties at the time of call, full stop. Accordingly, CR 2639 of 1991 is discharged. Full stop. FMAT 3273 of 1990 is dismissed for default without any orders to cost. Full stop. Interim orders, comma, if any, comma, stand vacated. পরেগুলো যদি এরকম অর্ডার থাকবে জাস্ট ওখান থেকে দেখিয়ে দেবে যেরকম অনেক দিয়ে দেয় সিমিলার সিমিলার অর্ডার ওই নাম্বারগুলো শুধু চেন সিমিলার 10 সেম সেম অর্ডার yes same same order Passover in the first call বোর্ডে দেখাচ্ছে না Passover in the first call
Lord, I appear for the appellant, my lord.
Yes.
My lord, I think the my lord state will have to be served again, my lord, because the my lord, the matter was last heard on the last year, my lord.
Last
And-
year.
My lord, Mr. Shumun Dev was appearing for the state matter. The arguments were almost concluded, my lord.
Hmm.
But my lord, but the state is answering one of the answering respondent, my lord.
You are for the appellant.
For the appellant, my lord.
Learned counsel for the appellant submits. You are appearing in this matter. Submits. We will call that has been passed. Submits, comma, in his usual fairness, comma, that although the matter was heard at length, comma, in view of the change of the panel of the state advocates, comma, a further notice is required to be served on the state. Accordingly, we direct the learned advocate on record for the appellant to serve a further notice on the state, indicating that the matter shall be listed for hearing next on August 11, 2026. Next
Yes,
Tuesday. Please serve a notice and act a line ad coding. A receipt in that regard shall be filed on the next occasion. If they don't appear, we'll proceed with it.
Petitioner, respondent.
Petitioner,
Respondent, petitioner.
your application.
No, my lord.
Respondent petitioner means?
Respondent, I am the
Watch, this is against a writ order, you are a writ petitioner there. Mr. Vasu, you are appearing in this matter.
Lord, I have one submission.
You have a submission.
One submission.
So we will pass our order in this. Although the respondents are represented by counsel, comma, none appears for the appellant at the time of call. Full stop, let the matter stand adjourned till August 11, 2026. Mr. Basu ki bolchen shune niye, tarpor pass over gulo dasbe. Yes, Mr. Basu.
Kindly do not take me amiss, my lord. This child is, my lord, absolutely arrogant, and my lord, he does not, he said, my lord, he is armed with certain photographs, my lord. He only said that he wants to interact with the lordship for
Not now. First, you
My lord,
return.
my lord, I said, my lord,
Child also has to abide by the order.
my lord, yes, my lord, the child said, my lord,
Don't
that-
so much. Don't encourage him so
No,
much.
I did not. I did.
Mr. Basu, he has to go back to his father as per the previous position. Then if an application is filed, we'll definitely consider and pass appropriate orders. We have assured you and we will do that, but not now. He has to learn discipline. You have to teach him discipline if he does not know.
Then
He has no idea of the consequence of violating an order of the court, Mr. Basu. You have.
I told
you
him,
please
I
impress upon
explained him. I explained to him. Actually,
And this sort of drama we hate. Yes. Call the passover matters. Please take him outside the courtroom, Mr. Basu.
I beg to appear for the petitioner. Mother, may I serve the learned PP office once again? It's a bail in connection with appeal.
That's why you have taken it up.
Mother, I have served already, but let me serve once again, my lord, and then come.
None appears for the state at the time of call. Full stop, the learned advocate for the appellant. Petitioner shall serve a copy, a notice on the state indicating the tendency of the matter in the list. Full stop, adjourn for the day.
Grateful.
কালকে ওইগুলো দিও যাই থাকে এগুলো উপরে থাকে 11টাও ডেকে নাও
Yes.
No.
My lord, I am for the state, my lord.
State,
Yes, my lord.
they have mentioned the matter probably.
This is my first appearance on behalf of.
Oh,
the
you,
state.
oh, right. So very well, congratulations for being on the panel. But it appeared on their mentioning probably.
Yes, yes.
Although the matter was listed on the mentioning of the appellant, comma, none appears for the appellant even on the second call, comma, although the state is represented through counsel, full stop. As a last chance to the appellant to move the matter, the same is adjourned for the day. Mr. Ravi, we are adjourning for the day. Tomorrow, if they don't appear, then we'll put it out of the list and
Grateful.
ask it to directly to go before the day. Yes. None appears for the parties at the time of call. Let the matter stand adjourned till August 11, 2026. Next.
My lord, I beg to appear on
Yes,
behalf of the
Mr. Sur.
petitioner, my lord. My lord, I am seeking time for the respondents because Mr. Kamal Kumar Chattopadhyay is suffering from high fever.
State, he's for the state.
Yes. My lord, to the West Bengal Small Industries Development Corporation. Your lordship, my lord, in this event, my lord, your lordship on last occasion has given them indication also in the order, since they have refused to, my lord, whether they are willing to settle the dispute, my lord, because it is the quantum of the amount of now. And my lord, they have by that time now has filed a vacating application of your lordship's interim order. Although your lordship categorically on the last occasion, I'm just reminding it. So in the
An adjournment is sought on the ground of illness of learned counsel for the WB SIDCL. Full stop. As a last chance to the WB SIDCL to contest the matter, the same is adjourned till August 11, 2026.
much.
আস্তে আস্তে করো, অত তাড়াহুড়ো করতে হবে না। পায়ের দিকে দেখে করো, সাবধানে করো, অত তাড়াহুড়ো করতে হবে না। তোমার লাইফটা অনেক বেশি ইম্পর্টেন্ট, যতই খ্যাঁচ খ্যাঁচ করো। None appears for the party. You are appearing?
No,
None appears for the parties at the time of call. Let the matter stand adjourned till August 11, 2026. Same. Same.
For the respondent.
Respond. 23.
23 respondent, my lord.
Although the respondent is represented through counsel, none appears for the appellant at the time of call. Full stop. Let the matter stand adjourned till August 11, 2026.
August 3.
None appears for the parties adjourned till August 11.
25, my lord, APA for the petitioner.
Take
Nobody.
up.
My lord,
We'll take up.
yes.
If the petition is present, we'll take up.
It was once heard, my lord, on last occasion, it was heard.
Yes, yes.
The learned advocate for the respondent, my lord, had sought for a copy from our end. We have given the copy, but she's not appearing.
Mr. Chokodhar, can you just give us a brief
Yes.
backdrop? I mean, just remind us.
No, my lord, it was not heard before your lordships.
Oh.
It's an assigned matter, my lord.
No, but we see that we have our notes. Must have comments on the last day. And we have cited, judgments have been cited, we have also noted. ঠিক ফাইল দিয়েছো তো?
Item 25, Srimati Shubhra Das.
No, 25 is Orpit Mongol.
Sorry, I made a mistake, man. I'm so sorry.
ওই none appears for the parties adjourned till August 11.
See, I'm for the petitioner. This is a second contempt application, Lordship.
Pardon?
Lordship, this is a second contempt application, Lordship. Lordship, Mr. Borot will appear in this matter, Lordship. Kindly pass it over, Lordship.
We will pass over till item 38.
My lord, I made a mistake. It's item 22. I was sitting here and I missed it. My
Sorry,
lord has
yes,
adjourned it.
Tuesday. But you have made it next
My-
Tuesday.
My lord is adjourned. Let it come back on Tuesday. In the meantime, I shall serve a notice
Better.
that let
We're
them
not
come.
directing it, but you do that.
Yes, yes.
To give a copy of it. I have not received any copy of the petition.
No, I mean,
Which one? Which item?
26.
Lordship,
Yeah.
today is the first appearance, Lordship. Contempt, second contempt application, Lordship.
Contempt, you want a copy? No, we'll just hear her. What is the contempt about? What is the alleged act of contempt? Just tell us if you are prima facie satisfied. If we prima facie dismiss it, then there's no scope.
Yes.
But if you prima facie we are satisfied, we'll do that.
Otherwise, why did
My
you
lord,
that the order is
No, we know you more than yourself, probably.
my lord, item number
So
20.
forget the other item. If you are taking up a matter in the midst of it, don't disturb. Yes. Yes, sir. What is the contempt?
এটাই আমাদের একটু করা উচিত।
Well, in this matter, I have been. This is item number.
26 এবার দেখে নিন আপনার, তাও আমি বলে দিচ্ছি আগে 24 কন্টেন্ট পাস করেছিল, তো সেটাতেও মানে ভাগার অর্ডার হচ্ছে, তো ওটাতে ওনারা কোনো অ্যাকশন নেয়নি, তার সেকেন্ড কন্টেন্টটা অ্যাপ্লাই করে।
Kolkata Municipal Corporation was to consider a representation.
My lord,
And if there is any illegal construction, to demolish it probably and with police help. So what is the alleged contempt? The Kolkata Municipal Corporation has, according to you, not taken any, not considered the representation?
yes,
Not considered.
not considered.
It is alleged by the petitioner that, in violation of the order dated January 4, 2024, passed in WPA within bracket P 616 of 2023, the Kolkata Municipal Corporation has not yet considered the representation of the petitioner and court taken expeditious action if any illegal construction or unauthorized construction has been made. Full stop. Next para, since a prima facie case has been made out, and as Mr. Ghosh, appearing for the KMC is present in court today, the petitioner shall serve a copy of the contempt application on Mr. Ghosh, who will accept the same on behalf of the alleged contemptor during the course of the day. Full stop. Let the matter be listed next on August 11, 2026.
I'm good.
Next Tuesday. Give a copy as soon as possible to Mr. Ghosh.
Yes,
I'll
sir.
have it in course of.
Yes, his office, his clerk will receive.
My lord, with my lord's leave, my lord, if my lord only allows, may I mention item number 25, my lord, my lord was online, my lord, I could not, my lord, log in, my lord.
No. Call on the next one.
Very good.
28, who is appearing? None appears for the parties at the time of call, August 11. Same.
Well, item number 29, I am for the appellant, my lord. Well, I beg to state, my lord, your lordship, while in the single bench, was pleased to consider the matter and dismiss the petition. And that was appealed against. Appeal court, my lord, to some extent altered the order. That, my lord, that has gone to the again single bench.
It has been assigned to me.
My lord, it has
Assigned
been
to us.
assigned because of the subsequent. That was not.
No, we have already put it in on the next Tuesday because you are not there. So that order remains. Yes, next. এটা কত যাচ্ছে? 29 হয়ে গেছে?
Well, same.
30 also, 30. Although the appellant 30 তে হবে, although the appellant is present, none appears for the respondents at the time of call. Full stop. As a last opportunity to the respondents to contest the matter, the same is adjourned till August 11, 2026. Full stop. The learned advocate for the appellant is requested to serve a notice of the pendency of the matter and the returnable date on the state in the meantime. Next.
Number 31. Well, same order.
31 same. 30 তে যা হলো 31
32, 30 same, man. মানে মিস্টার সনৎ কুমার রায় যাবে
যা হলো 31 হতে।
Same, man.
32 বৈদ্যুর্য ঘোষাল is appearing.
Advocate is Mr. Sanat Kumar Rai. I reject the same order, man.
Akshat, up to which item?
Up to 33, my lord.
32, 33 বোর্ডে দেখাও। Individually same orders possible. Next.
28 to 30.
28 to 29 we have called. These matters please serve a notice to us. Yes.
Lordship,
You
in
can serve
item
the other matters also, even if you did not that. 30 কত
Lordship, in item number 34, Lordship, I am for the appellant, Lordship.
Yes, please. What is the matter?
Possibly, I need to serve the state once again, Lordship. There is the effective respondent is the
appealing?
registrar of trade union. The
All right.
registrar of trade union is the effective respondent, Lordship.
Since none appears for the state, although the none appears for the respondents, although the appellants are represented to counsel, on the prayer of learned counsel for the appellants, we direct the learned advocate in the court for the appellants to serve a notice to the state respondents, indicating that the matter shall next be listed under the same heading on August 11, 2026.
Lordship, along with a copy of the once again the pleadings, Lordship, there is a change in the GP's office, Lordship. So,
serve a notice, serve a notice along with a copy
further
of the
copies
pleadings. Thank you.
Lordship.
Number 35.
I am for the respondent petitioner.
Acha, before us you are the respondent.
Yes, respondent.
Although the writ petitioner stroke respondent is represented by learned counsel, none appears for the state appellants at the time of call. Full stop. Let the matter be adjourned till August 11, 2026, when it will be listed under the same heading. First up, the learned advocate appearing for the writ petitioner stroke respondent is requested to serve a notice about the returnable date on the state in the meantime. None appears for the parties at the time of call, August 11.
Thirty-eight, I am for the petitioner, my lord. I am praying for 1 day accommodation.
On the prayer of the appellant, the matter is adjourned till August 11, 2026.
39, my lord, I am for the appellant petitioner.
Yes, Mr. Adhikari.
My
the
learned
application?
junior has not come till now. Brief is
You have come, court has come, junior has not come.
near.
Then we'll
My
give
lord,
you the-
this is my
You must have
application.
it by heart. You generally remember matters by. What
My
is the
lord,
matter?
matter is, my lord, the application has been filed
Yes.
against the violation of the order passed by the Honorable Court. And
You are speaking about Can
there-
4. Yes, we had directed affidavits probably.
on the earlier occasion,
This is
my
Can
learned friend-
4, Can 4, Mr. Adhikari.
Yes, can 4 and no, there are two applications. One application for addition of parties and another application for, my lord, mandatory injunction for demolition of the structure during the pendency of the interim order passed by the appellate court.
You directed affidavits we filed on the last occasion.
On the last occasion, my learned friend, one of the senior friend, my lord,
We'll
appeared.
give them another opportunity, Mr. Adhikari. If they don't appear, when should you keep it? Tell us.
Any day,
Today-
my lord, any day.
Tomorrow we are keeping it then. Give a notice to them. Just give a notice today. Although the appellant stroke petitioners are represented through counsel, none appears for the respondents opposite parties at the time of call. First up, any copy of opposition has been given to you?
No, nothing.
First up, we are apprised by learned counsel for the appellants that despite our direction to file affidavits passed on June 29, 2026, no copy of any affidavit in opposition has yet been served on the appellants. First up, next para. In view of the absence of the respondents, we adjourn the matter for the day. First up, it is made clear that in the event the respondents choose not to appear or not to file any affidavits in opposition, the court shall proceed to decide the applications on the basis of the pleadings made therein on the returnable date.
I am grateful, my lord.
Next matter. এখানে আর কোনো অ্যাপ্লিকেশন এসছে, নতুন অ্যাপ্লিকেশন এসছে ক্যান 1 ছাড়া? আর ক্যান 2 for the parties at the time of call, let the matter stand adjourned for the day.
Forty-one, my lord, I am for the appellant, my lord. My lord, in this case, my lord, on 11th May 2026, Mr. Obasti appeared on behalf of the, my lord, respondents, my lord, and prayed for time to file reply. Thereafter, my lord, again on 29 June, he prayed for.
Have they served any copy of opposition on you?
No. As of date, my lord, no copy has been served. On the last occasion, he prayed for time for filing of this affidavit in oppositions, my lord.
And Vokalatnama also.
Yes, my lord. As of date, my lord, has not received any, my lord, copy.
None appears for the respondents at the time of call. Full stop. Learned counsel for the appellants rightly points out that initially by an order dated May 11, 2026, we had directed affidavits to be exchanged in connection with Can 1 of 2026, first up. Again, on June 29, 2026, similar directions were passed, extending the time for filing affidavit in opposition and reply. First up, next para. Liberty was also granted to the learned advocate appearing for the respondents to file a proper vakalatnama in consonance with the office report. First up, next para. However, from the office report dated August 3, 2026, we find that no such further vakalatnama has been filed on behalf of the respondent numbers 1, 2, 4, and 5 as per our previous direction. Full stop. We are also apprised by learned counsel for the appellants that no copy of any affidavit in opposition has been filed, has been served on him. Full stop. Accordingly, we proceed to hear Can 1 of 2026 without further affidavits. What is the matter, Mr. Bhattacharya? We'll decide.
My lord, my probate application has been, my lord, dismissed only on the ground of, my lord, no attesting witnesses has been present. My lord, in my plaint, my lord, I have taken a plea that both the attesting witnesses died long back. It is there in the plaint itself.
How did you prove the will?
My lord, will has been proved through, my lord, registration documents, my lord.
Or registered will?
Yes, registered will, and one of the staff of that, my lord, registration office, my lord, deposed before the court and said that it is a genuine will.
So what sort of stay in a probate means?
Well, since the private respondents, they are claiming the land in questions which we are in possession.
Oh, yeah, in the prayer position, also asked
Yes,
for
yes, my lord.
changing nature, character, and all. Did
And
you
they are-
grant any ad interim order?
Yes, your lordship, on 24th of March 2026. And thereafter, your lordship directed to serve copy, my lord, I have served accordingly.
Yes, yes. Next para, by an order dated March 24, 2026, we had granted ad interim injunction in terms of prayer C of Can 1 of 2026. Full stop. Next para. The present appeal has been preferred against the dismissal of an application for probate of a will filed by the appellants, primarily on the ground that no attesting witness came up to prove the will. Full stop. Next parallel, counsel for the appellants submits that it was categorically stated in the plaint of the probate proceeding, upon the same turning contentious, that both the attesting witnesses had expired. Full stop. Moreover, the will was duly proved by collateral evidence. Full stop. One of the employees of the registration office where the will was registered also deposed as a witness to prove the will. Full stop. Next para. That apart, other arguable questions have been raised in the appeal, as elaborately discussed in the order dated May 11, 2026, passed by this court. Full stop. Next para. Hence, a prima facie case for grant of the interim order of injunction has been made out. Full stop. Accordingly, we grant injunction in terms of prayer C of Can 1 of 2026, thereby restraining the respondents, opposite parties, and their men and agents from alienating, encumbering, and or changing the nature and character of the estate of the deceased during pendency of the appeal. Full stop. Can 1 of 2026 is accordingly disposed of. No address to costs. The appellants shall since some of them have received.
All my lord, added respondent also, my lord, received.
No, notice of appeal also.
Oh.
Service return says some are good service.
During pendency of this appeal, my lord, respondent number 3 died, my lord. I have incorporated all the legal heirs of respondent number 3.
Yes.
All of them served and all of them received, my lord.
No, Mr. Bhattacharya,
Right.
regarding T series, up to apart from three of them, the district judge's forwarding letter says that the notices have been returned to the concerned department because residents of those respondents are situated beyond the jurisdiction. Regarding the others, we deem these to be good service. So we'll direct you to put in fresh requisites for service of notice on those. We are mentioning them in the order.
My lord.
Trial court records, you have put in special messenger calls. Did
No,
you?
my lord,
No
not
direction
directed,
has been.
not
Correct.
directed.
But you had put in the postal costs otherwise.
Yes.
Very good. We find from the office report dated August 3, 2026 that some of the respondents have been served properly. Full stop. Insofar as respondent numbers 3 within bracket small I, comma 3 within bracket small II, 1, 2, 3, 4, 5, 6, 7 পর্যন্ত হবে, হ্যাঁ, 3 ব্র্যাকেটে রোমান ওই 7 পর্যন্ত আলাদা আলাদা করে, and respondent number 3 within bracket small ix small 9 bracket closed are concerned, comma proper service of notice of the appeal has not been effected on them. Full stop. Accordingly, the appellants shall put in fresh requisites, Talabana and written up notice form for service of notice of the appeal on the said unserved respondents within a fortnight from date. Full stop. Next para, the trial court record shall be brought by special messenger at the cost of the appellants, comma also to be deposited within a fortnight. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. The original will, comma as and the original will, comma as and when the same arrives with the trial court records shall be kept in safe custody, subject to further directions of the court, comma under the aegis of the learned registrar general of this court. Liberty to mention the appeal for inclusion in the list as and when the same is ready for hearing. পরেও করতে পারি, সেটাও
I'm for the respondent.
respondent.
Yes. I've already filed my opposition in respect of
Yes,
can
yes.
2 and 3.
We'll give them a last chance. We'll take it up tomorrow. Although the respondent is
But
present,
already has not been, reply not been served.
not
to
sir,
me.
we'll record that. Although the respondent is represented through counsel, comma none appears for the appellant at the time of call. Full stop. Learned counsel for the respondent also informs the court that no copy of any affidavit in reply, comma to be filed as per the direction of the court dated July 27, 2026, comma has yet been served on the appellant. Full stop. We make it clear that in the event no reply is filed, comma we shall proceed without such reply to dispose of the applications. Full stop. As a last chance to the appellant to move the matter, the same is adjourned for the day and will be listed under the same heading tomorrow.
Yes.
Thank you.
Lord, I beg to appear on behalf of the
Yes,
appellant, Lord.
yes.
For the respondent,
Yes.
last direction that I am filing the affidavit in reply today to the affidavit in opposition filed by the.
Then you have filed your opposition on the last one.
Yes.
Yes, yes, yes.
And today we are filing the affidavit reply to this stay application. And today, your lordship, the last occasion, Lord, was pleased to observe the occupational charges will be determined.
Oh, this is
Appeal was admitted earlier.
I am joining issue with regard to the order of stay itself.
this arises out of a decree for eviction, obviously.
Yes.
Eviction of trespasser as per the court.
No.
Tenant.
Tenant, 2G applied,
the learned trial court do them. But my case is that the 2G does not apply in terms of Kandani properties because the original tenant died prior to that. That's the one issue. And another issue, whether the suit filed by the defendant earlier, that was not the erroneously not observed by the learned trial court as if the suit was filed by them and the res judicata does not apply. These are the 2 points of your lordship.
No, they did not file a suit.
No, they did not. We filed the suit, not and there the not my tenancy right was not established to a little to an extent, and the water supply was to be directed to be given. So that suit, the learned trial court proceeded as if the suit was filed by them, not by us. This is number one, and the 2G out 2G also not only evidence on record the exhibit death certificates. It was
Mr. Shen, what is the
the
acquisition charge which should be paid according to you?
I must
prior
be
to that-
candid, not they Friday that they filed us, they have served me a copy of the
In
supplementary
the
affidavit.
affidavit in opposition,
which-
my lord, I could not file, I could not get the report. Now I've got the
Now
report.
they have
prepared a supplementary affidavit, my lord, I've served on.
they have filed the valuation report.
Then you have to
Instead,
confirm
I have
that
to
also.
file an exception to the valuation report.
May I?
Well, on the prayer of learned counsel for the respondents, leave is granted to the respondents to file a supplementary affidavit to the affidavit in opposition, which is filed today and kept on record. Push up in order to enable the appellant to controvert the allegations made therein, the appellant is directed to file her rejoinder to the supplementary affidavit. How soon can we do it? Within a week?
Within 1 week.
Thank
One indulgence, but I want to produce the present condition of the suit premises in a pen drive, the videograph, if your lordship permit me.
He has annexed
Let us complete the
photographs.
sentence. Within a week from date. Pushed up, then the question of proving that and all these things comes.
That
But he has annexed photographs to his affidavit.
photographs that's in support of.
We don't
I
have the
can-
time to see.
All right, but I can show at least before that. I can
Let-
show before your lordship from the from my tab, not only video photo.
No, why can't you put it in the way of photographs in your
Photographs I have
Already
already given. Maybe not,
Motion won't help us.
may not.
Motion won't help us. Static photographs would do.
Sometimes that motion gives the clearer picture.
Pictures are already.
Nowadays, that your lordships are accepting and watching these while
Yes,
passing.
we are,
by.
but it's more serious matter.
Absolutely,
Condition of a building, what will motion do?
because they
Building is static.
But that-
You are moving around and taking a photograph
Like
from
learned
different
right
angles.
can
as
always-
per their report, they are
always
claiming
controvert by way of
20,000
another
per.
report by another expert. I have
Yes,
them
but we can't afford to do.
Give them clues.
But only they have determined that as if my tenant should occupation charge will be 20,000. I just want to show it's an old
Which
building.
area is this?
It's a
Shobha Bazar area. my lord.
Our area is a very old building, no water connection. Lordship will see the photographs at the time of hearing. Lord,
The matter shall next be listed. The matter shall next be listed on August 24th, 2026. They'll file it within a week. In difficult
Instead of
getting
24th, any other day. my lord.
it. August 25, 25th August. August 25, 2026.
Grateful.
I
Please,
pay
Roja,
for
what is
the
that?
appellant. Your Lordship, pursuant to your Lordship direction, I served upon the learned advocate appearing before the trial court, my lord.
Affidavit of service you can file.
Yes, my lord.
Achha, there are two defects. One defect actually.
It has been removed, my lord. We have removed it.
Classified in words you have removed.
Yes, it has been done.
No, not removed.
Well, then I will check
Needs to be classified in words at its head. So memorandum of appeal from
from my lord.
No,
I will check once again, my lord. I tender my
give you that
apology.
liberty and take up the matter.
Yes, my lord.
So from the affidavit of service, we've sorry. Leave is granted. The learned advocate on record for the appellant is granted leave to rectify the memorandum of appeal and classify it in words in terms of the report of the stamp reporter during the course of the day.
Yes, my lord. I will do.
Course of next
Today
para.
itself.
Affidavit of service filed to be kept on record, from which it transpires that due service has been effected on the learned advocate appearing for the respondent in the trial court as per our previous direction dated July 27, 2026. First up, accordingly, we take up the application for expertise hearing. What is that?
Your Lordship, suit I am the defendant in the suit for declaration in respect of a commercial vehicle, my lord. An application for injunction was moved ex parte, and the learned trial court granted ad interim injunction restraining the bank from taking.
It was hypothecated to you.
Yes, my lord. Without unconditional, my lord, the EMI is 90,000, my lord. There is a frivolous cause of action. I will show, my lord. The agreement is executed at Agra, Uttar Pradesh. Vehicle is registered in Uttar Pradesh, my lord, and the agreement also provides that the branch where the loan has been sanctioned, the courts having jurisdiction over that place, my lord, will have the exclusive jurisdiction, my lord. Despite that, my lord, this.
What injunction has been made?
Yes, my lord. Kindly come to page 26, my lord. The order has been annexed. We have initiated proceeding under SURFACE 13 to notice has been issued, my lord, because there is substantial default. A blanket order of injunction, my lord.
Well, Ms. Oja, but this stage we stay the order, then nothing remains. It's a modifier. Due process of law. Well, we will grant a stay subject to imposing similar injunction with the modification that except by due process of law. We'll incorporate that
Yes,
so that you can proceed.
Yes, my lord. May I just show the, if my lord desires, I can just show the EMIs, my lord. It's 90,000 admitted, default admitted, my lord, and they have stopped
Admitted
paying.
means in the plain they have
Yes,
admitted.
yes, that there is
To that
default.
portion,
Yes,
yes,
my
yes.
lord. There is a default in. Kindly come to page 13, my lord.
13.
Paragraph 6, the EMI is admitted, my lord. Paragraph 7,
Yes.
I am reading the last 3 lines, my lord. As on today, the plaintiff paid and or invested such and such, which is the allegation to the defendant against the said loan, and there is some due on account of the installments, and the plaintiff undertakes to pay rupees at the rate 25,000 per month. Then there is agreed rate. EMI is more than 90,000, my lord, and that too the learned trial court has given an unconditional order, my lord, restraining the bank. And I'll just also show, my lord, the clause 38 and the place where this agreement has been executed. That would appear at.
They have taken a plea that despite several requests, you did not hand over a copy of the loan.
These are the allegations, my lord. If it is so, my lord, they would not have paid some EMIs, 4 or 5 EMIs, my lord.
All right. We are granting stay subject to similar injunction with that rider.
Yes, yes.
Learned counsel for the appellant draws the attention of the court to paragraph number 7 of the plaint in the plaint of the suit filed by the respondent, comma, from which the present appeal arises. Full stop. The plaintiff stroke respondent has admitted therein that there was some due on account of installments in repayment of loan taken by the plaintiff stroke respondent from the appellant stroke bank. Full stop. Next para. The learned trial judge, comma, by the impugned order, comma, granted a blanket order of ad interim injunction restraining the defendant stroke appellant and its men and agents from seizing or taking peaceful possession of the vehicle, being number UP-884 capital AN-9559 for a limited period. Has this been extended, this interim?
Yes, yes.
We are apprised that the said order has subsequently been extended. Next para, we find from the materials before us that even from the pleadings of the plaint of the respondent, comma, it is evident that there was some default in repayment of the loan. Full stop. We are further apprised by learned counsel for the appellant bank that the appellant is taking due steps under the SURFACE Act for recovery of the loan. Full stop. Next para. Hence, comma, prima facie we find that the appeal was formally admitted, Ms. Oja.
Yes, my lord. There was no delay. There is no
No, is there
formal order of.
Yes, we admit. Yes, there is a formal. We admitted on 7th. Prior, we find that the trial court erred in law in granting a blanket protection to the respondent, comma, without leaving any opportunity for the bank even to proceed in due process of law comma, if necessary, to take possession of the vehicle in question, comma, which was hypothecated to the bank. Full stop. Next para. Accordingly, there shall be stay of operation of the impugned order bearing order number 2 dated June 2, 2026, passed by the learned judge, comma, 6th bench, comma, City Civil Court at Calcutta in title suit 1133 of 2026, comma, subject, however, to the rider that the the appellant bank shall be entitled to seize or take possession of the vehicle in question bearing number UP-84AN-9559 only in due process of law without using any undue force. Full stop. Such stay is granted till disposal of the appeal. Full stop. Can 1 of 2026 is accordingly disposed of without any order as to costs. Full stop. You prepare informal paperwork.
Yes.
In view of the short ambit of the appeal, comma, calling for the trial court records is dispensed with. Full stop. The appellant shall prepare and file the requisite number of informal paperwork without comparing with the records, but incorporating all relevant documents within 6 weeks from date. Full stop. Liberty to mention the appeal for inclusion in the list as and when the same is ready for hearing. Process of due process to proceeding claim. Yes.
We are for the respondent.
Respondent. We are adjourning for the day, Mr. Bush. We are keeping it as the last chance.
So then we are the next week.
Next week. You are for the which respondent? Pro forma respondents are also there. You are for the main respondent, principal respondent. Pro forma respondent. So none appears for the appellants at the time of call. Full stop. Learned senior counsel appearing for the pro forma respondent submits that he is in some difficulty tomorrow. Full stop. Accordingly, we adjourn the matter till August 10, 2026.
Lord, I have instruction to appear on behalf of the respondents, Lordship. On the earlier 2 occasions, they took adjournment, and there are some defects, Lordship. Defects, I think, defects have not been removed. I am the landlord, Lordship. 106 transfer of property at Lordship. Notice has been accepted. There is no benefit in the appeal, Lordship. I am suffering.
এটা মেনশনিং স্লিপটা কোথায়? দীপঙ্কর মেনশনিং স্লিপ দেখো।
Can you see the last 2 orders?
But at the time of call, comma, you are appearing for which respondent?
All respondents.
At the time of call, comma, none appears for the appellants, comma, although the respondents are represented through counsel. To the next para, we find from the order dated July 14, 2026, comma, that we had directed the matter to go out of the list since none appeared on behalf of the appellants on the said date. Full stop. Simultaneously, comma, we had also granted leave to the learned advocate for the appellants to rectify the defects pointed out by the stamp reporter in his report dated July 9, 2026 by incorporating the necessary corrections to the memorandum of appeal. Full stop. Next para. Proceeding. Although the said defects have been removed in the meantime, comma, since the appellants are not represented through counsel, comma, let the matter stand adjourned for the day. Full stop. Next para. However, comma, it is made clear that in the event the appellants are not represented on the next occasion when the matter is called on for hearing, comma, ex parte orders may be passed in the absence of the appellants. Can you give a notice to the appellants also? The learned advocate on record for the respondents is requested to give a notice to the learned advocate on record for the appellants, indicating that the matter shall be listed tomorrow.
Tomorrow.
And file a receipt in that?
Lordship,
Tomorrow difficulty?
Lordship, on next Monday, Lordship, if it is possible, Lordship.
Very. ওটা tomorrow না করে on August 10, 2026.
I'm grateful, Lordship.
যেখানে urgent for the day বলেছি একটু আগে, urgent till August 10, 20.
I will serve, Lordship.
Next.
47 for the appellant, my lord.
Yes, what is it?
For the respondent caveat.
Yes.
My lord, it's a suit. There was a defect that was cured, my lord.
Cured. Very good.
My lord, suit for eviction and recovery of possession on the ground of reasonable requirement and default.
1 second. Question. Just give us half a second.
There was a preamble in the
No, Mr. Mukherjee, you are appealing for the plaintiff response.
1, 2, 3. Yes.
1 to 4.
1, 2, 3. We are on caveat.
Achha, 4 is also one of the plaintiffs, but
4 কি আছে রে?
then she has to be served in other words. This will delay the matter.
4 এর হয়ে তুই ওকালতনামা দিতে
with,
পারবি?
daughters, my lord.
Huh? All daughter.
All daughters.
Can try blood filing of ওকালতনামা on her.
Then this is against an eviction decree.
Yes.
Eviction on the ground, 2G.
Reasonable
Better.
requirement. Reasonable
Better.
requirement.
Much better. Yeah. So, what is your ground? I mean,
My lord, the original plaintiff had purchased the property from the vendor who is from the East Pakistan. The West Bengal Evacuee Property Act, Section 18, there is a bar in case of transfer of the property by the
you are
person,
inducted by the person from East Pakistan.
East Pakistan, that is admitted, Exhibit 1. My lord, kindly come to page.
So, you say you deny their title. They have
Their
derivative title.
Yes, my lord.
They claim by purchase.
They came by purchase. Page 68, my lord, kindly come to page 68 of my application. From the top, my lord.
No affidavits have been exchanged as yet.
No, my lord.
Mr. Mukherjee, occupation charges directed to file affidavit.
Your lord, it is in the order 41 stage. Order 41 stage.
Oh, order for turn. Acha, this is not, sorry. Oh, acha. Both courts held against you?
Yes.
And the suit of the year 1992, the point that my learned friend takes is not that whether by virtue of not the West Bengal, not that
Evacuee Property Act.
Got a copy of the act.
not whether the sale was invalid. That's the only point that my learned friend takes.
Application system is application.
Actually, I'm sorry, my lord, I have only Section 18, my lord.
18.
1(8).
Everything except lease.
Except lease.
But they have purchased.
No purchase, but there is a
Cancel.
committee.
Huh?
It has to be referred to the committee, my lord.
An evacuee whose property has vested in the committee may nevertheless at any time dispose of such property by sale, etc. Upon such disposition, the evacuee shall intimate the committee thereof. Committee
Yes.
shall, as soon as
The-
may be, cause a
that-
public notice.
That procedure was not followed.
A disposition as aforesaid shall subject to provisions 3 of 300. Acha. Disposition shall take effect from the date of that notice. Subject to provisions of 21(3), let us see, 21. How did the courts deal with it?
My lord, it was dealt with in the first court. It was dealt with by, my lord, kindly come to page 215, my lord. That is the first court order.
Yes.
At page 224, my lord. Paragraph. I have carefully perused the exhibit 1, my lord.
Yes.
From where it appears that the said deed was executed by Muhammad Hussain, who was the resident of East Pakistan. That is evident also from the deed also. through his lawful constituted attorney, his brother Sheikh Suleiman, in favor of Tarapodo Das. That is the original
What is the
plaintiff.
date of that deed?
1951, my lord.
1951. Very good. Yes.
Before the partition of India in the year 1947, there was one nation, British India. After partition, two independent dominion created by India and Pakistan.
Yes.
Therefore, before Indian independence, Act 1947, there is no existence of separate nation, that is Pakistan, my lord. Now it's an enemy. Thereafter, it is declared as enemy property. So if it has to be transferred, that has to be transferred through that by following that procedure laid down in the West Bengal Evacuee Property Act. That was not complied with. Lordship, kindly come to page 68. That is the Exhibit 1, my lord.
Evacuee has been defined in the statute. It says
Yes.
evacuee means a person ordinarily resident in West Bengal who, on account of communal disturbances or fear of such disturbances, leaves or has after 15th August 1947 left West Bengal for any place in Pakistan. So, have you established that this person?
Yes, yes. Kindly come to page 68, my lord. Page 68 of my application. That is mentioned in the deed itself. 668, my lord.
State is its folders.
Yes, my lord. From the top, my lord.
You have deliberately not given
line.
a typed copy so that we cannot read.
My lord, I'm sorry, my lord. It's fifth line, my lord.
Draw adverse inference against you for not giving it.
I will.
If you could read it, probably
My
to
lord,
against
from the top, my lord, fifth line.
Yes.
The middle portion is East Pakistan.
Whatever you say, we have to accept that because we can't.
East Pakistan represented by his lawful constituted attorney, his brother. He is the original vendor. He is from East Pakistan.
No, let us just read the previous one.
A deed of sale of land and other structure thereon at rupees 5,000 and indenture.
You can read this so fluently. You are brilliant. Genuinely. Yes, please continue. Yes.
Before this
date is given October in the year 1000.
Here it was the date 52. Then the Nam Muhammad Hussein.
Yes, residing at Chowk Bazar,
Yes,
Faridpur. Faridpur. Yes. East Pakistan. Very good. Alright, so resides in
East Pakistan.
Did he ever?
This
was he ever in West Bengal? I mean, he has to leave.
That he has
ordinarily resident in West Bengal. Yes. On account of it doesn't say that he was originally.
Yes, otherwise, this property cannot acquired by him by.
Might be. I live in East Pakistan, but before independence, I acquired a property in the then unified India. Suppose he all through lived in East Pakistan or Bangladesh, wherever. He all along lived there, but he purchased a property here in Kolkata.
But before partition, if it is purchased before 1947,
before 1947, he could have lived there. It was one country.
But his brother was staying there. No, his family was staying there.
Yes, but we don't know whether he at any point of time was living here. If he was all along a resident of East Pakistan, then this evacuee, there is a question of evacuation. He never says that I ever lived in West Bengal. Anyway, let us see how the courts proceed. Sections have been discussed. Calcutta, section 18. This could, for the sake of argument. Was not lying unoccupied. It's come to be wrongfully used or occupied. Oh, the court says it can be safely presumed that vendor was a national of British India when he acquired the right. Yes, but West Bengal. Court finds he was an evacuee. 25 to 26. We don't understand it. Presumed, it can be safely presumed that the property was never vested in the committee. And even if the property was vested, then the evacuee has all right to transfer. Oh,
If it
so
is-
prior vesting in the committee has to be
Yes.
proved. That you have not proved probably. All evacuee properties, unless they vest, then this 18 does not apply. So, what is the provision for vesting? No proof of vesting was furnished by you. He had to show something to indicate that the committee took charge of the evacuee property under these sections. Section 17 and all. প্রপার্টিটা ভেস্ট করলে তবে আসছে ভেস্ট করে যদি দেখেন তো ওর কাছেই ছিল বাইরে Where is it? This is the only copy you have of this.
Yes, my lord.
Trial court quotation দেওয়া
ট্রায়াল করে কোটেশন দেওয়া আছে 225-26
No, not those sections.
The
Others.
internal page 10 of the trial court, Lord, the sections have been quoted, Lord.
We want to see the sections of vesting also.
Yes, that is 18.
No,
but-
18
I'm
is-
sorry.
17.
17.
17 is not quoted here.
17 is not quoted.
Section 17 says the committee may take charge of any evacuee property in the following cases where a report is received from collector, etc., etc. Evacuee has not returned. Before taking charge, committee shall cause a public notice. Objections filed, committee to consider. No such objection. Committee shall pass an order directing the charge of property be taken by the committee and thereupon the property. Sorry, but section 17, none of the elements you have proved. Let us see. For sections 18 to apply, precondition is section 17 vesting in the
Yes,
court.
ma'am.
Only then this bar would apply. He inducted you. It was all along with his brother. Brother was a power of attorney also. Never vested in the committee, that is. Appeal court also found similar.
It was not discussed in the appeal court, my lord. Kindly come to the
But
appeal
then
court
on
order.
yes, but then still, if it affirmed and trial
It
could
was
discuss thoroughly.
not at all considered by the learned appeal
So
court, my lord.
even if we consider, we don't find any evidence on record to show to the prior vesting. Unless it's vested, 18 is not attractive.
254 is the order of the judgment of the appeal court, my lord.
250?
54, my lord.
54.
Internal page, my lord. 10, my lord. 19.
Hmm.
9 bottom portion, my lord. It is also clear from the trial court record the defendant did not challenge the title of the original plaintiff, and now here it was contained the written statement that the title of the original plaintiff is imperfect as he was a citizen of East Pakistan as on date the transfer, and thus rightly pointed out by the learned advocate of the respondent, the lengthy discussion of the learned trial court is impugned judgment regarding enemy property was not necessary. That was the observation of the.
See, this finding is wrong, but the conclusion is correct. no substantial question of law, no disputed question of law has been raised. It's very clear. Sorry, despite the presumption raised by Mr. Mukherjee's appearance that they don't have any case. You don't have any case. Sorry, very sorry.
And
You argued
another-
very well, but almost had us admit it. Sorry.
And another ground is, my lord,
What is the other?
my lord, the plaintiff has pleaded in his plain, my lord, they have 7 rooms, small plus big. In the commissioner reports, it was evident that 18 rooms, small plus big. I am in possession, admittedly, as per the plaint, 2 big room, 1 veranda and 1 privy. So 4. So from the plaint, 7, they have said that they have 7 rooms. Commissioner reports disclose that there are 18 rooms. I am in possession 4 rooms.
7 still remain.
Still remain. So they have excess room in their hand, but that was not also considered by the,
Now, how did the courts proceed on that?
my lord.
You must have raised that
My
point.
lord, yes, it was raised, my lord.
Appeal court apparently looked into this number.
But first trial court also discussed about it. Before that, my lord, I would pray before your lordship to come to the plain first. At page.
No, we'll go back to the plain. Just let us see
Oh,
the
yes,
appeal
yes.
court judgment first. Page 12 and 13 onwards. Discusses commissioner's report, page 265, the last paragraph. 1 portion cemented, other tile roof. Yes, 6 in number.
And
Tile shed precarious
and
dilapidated.
yes.
So that can be
kindly come to 222.
222. Achha. Triple two, yes.
My lord, it is further submitted line advocate defendant during argument commission was held to have inspection middle portion, my lord,
Yes,
about
yes,
the
yes.
present occupation of the plaintiff. The court certainly be concluded that the particular commission work was nothing but fishing out evidence, and the plaintiff in the plaint or in the evidence he avoided to say how many rooms they possess.
These are your arguments.
It is my argument. And kept silence over the matter. Thus, there is no pleading to the effect that cannot be any scope of the court to adjudicate the ground of reasonable and suitable accommodation of the plaintiff on the ground of reasonable requirement for the ground taken under section 13(1)(f) of the West Bengal Premises Tenancy Act 1956 cannot be concluded whether the requirement sought in is a genuine one or not. Therefore, there is no scope for the court to rely on the commissioner's report, and the commissioner's report speaks that plaintiff are in occupation of 18 rooms and in total, and in the plain case paragraph 8, 9, 10, the requirement that has been sought for is more or less 14. That's not correct, my lord. They have said they have 7 rooms in their occupation and 3 rooms are in occupation presently. So it can be safely concluded the requirement has already been fulfilled and the ground has already taken a reasonable requirement in fanciful requirement. My lord, kindly come to the plaint once, my lord, at page 23. Amended plaint. Kindly come to page 30, my lord. 30.
Yes.
Paragraph 10, my lord.
10.
That the plaintiff requires at least 1 bedroom for his adult grandson, see such and such. The plaintiff requires another room for the purpose of study of his grandchildren. The said room can well be used in times for providing accommodation of marriage daughter of plaintiff, his son-in-law and grandchildren during her occasional visit and stay in the suit premises. The requirement of plaintiff are of 2 rooms. As stated in the above is out and out bona fide, it bears element of need without having any room of the amount of cap rise. The requirement of the plaintiff cannot be satisfied unless the plaintiff gets a decree for recovery of possession of the suit property after evicting the defendant therefrom. So the requirement, it comes total 2. And paragraph, kindly come to paragraph, my lord, 6, my lord, page 26. The plaintiff states that the present occupation is as available to him at the premises is too insufficient to meet the minimum requirement. The present accommodation available to the plaintiff in the suit premises consists 3 bedroom, 1 kitchen, 1 dining room, 1 storeroom, 1 thakur ghar. So total number comes 7, my lord. Now kindly come to, my lord, the commissioner's report. Commissioner's report at page 177, my lord. Total number of room comes, my lord, at page 190, room number 18.
No, but there are stone chips, building materials, iron rod, dilapidated. All these have been considered by the courts.
Considered, but I am to
Section is
poison
style shed.
2 rooms, my lord. They have sufficient room to.
No, and in paragraph 8, 9, these paragraphs of the plaint, page 28, 29, several other rooms have been claimed. Office rooms, 2 office rooms. For
They
the
have
plaintiff.
several rooms. These all
There
are
are 7 rooms, you said.
7, not 7 rooms. They have, my lord,
18 total.
14 rooms.
14 rooms, but if you add up 2 office rooms for the plaintiff who has a contractor business, construction business.
They said they have
space
7,
for building.
but on in commissioner's work, it was found it's 14. I am in poison,
Even if
admittedly.
it's 14, then their requirements exceed. You just see page 28, 29, 2 office rooms for the construction business, space for storing building material.
These all are occupied by them, my lord. Kindly come to the
The total
commissioner's
number,
report.
we have to calculate the total number minus 7. So their requirement is more than 7 as per their plaint.
As per their plaint, if it is comes, it's double. It is in their poison, my
14.
lord. 14.
See if it's 14 and
I am in poison, 2 room,
we are
1,
yes.
total 4. Privy, including privy and
You
baranda.
say those other 7 rooms, but among the other 7 rooms, some are dilapidated, some are tile shade. This have been
Dilapidated
considered.
condition is my room, my lord. This is not their room. Plaster.
No. See the commissioner's report.
My lord, kindly.
Page 183 if
Plaintiff's
you
room.
come.
If only plaintiff's room is 18, my lord, then. If it is not my room, is not commissioned,
some of those
then
rooms,
total rooms comes.
commissioner says at page 183, other pages also. Last paragraph. In that room I found
177.
various building materials, stone chips, etc.
It was entirely then the plaintiff's occupation, my lord.
Yes, those
18
stone
rooms.
chips and all. I mean, they require more rooms for accommodating their business and son and etc.
Total 18 rooms.
Yes.
And they said they have 7 rooms.
Plaster disappeared, tile shed chala and all this.
Yes, they said
those rooms won't suffice for them.
7 rooms they have stated, and they said 2 more rooms are required.
If you go into that extent, then it will be a reappreciation. We'll record your submission, but sorry. The present second appeal has been preferred against a judgment of affirmance whereby a decree of eviction has been granted by both the courts against the appellant on the ground of reasonable requirement. Appellants on the ground of reasonable requirement. So, next para, the counsel for the appellants argues that both the courts below erred in law in overlooking the legal effect of Section 18 of the West Bengal Evacuee EVACUEE Property Act, 1951, which stipulates that an evacuee whose property has vested in the committee may nevertheless at any time dispose of such property by sale, comma, exchange, comma, etc. Subject, comma, however, to such subject, however, to the evacuee intimating the committee about the disposition, and also subsection 3 of section 18, which stipulates that such a disposition shall take effect on and from the date of publication of the notice referred to in subsection 2 of the said section. First up, next para, learned counsel submits that the courts overlook the fact that from the transfer deed of the original landlord itself, comma, it would be evident that he was a resident of East Pakistan and within bracket now Bangladesh bracket closed, and as such, comma, the rigors of the 1951 Act squarely applied. So next para, secondly, comma, learned counsel submits that from the commissioner's report it was found that there are total 18 rooms in the suit property, comma, out of which 4 are occupied by the appellants stroke tenants. First of thus, comma, the respondent landlords have at least 14 rooms in their occupation, whereas the necessity pleaded and proved by evidence by them is for less rooms. First of next para thus, comma, it is argued that the suit ought not to have been decreed on the ground of reasonable requirement. First of next para, however, comma, insofar as the first ground is concerned, comma, we do not find merits in the contention of the appellants for the simple reason that the sine qua non and precondition for section 18 of the 1951 Act being attracted is that the subject property has to be vested in the committee contemplated under the said statute. Full stop. As per section 17, comma, the detailed procedure of the situations in which the committee may take charge of an evacuee property, comma, consequentially the property vesting in the committee, comma, has been laid out. Full stop. Next para, however, comma, we do not find a single piece of evidence having been adduced by the appellants in the trial court or the first appellate court to establish that the property vested in the committee in the first place. Full stop. In the absence of such vesting, comma, the rigors of section 18 were not attracted at all, and comma, as such, comma, the derivative title in favor of the plaintiff stroke respondents could not be said to be vitiated. Full next para, insofar as the requirement of the plaintiff stroke respondents is concerned, comma, we find from the pleadings in the plaint that the requirement of the plaintiffs, comma, pleaded therein, comma, was more than the 7 rooms in their occupation. Full next para, the learned first appellate court, comma, in the impugned judgment, comma, categorically considered the commissioner's report and came to the observation that the suit property was comprised of 2 parts, comma, one portion being cemented and the other being tile roofed. Full stop. Next para, the dilapidated condition with broken doors and windows of several rooms was also considered by the first appellate court, comma, apart from the fact that from the report of the commissioner it appeared that building materials are dumped in a storeroom in some of the spaces and rooms available at the suit premises. Full stop. Upon a full-fledged consideration of the evidence at length, comma, the courts came to the both the courts came to the finding that the plaintiff stroke respondents reasonably require the suit property for their own use and occupation. Full stop. Next para. In such view of the matter, comma, the question as to the reasonableness of the requirement comes within the domain of factual findings. Full stop. It is well settled that at the second appellate stage, comma, there cannot be a reappreciation of the evidence. Full stop. Both the courts having arrived at a concurrent finding of fact in that regard, comma, it is not open for this court to entertain a second appeal on such issue. Full stop. Next para, thus, comma, we do not find any substantial question of law involved in the appeal. Full stop. Accordingly, SAT 100 of 2026 is dismissed under order for 11 of the Code of Civil Procedure. Consequentially, can 1 of 2026 is also disposed of. No orders to cause urgent certificate. প্রথমে একটা affidavit service factory sorry.
Yes.
That you this. এই বইটা ওনাকে ফেরত দিয়ে দাও পরে খেয়াল থাকবে। Yes.
Lord, this is my second appeal.
Yes.
Lord, I am the tenant. The landlord filed a suit against me for eviction on numerous grounds. The trial court dismissed the suit. I won. Then the landlord took the matter, my lord, before the first appellate court. And the first appellate court, my lord, reversed the decision of the learned trial court and has, my lord, decreed my eviction.
On what ground?
On ground of subletting. And, my lord, this subletting is on account of me amalgamating, my lord, with a sister concern. So, the company A was recognized, my lord, as the tenant, and A and B, my lord, were sister concerns running business from the same premises, same persons, same business. And then, my lord, as per a scheme, my lord, approved by the Honorable High Court under the Companies Act, my lord, company A and B amalgamated into being company B. So all that A had.
No, a third company was created.
No. A and B.
And you are A or B?
No, so my lord, I am B today because A doesn't exist anymore.
You were what? A.
I was A.
It was let out to A.
A was the tenant.
A merged with B and became, or amalgamated with B and became
amalgamated
B.
in B and became B, and all that belonged to A stood, my lord, belonged to B. Belonging to B.
If it was the other way around, we could have understood. But if
Now law is against me on this point. I am conceding, my lord, to the extent that, my lord, the Supreme Court has also held that if there is a tenant and that tenant company amalgamates with another company
and
becomes that company, then this amounts to subletting.
Yes.
So, my lord, I am not on this point at all. Judgments are against me. My lord, there is another angle to the matter. And, my lord, in the facts of the peculiar facts of this case, my lord, kindly consider this. And these are admitted facts. I can show, my lord, everything I say is agreed to by both parties. Save and except for the proposition of law, my lord, that I wish to propound. The tenancy was not in the name of company A. The tenancy was by a tenancy agreement which has been exhibited in trial of 1986 in the name of a proprietor. That
proprietor of some company by
proprietor, a sole proprietor
of a company.
I'll tell your lordship, a sole proprietor. For now, my lord, take it that a sole proprietor is given a tenancy.
We'll require some stimulus to.
Very good.
We'll come back in.
Convenient for your lordship.
Yes.
So, my lord, the tenancy of 1986 is in the name of Messrs. Balaji Distributors Electricals. Then this proprietor, that in the next year, 1987, starts Balaji Distributors Electricals Private Limited,
Which is also a proprietorship.
which is a private limited company. Balaji Distributors Electricals Private Limited. So Messrs. Balaji Distributors Electricals, my lord, then in 86, tenancy. Then next year, 87 comes Balaji Distributors Electricals Private Limited. And then in 1991 comes Govind Promoters Private Limited. So here we have one sole proprietor who gets the tenancy in 1986. He incorporates company A in 1987, and then he incorporates company B in 1991.
No,
And
the Balaji Private Limited, the name changed to Govind.
no, my lord, the proprietorship has continued because even post the year 2000,
So it was not a formation of a company.
it was a formation of a company.
Sometimes proprietorships are also named company.
No, my lord.
You have come across those also.
So, my lord, here there was a sole proprietor. He had his proprietorship concern.
Formed a company.
He formed a
entity.
yes.
And what was Govind? Govind was another name of this.
No, and Govind Promoters, my lord, was another company. Now both these companies and the proprietor. So we have one
Separate
proprietorship
companies function from this.
Yes. So we have one proprietorship, my lord, functioning. We have company A functioning and company B functioning. All three same management, same owners, family companies running from the same tenanted premises. This continues until 2009. In the year 2009, there is, my lord, an amalgamation of the two companies, A and B, under the Companies Act. So Balaji Distributors Electricals Private Limited, my lord, ceases to exist for having merged with Govind Promoters Limited. So from 2009, there is the proprietor and Govind Promoters Limited. This is, my lord, the position since 2009. After this, my lord, the suit was filed. After 2009, the suit was filed. Proprietor not a party to the suit. Govind Promoters not a party to the suit. The defunct company, which merged with the second company B, company A, was made the sole defendant. That is when
the subletting, according to them, was Balaji amalgamating with Govind.
Yes. So the proposition, my lord, that I wish to, my lord, propound is that if a
registered office was also the same.
Yes, same place, same. They are both family companies. Now, if a proprietor is using his premises to carry on a business in the name of a company which he forms, then that doesn't amount to subletting. The test is whether effectively it's the same group of persons running the business or whether there's a change of hands. And this has to be adjudicated in trial. And neither the trial court nor the first appellate court have gone into this question. And I can show, my lord, from the evidence that the 1986 agreement is exhibited. Number one, the plaintiff's witness who is exhibiting that document testifies that that is signed by the landlord and it is signed by the promoter of the tenant company, namely, my lord, the sole proprietor. And not just this, my lord, he also, my lord, there is correspondence, my lord, of increase of rent and correspondence with the tenant addressed only to the proprietorship and not to the company. So the company and the proprietorship have, my lord, interchangeably been recognized as tenants.
Rent receipts were given to whom? In whose name?
Rent receipts were, my lord, in the name of the defunct company, Balaji Distributors Electricals Private Limited.
Then
But
that was
for
the
this,
recognized tenant. That was the recognized tenant.
yes, but if your lordship, my lord, considers the agreement, the tenancy, my lord, is said to have commenced under, my lord, the 1986 agreement. If your lordship just has a look at that agreement once. And, my lord, I have decisions, my lord, to back this proposition that if a proprietor starts a business, and, my lord, all the decisions that have been relied upon by the first appellate court are simpliciter cases of merger. say X Reliance merges with X Tata. And there is, in all these cases, my lord, it has been shown that there is some sort of a pecuniary relationship. There has been a relationship of of one company paying rent to the other. It hasn't been a case where the same proprietor is running two of his companies for a long time. Kindly, my lord, consider the tenancy agreement.
So you are bringing two company law concepts into tenancy eviction. One is piercing the corporate veil and seeing who is actually in control.
Who's actually in
And secondly, group of companies theory of Cox and Kings, which is entirely on a different footing. But still,
but
yes,
my lord, that apart,
interesting.
yes, my lord,
Yes.
my lord, worthy of a second appeal, my lord, in my submission to be admitted. But if your lordship, my lord, considers now the tenancy agreement.
No, previously we thought that if a second appeal is argued for quite some time in order for to stage, that itself should entirely to be admitted. But then when I became a judge, I found out that there can be an idiot judge who doesn't understand for a long time. So there can be a situation where it's argued at length, Mr. Dakmani, but because of other reasons than the merits of the appeal. So therefore, that itself does not, the arguability does not itself mean that it's, the question is interesting, but let us see whether it's
My lord, I am a little optimistic today, I must confess. But we'll see where
so this is very interesting. Yes.
Yes. So if your lordship, my lord, takes the
agreement,
a tenancy agreement,
which page?
Just, my lord,
Yes.
201, volume 2, page 201. Take this judgment out. Is my lord there?
Yes, yes, yes.
So your lordship will, my lord, see
Messrs. Balaji.
Messrs. Balaji Distributors Electricals. And the date is, my lord, August 28, 1986. And my lord, this tenancy agreement, my lord, has a clause 7. Your lordship will see that clause 7 there.
Not transfer as anything.
So they have been completely okay with me as proprietor starting another company and construing that to be not a transfer.
But the tenant's receipt was in the name of this proprietorship, not you.
Well, Lord, of course, they will give one receipt. They will not give 3 receipts.
Of course, and also proprietorship is not a separate juristic entity.
It's not. It's the
has to be taken as identical with the proprietor.
It's proprietor. It's a legal name. So, my lord, this clause, transfer clause, if this was to be construed, that if I as proprietor start another company and therefore I sublet.
But company is a different juristic entity all the same.
My lord, I understand. But my lord, if just consider, my lord, one thing. If, my lord, this clause 7, my lord, if this means that the proprietor cannot create another company, then, my lord, they never would have, my lord, acknowledged, they would have evicted me immediately then. So when
you also said something more, important. Govind was already functioning there before the amalgamation.
Yes.
The registered office, is there anything to show that?
My lord, master data, I believe we have annexed.
No, but was it produced in the court or discussed by the trial court?
Nothing, my lord. There's no discussion on this. There is no, it's completely, my lord, the learned court below just proceeds on the basis of, my lord, the proposition of law that just what your lordship was initially saying, that had it been the other way around, it perhaps not have been, but this way it will be. So your lordship will...
We were under the impression that Govind was some separate stranger entity. But
no, my lord.
One is that the same proprietor was the promoter.
My pleadings, my lord, are there that both these companies, company A, company B, run by the same set of persons doing the same business. Effectively, it's only a name change, this merger. Those pleadings are there.
But piercing corporate field does not come in a tenancy situation.
My lord, may I?
Here, if there is an allegation of fraud or something, some violation by the companies, then only that theory is adopted.
My lord, may I only, my lord, just show your lordship, my lord, one thing. Your lordship will, my lord, consider the, my lord, evidence of the plaintiff itself.
What does it say? Just tell us.
Yes, my lord, the 2 lines only. It says that the defendant, namely the company, was inducted as a tenant in 1986. So, by virtue of that agreement, so they are treating the proprietor and the company at all times to be the same. So, when me and my company A are being treated as the same, how can my company B be a case of subletting?
Reading that this Govind was operating from this premises. There's formation of a company. Yes, loosely speaking, one person may promote a company and all those things, but you cannot say a company is formed by a company in the legal sense.
Will your lordship just consider page 189? Lord, kindly consider 189. My lord, your lordship said whose name was the tenancy receipt, and kindly consider, my lord, this is from the plaintiff. My lord, it's a letter to the tenant of 2002. 16 years after, my lord, the tenancy came in. My lord, kindly see it's addressed to the proprietorship. Fixation of rent, same premise.
Of the company is also same with private limited.
No, so if you add private limited, it becomes the company. But that's my entity.
No, but Govind still remains a stranger to the suit property.
Lord, Govind
is a different juristic entity, Mr. Lakshman.
My lord, certainly,
You
but
cannot
my
get
lord,
over
it is, my lord, but it is my entity. It's running from the same premises.
This we have some doubt whether legally can in law whether that can be recognized. It's your entity. For the purpose of subletting,
Yes.
it's a different company.
My lord, may I only
to amalgamate with that and become that company. You may have been the promoter of the company, but once it becomes a company, it's a separate juristic entity.
No, my lord, for that, my lord, may I just cite one decision, if your lordship may consider?
Yes, yes.
Yes.
Why
So,
not?
my lord, I have convinced, I'm hoping, my lord, that today we are in a situation where a proprietor has created a company which is using that premises, whether that amounts to subletting or not.
Exactly, to mean by the proprietor has created a company. It's not a family company.
Well, of course, it's the same patriarch who starts, my lord. Kindly just consider one decision, my lord. It may throw some light on it.
Company law is, much
my lord.
modern than family life in India. So it does not recognize such patriarchy. Personal law is more patriarchal, maybe. Till now.
No, not this.
Times are changing.
Supreme Court. My lord, this is, my lord, 1986, Volume 3, Supreme Court Cases, page 62. Two decisions. Give one. No, but for the other side.
It doesn't have another.
86, 3, SEC, 62. Avinash. It's okay. Kindly, take paragraph 3 and paragraph 8 only. Are my lords there?
Yes.
We have been taken through the judgments of the rent controller and the rent control tribunal. We have also been taken through the relevant evidence. The facts which emerge from the evidence are that the Caravan Goods Carrier Private Limited was formed with the partners of the Madras Bangalore Transport Company as its directors, with the apparent object of circumventing the ban against the Madras Bangalore Transport Company from operating in the area allotted to the Madras Bangalore Transport Company. Both the Caravan Goods Carrier Private Limited and the Madras Bangalore Transport Company had their signboards at the premises, and they were both registered under the Delhi Shops and Establishments Act as having their offices at the disputed premises. Each was constituted as agent of the other. Detailed arrangements were made regarding the separate maintenance of accounts, etc. From the facts established on the evidence, we do not have any doubt.
Mr. Lakman, you have seen para 8 also.
Very well.
These facts, these foundational facts have been proved in your case.
No, my lord,
they were operating from the same premises and the same partners became the directors of the company.
Yes, so my lord, I have
Find
been
that from the evidence also. You had to lead
My lord,
evidence on that.
your lordship will then, my lord, see my written statement.
Was because while proving subletting, did they produce any document regarding your this caravan is your Govind?
Nothing. They have produced nothing. Only on a, my lord, the trial court hasn't even gone into all of this.
Govind has been
My lord, bereft of any evaluation of evidence or any pleading, purely, my lord, on the point of
But if it's
law.
a different company, if it's admitted that there's a different company, it has amalgamated, that's admitted by you.
Yes, it's
Then
a separate entity.
But onus shifted on you then, Mr. Lakman.
My lord, but
your
if,
client,
my lord,
show that they have the same person as directors or something like that. You are saying verbally now from the bar before the second
my
appeal.
lord, the pleading is there. My lord, my strength of my evidence, however weak, it should have been evaluated.
No, there is no evidence what can be done.
No, my
There
lord,
has
may
no
I?
evidence regarding this, we are saying caravan every time. This Govind was operating from the same premises, one. Secondly, the set of directors, no document, the owner shifted on you to show that these things are there. These are foundational.
My lord, master data is something, my lord, is public record. I can show that to your lordship.
Not
But my
a-
lord, that apart, if your lordship just considers, my lord, my pleading. My lord, my additional
Let us
details.
see your pleading.
Page 117, if your lordship sees. Is my lord there? Paragraph 5, my lord.
Devendra Kumar Mantri was one of the directors. He was also the sole proprietor of that.
Yes, my lord. In fact, this is not in dispute. They themselves have pleaded that the 86 tenancy was signed by the proprietor of the defendant company.
He is Devendra Kumar Mantri, this person.
Name, my lord, I will have to cross check, my lord. I was struggling, my lord, to even remember the names in the cost title.
No, the deed you showed us.
Yes. Names, my lord, I will have to cross
It
check.
has been annexed here.
The tenancy deed.
Tenancy agreement. Sorry.
Yes, my lord, at page 201.
See the signature page. What is there? Whose signature is there? And then we'll come back to this 117.
Yes. So, my lord,
let's see who signed.
I confirm. Just find out whose name this is. My lord, but in the meantime, if your lordship just sees page 203, and your lordship is there 203, the signature.
No, 203.
Yes, my lord. The agreement starts, my lord, at 201.
Yes, 203. That is what we want to see.
Yes. Your lordship sees page 203.
Yes.
Yes. Now, my lord, kindly tally this with, my lord, page 103.
This was Hope India.
Hope India, my lord, was the predecessor of the plaintiff.
Oh, there.
Yes.
Your signature is not there in that.
So,
the confirmation is there.
No, so, my lord, this is my sign, my lord.
Or something.
If your lordship just sees page 103 for a moment.
103 or 203?
203 I've shown your lordship is the signature.
As 103.
Now, my lord, kindly see 103.
Yes. Who's crossing it?
Just,
You're not there.
my lord, may I just consult, my lord, my colleague?
Yes,
for a
yes,
second?
why not?
Chief. Yes, page 66. My lord, kindly, I'm so sorry. Kindly, my lord, take page 66. This is, my lord, the chief, evidence in chief of the plaintiff. Kindly, my lord, see point 5 there, clause 5 of the chief at page 66. And tally that with page 203, the signatures. My lord, last line. This is the agreement dated 28th August 1986. It bears the signature of Mr. Arun Poddar of Hope India Limited and also bears the signature of proprietor of defendant company.
Yes, that is the confirming party signature at the bottom.
Yes.
That is some Ginodi or someone else.
So that is, my lord, that is
no
supposed to be.
has been made out that the like in Caravan, that the directors are the same.
No, my lord, proprietor of the defendant company. So in this context, my lord, there is a proprietor tenant. There is a proprietor tenant. And, my lord, the proprietor of the defendant company.
Proprietor of company means nothing, but basically.
So that's the tenancy, my lord, in the name of the proprietorship. The company didn't exist at that point in time in 1986.
That's what we understand. Let us suppose for a moment that they interchangeably treated as the same entity, this proprietorship and Balaji company. The company.
Yes.
Let us proceed on that premise.
Yes.
Even then, this and they even after it became a company, they have
so proprietor and Balaji are at all times same.
Suppose that. Let us proceed on that premise. They also took it that way.
Yes.
But then their the subletting, alleged subletting is when this Govind came into the picture.
So, my lord,
Now,
all
therefore,
my
if
evidence.
if you showed that Govind was operating from the same premises, same registered office, we could understand.
So-
Same directors are share the directorship of Govind and Balaji company, we could have understood.
Yes, my lord.
But
So
there is
now,
nothing, no foundational evidence on your part. to
your
show
lordship
that.
will, my lord, just
The
consider, my lord, my written statement for a moment.
Govind may have been, he may have been instrumental in the formation of Govind, but he could at best be a promoter.
I understand, my lord. Your lordship will just, my lord, take my written statement for a moment. My lord, written statement, my lord, at page 61. It starts at page 60. मेरा evidence in 60 देखो तो, additional. My lord, page 60 is the written statement. I only show one line, my lord. It starts at page 61. First paragraph, my lord, at page 61.
Yes.
Sixth line from top. It would not be out of place. It would not be out of place to mention here that the promoters, directors, shareholders of both the companies are almost the same group of persons. The defendant craves leave of this learned court to refer to the said order of the High Court. This is the amalgamation order. It's on the basis of this written statement that they amend their plaint to add the remaining entity, the amalgamated entity.
As subtenant.
No, as a defendant in the suit, because they had filed the suit, my lord, in the name of the X entity, which merged, which, my lord, ceased to have an original existence.
Oh, Govind is the appellant. He was Govind was incorporated as a defendant.
Yes, my lord. My lord, just one moment.
No, oh.
May I? Govind Promoters, my lord. Govind Promoters is the company which remains today. B.
Govind was the only defendant. Lastly.
Yes. The proprietor was not a defendant at all.
But Balaji no longer was there.
Balaji, no. So they filed a suit against Balaji. In Balaji's written statement, my lord, I say that now Balaji is Govind. So they then amend their plaint to make Govind the party in place of Balaji, to which I file an additional written statement, further stating that it's the same people, everything is the same. So, my lord, this had to be at least, my lord, adjudicated by the court below, that whether indeed this is same or not. Today, my lord, I have, my lord, master data. This all should have been adjudicated. However weak my evidence is, my lord, it should have been evaluated.
Produce some evidence to show that the shareholder, this pleading of yours.
There is no.
Court order was produced.
To the best of my knowledge, there is no cross-examination disputing this.
What is your evidence on this, Chief?
Just.
There can be only cross-examination if you say this.
My lord, the records, my lord, are haphazard because we filed in a hurry. The records are a little haphazard, but
you show us the examination in chief where you state this.
Chief.
You have to corroborate this.
Yes, my lord. Yes.
71.
71.
Thank you.
71. My lord, may I just, my lord, will Rachi just give me, my lord, a second?
Yes. Second chance or a second?
No, my lord, a second, my lord. As a figure of speech, my lord, just a little bit of time.
Yes. Just show us your statement.
Yes, my lord. Yes, paragraph 2, my lord.
Yes.
I say that in terms of scheme of amalgamation formulated by the promoters of defendant company.
Page 72.
71.
72. That's it.
Yes. It would not be out of place to mention that the promoters, directors, shareholders of the company is almost the same group of persons. Certified copy of the scheme is given here. There is, my lord, evidence.
Examination have you annexed? I haven't annexed the cross.
Cross-examination, my lord.
There is very little chance that you have annexed the cross.
No, my lord, I am hoping.
Going by experience. No, not about you. I mean,
102, my lord.
It's there.
So grateful to my friend, my lord. He's enabling me, my lord, to
He's
admit.
too fair for his client's comfort.
Lordship, can you give me 2 minutes, my lord? If Lordship, can you permit me, my lord? There is, my lord.
There is no question, my lord. Seems to be no question. So either the Carapiet rule could have triggered in, or the learned judge, my lord, under section 165 of the Old Evidence Act could have, my lord, sought for queries to be allowed, or the Carapiet rule, my lord. This hasn't been addressed at all, this question.
If we had given that 2 minutes to you, then what would you have argued?
My lord, I would have argued, my lord, admittedly, my lord, first point, what is being argued by my learned friend is not the case argued or
No detailed argument.
in the, my lord, very well. My lord, your lordship, my lord,
Whatever right of
Balaji
sharing.
Distributors Private Limited was my tenant. Admitted fact, my lord, by both the parties, my lord. Balaji merges, my lord, with Govind Promoters. Now, on the point of law, this principle, my lord, has been clarified by the Honorable Supreme Court as well as our High Court, which has been relied upon by the learned trial judge, by the learned appellate court, my lord, below. My lord, a proprietor may, my lord, only one submission. Proprietor may have 10 companies in the same address. That does not mean that all 10 become tenants. Balaji Distributors was the last.
Understood. Let us see the first appellate court judgment, sir.
Yes.
That one.
My lord, that starts at, my lord, page 20. And one of the relevant portion that deals with, because suit was on numerous grounds, kindly see pages 34 to 36.
Yes. Refer to the internal page.
Yes, my lord. Internal, my lord, page of my lord, the first appellate court or?
First appellate court.
First appellate court, very
well. Court you won,
so,
no difficulty.
So 38, my lord.
Internal page 3.
Starts at page 38. Just one moment, my lord. Just one moment.
Internal pages are at the top of the judge.
Yes, my lord, your lordship will, my lord, consider, starts at page 39. P39, last line in the first paragraph. However, it is stated in the written statement that the promoters, directors, and shareholders of both company are the same group of persons. So there's an acknowledgement, my lord, of my pleading. Then again, your lordship will, my lord, see the third paragraph there. In additional written statement, is your lordship there?
No. Which page?
My lord, at page, internal page 2. Internal page 2 itself.
Yes, additional.
Yes. In additional written statement, the defendant respondent stated similar to the original written statement. The fact of amalgamation is admitted. However, it is stated that promoters, directors, and shareholders of both companies are the same group of persons. So this has been my consistent stance. And my lord, the learned court, my lord, has taken cognizance of such stance of mine, which is also then my evidence on which there's no cross-examination. And then, my lord, your lordship will now, my lord, come, my lord, to my lord, page, internal page 3. First, my lord, on top, my lord, the first. Now, this court is to decide in the appeal whether the amalgamation of two companies and consequent transfer of tenancy right in favor of the new company may be treated as assignment or subletting of the tenanted premises, depriving the tenant the right of protection against eviction if the same is done without written consent of the landlord. May I just pause here? My lord, kindly read the first sentence again, please. Now, this court is to decide in the appeal whether the amalgamation of two companies, so it's not these two companies, it's a general proposition of law, my lord, that is being framed, my lord, to be answered. So it's not in the facts of this case. And my lord, this proposition is answered by, my lord, relying upon a range of judgments. And in all these, my lord, I can distinguish each of these judgments in one sentence each. Like, for instance, my lord, your lordship will see page 4. Page 4, my lord, right at the bottom, decision of General Radio versus M.A. Khadar, that decision, my lord, the judgment, my lord, is silent on the relation between the parties. The two different companies had completely two different names, and the general proposition was applied, but my lord, it was silent on what exactly was the relation between the parties. My facts are completely different, as pleaded. Then, my lord, your lordship will see the next page, my lord, page 5. My lord, the third last paragraph, Singer India. Another, my lord, decision is, my lord, here an American company had amalgamated, my lord, with an Indian company. So, my lord, in the facts of that case, it was a foreign, my lord, and a domestic amalgamation. Not at all, my lord, applicable to my case. Then, my lord, page 6, your lordship will, my lord, see Bhagwati Prasad Khaitan versus Turner, Morrison and Company. Page 6, if your lordship is there, my lord, it's in bold. My lord, here, my lord, the amalgamation of a holding company was with a subsidiary, but my lord, the distinguishing factors were that money was accepted by the holding company for subletting to the subsidiary. So there was, my lord, a monetary transaction.
The difficulty, Mr. Lakmani, becomes a third entity altogether. This is a different company.
My lord, may I just...
Whoever started it, whoever was the promoter, whoever was the patriarch or whatever you say, at the end of the day, this Govind is an entirely different company. Without his consent, you have amalgamated with that company.
So, my lord, may I just answer that, my lord, with one, my lord? Kindly, my lord, one decision and I will rest my case and I will leave it to your lordship.
You cannot get over that. I mean, it's a different company altogether.
My lord, it's a division bench, my lord, of our court. My lord, this is AIR 1989, Calcutta 178, in the context of, my lord, our Tenancy Act.
Yes.
My lord, first paragraph itself.
Yes.
The weight of authorities is clearly in favor of the view that if a tenant, without parting with the possession of the premises, forms a partnership or a company along with others, retaining controlling interest therein, and permits the firm or the company to operate from and use the tenanted premises, the tenant does not transfer, assign, or sublet the premises to incur the mischief of the relevant provisions of the rent control laws, providing for eviction on such ground. So, my lord, this is the proposition which is, my lord, not quarreled.
Here, the difficulty is Balaji did not retain controlling interest or anything. It did not retain its entity. It amalgamated. It lost its identity altogether.
My lord, may I say this?
It
My lord,
evaporated.
a tenant, my lord, a tenant creating a company. Now, my lord, here there's a proprietor.
This proposition, Mr. Lakmani, Balaji had to exist and retain a controlling interest in whatever it was merging with or whatever. It had to, suppose it had 60% share in that or whatever shareholding or
My lord,
whatever.
just one more, my lord. My lord, my mind works as per ABC. My lord, Balaji is...
itself is no longer there at all, no, non-existent.
Yes, Balaji A it's non-existent.
Not there. So there is a question of it retaining controlling interest of this Govind. It's Govind now all through.
No, but the proprietor is there. Kindly, my lord, even in the year...
How can proprietor...
My lord, in the year 2002, my lord, there is a letter which they have exhibited, my lord, writing, my lord, to the proprietor that, dear tenant, we wanting to increase your rent.
Balaji, everything Balaji.
No, but that's the my lord, that's the proprietor. Proprietor is of course there.
Maybe proprietor, then it became a company. They did not have any qualms on that because the proprietor himself maybe created the company. But so, Govind is a different company altogether.
No, my lord, but it is of the same proprietor. And my lord, if, my lord, the proprietor, just consider, my lord, this...
We are looking from the lens of the landlord, Mr. Lakman, not from the lens of the proprietor.
Yes.
From the lens of the proprietor, you are right. The proprietor presumes, the proprietor's presume says, it has created, it has, the rainbow has diverged into one is Balaji and another is Govind. It's the same proprietor who creates these companies. Let us suppose that.
Yes,
but we have to look from the lens of the landlord. He doesn't give any consent. He all along has dual relationship with Balaji in whatever avatar it comes. Yes. Either proprietorship or company, or Balaji remains Balaji. But when Balaji goes altogether, now from his lens, Govind is entirely new. For proprietor of Balaji, they may be the same, a continuation of his identity through the genes of Balaji. The Balaji genes go into this Govind, but it's the proprietor's genes. From the landlord's viewpoint, there is no transfer. It's a different entity altogether.
My lord, understandable. My lord, if I may just, my lord, give an answer, my lord, in the way of a question. My lord, if I am a proprietor and I have two companies operating from my premises, and at all points in time, one of those two companies has been, my lord, interchangeably recognized as the tenant along with me, as is the my lord case here. And then if I decide for tax convenience or whatever on the advice of my chartered accountant to merge my two companies doing the same business, my lord, same trade from the same premises, would this really amount to me bringing in a new person? At the end, my lord, the mischief referred to is, my lord, me not actually using it but giving it to somebody else, or at least a part of it to somebody else. For all practical purposes, my lord, I am the one who is running everything. For my convenience sake, I have amalgamated two of my entities. I am still, my lord, there at the premises. The tenancy is in my name. The tenant rent agreement is in my name, not in dispute. My lord, whether, my lord, in the facts of this case, would it really amount to, my lord, subletting? Who is it? Who is it that I have given it to, if not myself? So, my lord, this is a question of fact. But, my lord, the fact that the trial court didn't even go into this question of, my lord, fact is, my lord, now a question of law. Whether it should have or it shouldn't have. Otherwise, my lord, in any amalgamation case, straight away there'll be a decree. Praying for a detailed hearing, my lord, where I can, my lord, distinguish all these. I'm not, my lord, praying for my appeal to be allowed today, my lord. I'm only, my lord, praying for an opportunity of a detailed hearing, my lord.
Very well. We'll admit this.
Grateful.
The present second appeal will be heard on the following substantial question of law. Whether, comma, in view of there being no counter suggestion put to the defendant's witness with regard to the promoters, directors, and shareholders of both Balaji Distributors within bracket Electricals Private Limited, comma, the original tenant, and Messrs. Govind Promoters Private Limited, comma, the alleged subtenant, being almost the same group of persons, comma, the learned First Appellate Court was justified in granting an eviction decree on the ground of subletting, comma, without considering as to whether Messrs. Govind Promoters Private Limited was an alter ego of Balaji or Electrical যেটা বললাম, in spite of the amalgamation between the two companies. Only this question. Yes. Any interlocutory application, Mr. Lakmani?
Yes, my lord. My lord, can one.
Stay.
Can one is, my lord, stay.
Occupation charge. They said execution has been levied. You have levied execution?
No, till date it has not been.
There shall be stay of operation of the impugned judgment and decree of the First Appellate Court till disposal of Can 1 of 2026. Whose affidavit in opposition thereto shall be filed by the respondent within how much time? You need to get those documents also.
1 week.
Within a week from date. Whose reply if any shall be filed within a week thereafter. Whose the liberty to the parties to mention the application for inclusion in the list of the appropriate learned single judge having determination after the after a fortnight. Full stop. It is made clear that the question of imposition of occupation charges as a condition of stay as well as the quantum thereof is kept open for being decided at the final hearing of the stay application.
Grateful, my lord. Thank you.
Very well argued, Mr. Lakmani.
Grateful.
We had to reverse our view. Yes.
Grateful.
এটা দেখে দাও। question. Alter ego failure.
I appear for the appel.
হচ্ছে judgment টা নাকি?
May I please?
Yes, please.
Property was purchased by my grandfather. Subsequently, my father came into the picture.
No, what is the stage? I mean, you have this is appearing for admission now.
Admission, order for.
What happened previously?
Well,
Or rectification of memorandum, madam. Sorry, yes. Remember. Please repeat, grandfather.
property purchased by my grandfather.
Yes.
Subsequently, my father came into the picture. The
First,
property
tell us
was
what have you
default.
challenged? Injunction
Alright,
grant.
Yes, refused. Injunction refused.
Ad interim.
Ad interim as well as on contest, my lord. If my lord kindly takes the
So
order.
not ad interim then temporary injunction has been dismissed.
Temporary injunction has been dismissed. My lord, we kindly take page 97. The impugned order, my lord, 1st June 2026.
You have to make out a very strong case that it's a fraudulent document, forged it. Forged it can be
But,
proved in trial.
There is a clear suppression. May I show you a lordship? But I will kindly now come to page 31, which is the gift deed, impugned gift deed.
No, but this is an ad interim refusal.
No, my lord, the final refusal, your lordship.
Oh, you are challenging the last order.
Yes, last order.
Okay, let us go to that then.
Last order, my lord, the last order is 1st June 2020.
In the same appeal, you cannot challenge several orders.
No,
You will constitute this to be a challenge in the last order.
Yes, yes.
Obviously, it has merged in this.
Merged in this.
Let us see the last order. We saw the first order now.
My lord, 1st June 2026, your lordship takes
Yes.
page 97. It's marked here.
Oh, no change of circumstance and the same logic.
Same logic. My lord kindly takes the subsequent page.
Yes.
My lord, fairly at the bottom, my lord, at this stage, if my lord kindly takes that part.
The final order.
Final order, your lordship, page 98. At this stage, the
Yes, we have read that. We have read that.
now my lord will kindly take,
Defendants have appeared and they have admitted they cannot admit the existence. They have asserted rather.
they have admitted the existence of the gift deed. Now, my
If
lord,
it is in their name.
it is in their name. My lord kindly comes to page 31 now.
30?
31, which is the gift deed. My lord, the daughters have been left out.
That may be one may give one's property to only the sons.
No, my lord.
That itself does not make it vitiate it.
Now your lordship, this is the
registered
gift
deed.
deed. My lord, may I just socialize?
Yes. It's 50. You are the daughter.
My lord, I'm the daughter. My lord, kindly come to page 50.
50.
50.
Yes.
My lord, and whereas the said Rajendra Singh donor, the third paragraph.
50.
50, your lordship. 50.
Oh, there are two sets of paginations. The faint one you are relying on.
Faint one.
Yes, whereas.
Internal page 5.
Yes, yes, Rajendra Singh.
And whereas Rajendra Singh donor has married to such and such in the year such and such, and out of the wedlock only 3 male child was born. Well, that's clear suppression. The 2 daughters have been left out.
Only is not there.
Well, three male child were born. Well, there is no utterance of the daughters here.
No mention of the daughters at all.
No mention. Now, my next document. Your lordship kindly takes into consideration page 88. Well, this is a document. This is my written objection.
You had different mothers or the same?
No, same mothers.
The mother is the donor.
The father is.
Father.
Page 83 is my written objection to the is their written objection to my order 39 rule 1 and 2.
Clear admission paragraph 10.
And my lord kindly takes the page 84 paragraph 10 and 11.
Yes.
That regard to statements made in para 6 of the injunction application.
No, they admit you are the daughters.
Admitted. Now your lordship kindly comes to the mental health of my father. My lord, page 88. It is their written objection.
Yes.
My lord, para 18. My lord, this is 4th line.
Seriously.
As a matter of fact,
lost control over.
Yes, your lordship. Now the learned judge has not considered these at all. In my respectful submission before your lordship.
Rajendra Singh is the donor.
Rajendra Singh is the father who is the donor. My lord kindly takes now the, my lord kindly compares the gift deed with this page. Okay.
What about,
My lord, page 33, 46. So they have admitted
this is-
clearly.
No, no.
But
This must have been in the denial section. I mean, it's a mistake. This must have been, there must be a reference to you. Because after that, they say defendants execute taking
they have
advantage.
only in denied
Seeing
the
such
injury.
situation, defendants executed the deed of gift. They won't be admitting by employing their chosen advocate who in turn prepared the deed.
This is what is accurate.
No,
for
this
the
is a
fact.
denial. It's a denial. This is a part of the denial.
My lord, they have
This has been
admitted me
couched
as a-
unhappily.
admitted me as a daughter, and my lord, I have
This must
shown-
be your statement in your para 17 and 18. Let us see your injunction application para 17 and 18.
Yes, sir. Injunction application, my lord will find that page 72.
Social structure, such and such.
My lord, para 17, 18, your lordship will kindly take page 77. Which your lordship
Yes,
is
yes,
ready.
yes. Yes, right.
And next, your lordship will kindly take, my lord, in this page 77,
Huh.
my lord, para 16, last 3 lines. Last 3 lines. Though in fact, Chandrakanti Singh, that is my mother, has no right over the said scheduled property, has gifted the property. My lord, one of the executors of the gift deed.
You say that father executed?
Yes. Father and mother both.
We asked you specifically, that's why. So both the father and mother executed the gift deed.
Executed the gift deed. And my father expired in 2000.
Achha, regarding possession, what proof of possession have you shown? You have also asked injunction regarding possession. Possession, we are a bit hesitant because without knowing who is in possession.
Well, I'm told that we are in possession because
You are told you are in possession.
But I have pleaded in my plaint that I was
That
there.
won't suffice. Is there any proof? Otherwise, regarding transfer, you can appreciate, yes. Transfer, creation of third party interest you have asked for, we can consider that. But regarding this possession, you have to show something.
They are admitted.
Third party interest will.
Well, at page 84, para 11, they have admitted
Let us see that.
that I am in possession. Page 84,
Their
your lordship,
written objection seems to be drafted by you also. Para 11. Achha.
Para 11, page 4, page 84.
Admit the same and further state the.
They have admitted me as their full-blooded daughters of.
And she used to stay on.
Used to stay.
And used to stay.
And are residing at the scheduled property. You managed your other side, or not here. I mean, anyway. The present appeal has been preferred against an order whereby the temporary injunction application filed by the plaintiffs stroke appellants in connection with the suit for declaration that a deed of gift executed by the parents of the parties was fraudulent and void and consequential reliefs, comma, against an order whereby startটা কি করলাম একবার বলুন, the present appeal has been preferred against filing has been refused. Full stop. Next para, learned counsel appearing for the appellant submits that the learned trial judge failed to advert to the materials on record, comma, particularly to the fact that the plaintiff's possession in the suit property has been categorically admitted in the written objection filed by the defendant's respondents in their written objection thereto. Full stop. Moreover, comma, the moreover, whereas the relationship of the appellants as the daughters of the donors has also been clearly admitted in the written objection, the deed of the the impugned deed of gift proceeds on the premise as if the donors had only 3 sons, that is the respondents, without any whisper as to the existence of the appellant's daughters. Full stop. Even otherwise, from the written objection to the injunction application filed in the trial court, it would appear that there is an admission on the part of the defendants that the donor, that the father of the appellants, that is one of the donors, was seriously ill and lost control over himself. Full stop. Next para. Thus, it is submitted that since the case of forgery was prima facie established, the learned trial judge ought to have granted injunction. Full stop. Next para. We find substance in such contentions and further take note of the settled position of law that at the stage of considering an injunction application, the title of the parties to a property is not required to be proved to the hilt, but the learned trial judge only has to see whether a triable issue has been raised for hearing of the appeal of the suit on merits. For proceeding from such perspective and in view of the aforesaid circumstances, we find a sufficiently strong prima facie case being made out for grant of injunction. Next para. Even otherwise, in the impugned order, the learned trial judge apparently proceeded merely to make the earlier ad interim order granted by the trial judge absolute, without an independent consideration of the averments, the allegations and counter allegations made by the parties. Full stop. Hence, the appeal is admitted and will be heard on the above questions and the other grounds taken in the memorandum of appeal. Full stop. The respondents and their men and agents shall remain restrained by an order of injunction from creating any third-party interest in respect of the suit property and or disturbing the possession of the appellant stroke petitioners in respect thereof till disposal of Can 1 of 2026. Full stop. The appellant shall serve copies of Can 1 of 2026 as well as copies of the memorandum of the appeal on the respondents, indicating that the application shall next be listed for hearing in the monthly list of September 2026, when an affidavit of service to that effect shall be filed by the appellants. Well are good. Yes. Next.
This is my in a suit for
sorry, yes.
In a suit for defamation, damages and compensation, ad interim injunction has been refused, I'm up against that. But kindly take the impugned order once,
yes,
with the memo of appeal. But it's an order dated 22nd May.
With the memo of annex everything, the entire certificate.
I don't know. They said that they have taken up.
Don't do that. You always apply for certificate copy separately. Apply for the order separately and the other certificate copies. Anyway, you have got the order before us.
Yes, kindly have a look at the order.
Yes, please.
The only, kindly sees the reasoning. I have carefully gone through the.
Yes, we have seen. We don't know whether it's the same judge. This is a replica of several other matters.
Orders, similar type of orders. Kindly have a look at
Questioner. Yes, we know this order.
A good case for trial, but yes. No ad interim.
Exactly same. Ekdam same length. Copy paste. Might have a good case for trial, but at this stage. Independently satisfy us also, Mr. Just prima facie.
I'll tell you a lot what the facts is in brief, my lord. This is an ex-employee of this NIPS School of Hotel Management, my lord. He, resigns. My lord, obviously the relationship, my lord, he was there for, my lord, from 1998 and his resignation happened in 2026. Obviously, at the end, the relationship was not good. There are interests, there may be disputes between the parties. I am not on that, but after resigning, he puts up something on Facebook.
You have annexed those?
Yes, madam.
Just first one.
Yes, madam.
One or
Kindly
two.
comes to page 102. But kindly see, I don't know, your lordship's copy how it is.
You just check up.
Yes.
102 if it's otherwise.
102,
decide.
103, and 104.
These are sarcastic advice.
No, I'll just, if your lordship has got 102,
102, yes.
but he puts up, he says 27 years, 4 months gone.
Journeyed.
Yes.
Journey of such and such ending.
Then
sincere best wishes to NIPS,
yes.
which is
Yes,
sarcastic.
that is fine. No problem, my lord. Then somebody says good wishes to you, sir. And then, my lords, he starts. And then he again writes. That is where it starts.
But this is bad English only, not congratulate and all.
My lord, I have been humiliated day on day again. My salary reduced and then reduced salary not paid. I have been shouted upon. I am worthless. I am no good. I have made bad to NIPS. My lord, then my lord turns over. My lord, then the others are reacting to it. And my lord, 104 is very important. 104 is another employee who has joined. Kindly see what he asks him. Do you get your salary? Salary pow.
Yes, yes.
Has your lordship got that?
Oh, he's asking.
He is asking. My lord, all that I'm asking is, my lord, these posts, my lord, whatever be the thing, my lord.
How can you implement this? I mean, he'll say that.
My lord, my lord, kindly see what he says. Something to be discussed, as this will be aligned with freedom of speech as per law. And my lord, I'll show his, my lord, reply. We gave him a notice. My lord, in his reply, he says, Facebook is my personal domain. I can write whatever. Lord, may I just show that, my lord, what he is his legal reply.
Whether we have to. Triumph even.
Read, my lord,
reduced. Maybe facts.
My lord, maybe facts, but my lord, the other person, my lord, whatever his dispute is, but he is telling even the others that whether you get your salary or not.
Yeah, he has a right to ask others whether they're getting their salary.
My lord, but my lord, that is in a way, it's an innuendo, my lord, where he is trying to say, my lord, all that we are saying is whatever.
It's all innuendo, no direct.
My lord, innuendo is, my lord.
Salary reduced, maybe fact, we don't know.
Then, my lord, the other thing, he has been humiliated.
I have been shouted upon.
My lord, these are all.
After writing this, this sort of English, he might have been shouted upon.
My lord, he has resigned by that point of time. It is after resignation. My lord, this is happening.
Very well, yes.
I have like two similar, my lord, cases also, my lord, on this, my lord, by coordinate benches, my lord, it has been restrained. My lord, similar public.
Same person?
No. A different matter.
Here the innuendos were stronger or similar?
Yes, my lord, stronger, similar, my lord, but innuendos were there, my lord.
What is the softest innuendo there? Show us that. Stronger, yes. A person resigns or he's forced to resign. He says, my salary was reduced. I was shouted upon. This is not defamation. One may be shouted upon by the boss.
The only thing which I am showing is, he first starts with saying my sincere best wishes. Then people start wishing him.
No.
And then, my lord, he gets into.
One is entitled to sarcasm, Mr. Viraj. This much we cannot. And he's right. He's entitled to freedom of speech.
Freedom of speech.
I get thrown out of a company, forced to resign. I say my salary was reduced. I was shouted upon.
Yes.
Right. And then he says best wishes to the company.
But till that extent,
right this much.
Till that extent, my lord, I understand, my lord, he's
right. To went somewhere.
Whether he's saying that or not.
Touch you come up and file
no,
defamation.
But salary, whether somebody else, my lord, who has just joined, he's asking him sarcastically, do you get your salary?
Yes, he may ask him seriously also. Are you getting your
My lord,
salary?
my lord, that
He may
would perhaps,
caution a person that you ensure that you get your salary.
my lord,
That's not also defamation.
in
He's not saying they don't pay salary even.
my lord, what it is creating is, my lord, the effect of that is, my lord, after that, never expected this to happen to you at least.
He did not expect.
No, my lord, the
Others did not expect.
my lord,
That's others.
my lord, in a way,
Defamation.
my lord, in a way, my lord, it is, my lord, all that we are saying is, my lord, let him not publish all this. Whatever is his, my lord, he can, my lord, obviously take his.
I mean, we cannot.
And my lord, he is
kill a person.
still continuing also, my lord. That is the thing. Right now also he
What
is
has he
continuing.
written? You cannot strangle a person.
Kindly have a look.
Strangulation of a
My lord,
person.
after that also, my lord, he is continuing, my lord. Kindly see. Somebody else is saying this person is staying at this hotel, but salary and gratuity is due. Somebody else, my lord, he is commenting every.
After such and such, he's staying in Taj. You are not Taj. You are the
No.
hotel manager.
My lord, this Dr. Pathak is, my lord, another employee. He is staying on his page, he is going and writing. My lord, on every person who is associated, he is writing on their pages. My lord, somewhere there has to be a stop, my lord, otherwise this continues, my lord.
No, the next posts are very.
Well, I didn't want to
reload it.
Obviously, my lord. So, my lord, if it's not stopped, my lord, it's just.
All right, yes, it's increasing. The present challenge has been preferred against the refusal of ad interim injunction sought by the appellant in a suit primarily for defamation, compensation on the ground of defamation. Whose of next para? Learned counsel for the appellant places before the court the relevant portion of the impugned order, where the learned trial judge, despite having observed that a good case has been made out by the plaintiff for trial, refused to grant any ad interim injunction merely on the ground that at this stage the other side is required to be heard. For next para, it is palpable from the impugned order that the learned trial judge did not advert to the materials and the averments placed before her at all while considering the prayer for ad interim injunction. Full stop. From the at the stage of ad interim injunction, it is well settled, the learned trial judge has to proceed on the premise of the averments made in the plaint and the temporary injunction application and the documents relied upon therein. Full stop. From the said materials, we find that a prima facie case of defamation has been made out, thereby entitling the plaintiff stroke appellant to injunction as sought for, at least at the ad interim stage. So, where is the prayer for injunction in the trial court, Mr.
Yes, ma'am.
Just show us the prayer in the trial court.
Yes.
We'll proceed on that premise.
59.
59.
Yes.
Accordingly, the respondent is restrained by an order of injunction from publishing, circulating, republishing and stroke or causing publication of any defamatory statements, comments, posts or materials concerning the appellant, including statements similar to or containing allegations akin to those contained in the publications which were furnished with the plaint in social media and in any medium whatsoever till disposal of Can 1 of 2026. For next para, the appellant shall serve a copy of the application as well as a copy of the memorandum of appeal on the respondent, indicating that the application shall next be listed in the monthly list of September 2026 when an affidavit of service to that effect shall be filed by the appellant.
The D, prayer D also, my lord, I was thinking, my lord, but my lord, anyways, my lord, for the time
What
being,
was
my
D?
lord, to take it down, my lord. Though it's in the form of mandatory injunction, I know.
Up to
very
this,
well,
up to this, what you have annexed, we
yes,
didn't find any
very well.
anything very serious.
Very well. But it's just getting bolder and bolder.
It's getting bolder. But এটা একটু ফেরত দিয়ে দিতে। Take this back,
Yes,
Mr.
Malad,
Raychaudhuri,
we'll come up with
but
a-
we are not in a position to advise you.
Yes, Malad, we know what is to be done.
Yes.
Grateful to you, Lakshmi.
Yes. Next.
My lord.
Yes. Yes,
My
Mr. What
appeal,
is
my
the
lord,
case?
from an order under Order 39, Rule 10, directing, my lord, deposit of occupation charges.
One second. Valuation is 100 rupee.
Yeah, my lord, the stamp reporter has recorded that that is incorrect, my lord. We have paid the value, the 50,000 rupee court fee, my lord. That has to be corrected.
You have annexed the plaint?
Yes, plaint is annexed, my lord. I'll just indicate.
Doesn't
The plaint, my lord, what you will find at page 24.
Yes.
Prayers are at 37.
Right.
The lord will kindly direct us to make that rectification.
On
My
the
lord,
prayer
we
of
have
learned
paid.
counsel for the appellants, leave is granted to the learned advocate on record for the appellants to rectify the valuation statement in the memorandum of appeal during the course of the day.
Lordship.
The appeal is taken up for hearing under order of Rule 11 of the Code of Civil Procedure. Yes.
May I file the affidavit of service?
Affidavit of service filed to be kept on record. Mr. Bose, you are appealing for the sole, all the respondents.
Only for the plaintiff, High View Apartments Private Limited.
If your lordship.
What about 2 and 3?
2 and 3 are, my lord, my wife and son.
Very good.
So they are allied in interest of the appellant
So
here.
your present appeal is against, practically against.
Yes, my lord. If your lordship will just kindly take the cause title in the plaint once, that is at page 24.
Yes.
Highview Apartments is the plaintiff, represented by Mr. Bose, my lord. And the defendants are Arvind Kumar Jhunjhunwala, number 2 is Meenakshi Jhunjhunwala, 3 is Akshay Jhunjhunwala. So wife and son. Defendant number.
No, the respondent numbers 2 and 3.
Yes. So I'm showing your lordship from the plaint, my lord, that Meenakshi Jhunjhunwala and Akshay Jhunjhunwala.
No, not about you. We are asking respondent numbers 2 and 3 whether they are represented.
No, my lord, they're not separately. If your lordship.
They must be separate from High View.
Yes, my lord. But you will see.
So only you are for one only.
I am for one only, my lord.
Respondent number 1, Mr. Bose is appearing, Mr. Shah.
For Highview, yes, my lord. The others are not separately represented because they are allied in interest with Arvind Jhunjhunwala, my lord. That is all I'm saying.
Well,
yes, my lord. So, my lord, if your lordship will directly take the order, or may I just give your lordship a gist, background in the conspectus in which the order imprint came to be passed? Yeah, my lord.
What is the injunction application?
No, my lord.
Injunction order.
The suit is, my lord, for eviction, arrears of rent, and mean profits. In that, my lord, they made an application for occupation charges to be paid. And also they said that, my lord, since 2019, my lord, they have been paying the maintenance charges in respect of the suit premises to the defendant number 5, that is the owners association. So I should be directed, my lord, to pay them for the maintenance charge they have borne on my account. And henceforth also, my lord, I should be directed to make maintenance charge payments directly to the association. Now, my lord, in the order impugned, I have been directed to pay occupation charges. I have also been directed to pay maintenance charges, both arrears that they have paid.
So why appeal?
My lord, yes, I'll tell your lordship. The gist of my submission is this, my lord. For occupation charges, to my humble understanding, my lord, the sine qua non is there has to be an establishment or an admission regarding, my lord, landlord-tenant relationship.
No, but review 227 lies. How can you prefer
Order 39, Rule 10, my lord. That is appealable under Order 43, Rule 1, appeal from order. My lord, the petition that is filed, I'll show your lordship, my lord.
The caption is immaterial.
Caption is, yes, that is my humble submission. Your lordship will see the application that is made, that is at page 312. The nomenclature is application under 151.
Maybe.
But in fact, my lord, powers under Order 39, Rule 10 have been invoked by the learned trial court in passing the order impugned. So, my lord, in my humble submission, it is appealable under Order 43.
Give us half a second. So 10 is where the subject matter of suit is money.
Yes, my lord.
Here eviction and mean profits also.
Arrears of rent and mean profits. That is why, my lord.
Yes.
And
or some other thing capable of delivery. And any party that admits that he holds such money or other thing as a trustee.
Yes, my lord.
Or that it belongs or is due to another party. The court may Rule 10 is on the basis of an admission code may direct it to be deposited in court or paid. You have not admitted anything.
I have not, and that is why the order impute could not be passed. But Lordship,
3910 doesn't,
well,
3910
3910 has been considered by the trial court in passing the order. I will show your Lordship from the text of
has
the
been
order
treated
itself.
to be.
Yes, he has held that under 3910 he has the power. And my lord, Order 39 Rule 10 has been considered by my lord the single bench of this honorable court in the matter of Green Band apartment.
No, but the sine qua non is admission.
Yes, sine qua non is admission where there is none. So he could not have invoked powers under Order 39 Rule 10 to direct
And
occupation
if it's
charges to be
passed under
paid.
3910, then you have to prefer an appeal, and
That
then
is why I have come before your lordship, my lord. And 3910 has been considered.
we'll continue after the recess immediately after this. Mr. Bose will come back after this.
My lord, I apologize, my lord. Second appeal.
You are in the middle of a
matter.
matter, sir.
I know, my lord, but
No, don't.
the writ has been issued, my lord.
Maybe no. This is not the mentioning of. Yes.
My lord, on the aspect of maintainability, I was showing your lordship how, my lord, powers under Order 39, Rule 10 have been invoked, which is appealable under Order 41, Order 43, appeal
Yes,
from orders.
it is.
My lord, I will show your lordship from the impugned order how that power has been invoked. The
Right.
court has held that he has power under Order 39, Rule 10 to direct, my lord, payment of occupation charges. That apart, my lord, of course, is an argument in the alternative. I am also equipped with cases where it says, my lord, even if the matter is, my lord, revisable and not appealable or vice versa, lordships, of course, have the power, my lord, to convert it to the other. And, my lord, the only real test to see whether, my lord, this power to convert should be exercised is to see whether the appeal has been filed within time or not.
No, even otherwise, Mr. Shah, if a particular power has been invoked,
yes,
then the remedy against that provision has to be.
And I'm, my lord, confident I'll be able to satisfy your lordship of that. I'm just saying, my lord, as an
as
alternative
a matter of principle, you agree with that.
lordship.
If the court even erroneously assumes a power, particular power,
lordship,
then that will be the determinant of what is the remedy.
Yes. And my appeal is filed within time, so there's no difficulty on that score. Now, my lord, may I, before I take your lordship through the order impugned, I'll just like to give your lordship the factual background in just 1 minute.
Yes.
My lord, here, your lordship has seen the defendants are, my lord, Arvind Jhunjhunwala, his wife Meenakshi Jhunjhunwala, and his son. Now, my lord, the property in question, my lord, is 10B Balihai. It is an apartment in Alipur. So, my lord, how the plaintiff came to acquire this is important. So, because the question is, what is the character of my occupation? They asked for my eviction. I am saying there is no admission or acknowledgement of landlord-tenancy relationship. So, they could not have directed, my lord, occupation charges to be paid, because that is the sine qua non for directing occupation charges. My lord, the premises 50% was, my lord, acquired by the plaintiff through SARFAESI sale. The remaining 50% interest, my lord, undivided 50% interest, was held by one, my lord, Phul Mintri Devi. So, my lord, the plaintiff acquired the remaining 50% from Phul Mintri Devi. And, my lord, under Phul Mintri Devi, there was a tenant called Manish Dokania. He is also a defendant. Under Manish Dokania, my lord, the wife and son of the defendant number one, my lord, Meenakshi Agarwal and their son, they were inducted as tenants under this Manish Dokania. So, subtenants under this Phul Mintri Devi.
What about you, Arvind?
Arvind Jhunjhunwala was never a tenant. So, I'll come to how Arvind Jhunjhunwala also independently occupying. My lord, this plaintiff company, Highview Towers Limited, it's a company. Arvind Jhunjhunwala used to be a director of this company. So, my lord, it is the avowed case of the plaintiff that they permitted Arvind Jhunjhunwala to occupy the premises as gratuitous licensee while he was a director of the company.
Regarding the other 50%.
Regarding the entire
SARFAESI purchase.
They've not really distinguished, my lord.
You are distinguishing on that light.
Yes. I'm just trying to show your lordship, my lord, how I came into possession and, my lord, how the plaintiff acquired the interest. So, my lord, I'm telling your lordship that.
So, you were, as director of that company, you were put in position as a gratuitous licensee sort of.
The Arvind Jhunjhunwala, defendant number one, was gratuitous licensee as director of the company. That is the plaintiff's case. And, my lord, his wife and son were subtenants under this Manish Dokania.
That is also the plaintiff case.
That is, my lord,
Not
yes,
exactly
it's not
the-
disputed in the plaint or in the affidavit in reply to this application also.
All right, yes.
So, this is how I come into possession. Thereafter, my lord, after the plaintiff company acquires 100% of interest in the property, my lord, 50% through SARFAESI sale and 50% from this Phul Mintri Devi through outright purchase.
No, you purchased the property?
I
or-
did not. Plaintiff company.
Oh, sorry.
Mr. Bose's client.
Right.
They acquired 50% in SARFAESI sale.
Oh, right.
And balance 50% they acquired, my lord, from Phul Mintri Devi.
Yes.
Who is my super landlord. Super landlord of the wife and son of Arvind Jhunjhunwala, defendant numbers 2 and 3. Now, my lord, this is how I come into possession and this is how the plaintiff acquires the entirety of the suit property, 10B Balihai. Thereafter, my lord, this Manish Dokania, he surrenders his tenancy. He comes direct tenant under the plaintiff, my lord, he surrenders. But what is material, my lord, is I ought to have become direct tenant under the plaintiff company at that juncture, but neither has the plaintiff company ever demanded any rent from me.
No, you automatically don't become a director.
I could have asked for atonement of the lease. I have not. I have not. They have also.
There were provisions under the 56 Act as well as the 96.
Lordship, I have not. So that is why I'm saying I never came to become.
Your tenancy was coextensive with your superior landlord's tenancy.
Yes, could have been. But
You
what
have
has
legal right now as such.
Well, this is now I'll explain to your lordship what is my legal right. So, couple of facts, my lord, I'd like to draw the court's kind attention to. One is, my lord, since the plaintiff company acquired from this Phul Mintri Devi, this is all in 2013, as far back as 2013.
Both the surface and this.
Yes, both the surface acquisition and, my lord, the acquisition from outright purchase from this Phul Mintri Devi was in 2013.
Yes.
Suit is filed in 2019. In the intervening 6 years, my lord, the plaintiff has not once called upon any of them, Arvind Jhunjhunwala, wife, son, to pay any rent. They have not acknowledged me to be tenant. They have not demanded any rent. I have not paid them any rent. I had last paid, or the wife and son had last paid license fee to, yes, Manish Dokania. So there is no landlord-tenancy relationship with the plaintiff and myself. Now, lordship will ask me, what is my right to occupy them? This is the case. Now, my lord, your lordship has seen the plaint that the plaintiff has filed, my lord, that is 1166 of 2019. And is at page 24 is the plaint, my lord.
Yes.
And the reliefs, my lord, are at page 37.
Right.
There is another suit that was filed prior in point of time. That is my suit. Lordship will find the plaint at page 542. That will be, my lord, volume 5 of the stay petition. This is a little important, my lord. I'll have to take your lordship through this. So page 542, my lord, this is title suit number 606 of 2019. That is filed by the defendant number 1, Arvind Jhunjhunwala, my lord, and wife and son are also parties here, against the plaintiff herein. And the reliefs, my lord, are at page 557. The case is this, my lord. There was a My lord, the plaintiff company belongs to the Bangar group of companies. Hemant Bangar was the original promoter. Or Hemant Bangar's father, ki naam bodol? Gopal Das Bangar was the promoter of the company. He has passed away, my lord. He passed away, I think, in 2018. And his son is Hemant Bangar, who is currently in control of the plaintiff company. And my lord, lordship has been told, my lord, that the defendant number 1, Arvind Jhunjhunwala, was a director of the plaintiff company. That is the plaint case also, no dispute there. Subsequently, he's been removed. And after his removal, he's been asked to vacate the premises. The defendant's case, my lord, is that while he was an employee of the plaintiff company, he simultaneously, my lord, was an employee and, my lord, officer in various other companies of the Bangar group. And he has rendered services to these Bangar companies, for which, my lord, payment was outstanding to him. Some as consultant, some as director, some as otherwise, my lord. They're engaged in various real estate projects. So he has negotiated the land deals, my lord, procured eviction of tenants, things like that, for which, my lord, monies were payable to him. So, my lord, there was an oral arrangement manifested through conduct and through, my lord, contemporaneous correspondence that this property, 10B Balihai, which is the suit premises, is being acquired by the plaintiff company for the sole object of transferring it to Arvind Jhunjhunwala in lieu of the consideration payable to him for services rendered to the Bangar group of companies. So, my lord, my suit, which is filed prior in point of time, 606 of 2019, is for specific performance of this agreement. And this explains, my lord, why even when the plaintiff acquired the property in 2013, when they acquired 50% from Sarfesi sale, my lord, and the remaining 50% from this Phul Mintri Devi, this title deed, admittedly, is in my possession since 2013. Possession of Arvind Jhunjhunwala. The plaintiff has never called upon me to return this title deed.
Title deed of Haida's purchase.
I beg your pardon, my lord?
Title deed of the plaintiff's purchase.
Plaintiff's purchase of 50%
title deed is with you.
Yes.
So, according to you, the understanding was that the plaintiff is purchasing that for you.
Yes.
Without any further transfer in your favor.
My lord, there is the envisaged transfer was through the transfer of the shares in the plaintiff company to me. So it's not that, my lord, there is any lack of stamp duty or registration required. There is no conveyance envisaged. It was expected, my lord, and understood.
Shareholder cannot be the owner of the assets of the company. High-rise is the company.
Right. That is right. That is right, my lord.
So how do you say that it was purchased for you?
That is what I'm trying to demonstrate from the conduct, my lord, that there's an agreement that this property will be transferred to me through the device of transfer of the shareholding of High-rise. So the contract that I have, oral agreement that I have, is not with the plaintiff, but really with the...
Tally. I mean, How can there be a transfer of the asset of the company through transfer of shareholding?
Let me try to explain.
Don't understand this.
Perhaps I could not make myself clear, my lord. My arrangement is really with the promoters of the company, not with the company itself.
Yes.
My arrangement with the promoters of the company that the shareholding in the entire company will be transferred to me. With the object, of course, of, my lord, transferring
All the shares.
All the shares, because the entire thing is held by the bungers or their nominees.
All right.
So the bungers will transfer the shares of the company to me with the concerted object, of course, of transferring the principal asset of the company, which is this 10B Balihai, to me, in lieu of the consideration payable to me for the various services I've rendered to the bunger group of companies. Now, my lord, the veracity of this case will be tested in the trial.
Yes, that
in
is
my
not
suit.
so much German now. At this
No, it is not. But what I'm trying to tell your lordship is only this. The character of my occupation, whether I am a permissive licensee, whether I am a tenant, whether I am the intended transferee, this is sub judice in both the suits. In title suit 116.
Do they run a case of your tenancy at all?
No, they do not. Now, let me show your lordship the averments in the plaint and the petition.
What about your wife and son? What is their stand on them?
My lord, I say that I ought to have been, my lord, I was ready and willing to pay rent, but no rent has ever been demanded of me.
Plaint case is what? That you are in the capacity of?
They say I am trespasser.
Trespasser,
Yes.
all of you.
Yes.
So no license, tenancy has been claimed with
Not
them?
at all, man. Not at all.
Good.
So there is a conspicuous absence of any averment also that any of the defendants are tenants in the property.
All right.
So in these circumstances, my lord, the question that will fall for your lordship's kind consideration is whether, my lord, powers under Order 39 Rule 10 could be invoked to, my lord, direct payment of occupation charge. Lordship.
Eviction has also been sought in the suit itself.
Yes. In this suit
Eviction is sought. You may have a point in arguing that, yes, in all those cases, Aftaram and all, as a condition under Order 41 Rule 5, it has been imposed. Occupation charge, not independently on a standalone footing.
Yes, my lord.
And that too, after a decree of eviction is passed.
Lordship.
And you are suffering a degree, the premise being that you are suffering a degree of eviction, but you are still continuing in possession, depriving them of the current occupation charge.
Extremely grateful. And my lord, lordship will say, when I take your lordship through the petition that is filed in the trial court in which the order impugned has been passed, they have in fact said, give me mean profits. Mean profits is only post-decretal, as the lordship has put.
And they have asked for mean profits.
They have asked for mean profits. Now, my lord, to my very humble understanding, the distinction between occupation charge and mean profits is one is pre-decretal, one is post-decretal. And also, my lord, occupation charge is at the rate of rent last paid. Mean profits is, my lord, at the market rate to be ascertained either in
occupation charge is interpreted in those judgments.
My lord, occupation charge in this case, I have never paid any rent to the plaintiff. So how can, now the trial court has directed me to pay occupation charge to the plaintiff at the rate of license fee last paid by the wife and son to this Manish Dokani. That is a clear error, my lord. There is no tenancy relationship, even a word, with regard between the plaintiff and the defendants, any of the defendants. Okay. None of them have ever tendered any rent to the plaintiff. So this is the case, my lord. Now may I take your lordship through the order impugned?
Yes.
Kindly see, my lord, the memo of appeal, page 20. Order is dated 26 June 2026.
If you come to page 7, page 5 of that, Mr. Shah.
Yes, my lord.
The firstly, that is the last half of the page. In course of hearing, learned advocate for the defendants debated. So, firstly, that defendants do not admit the plaintiff as owner of the suit property. You do admit the plaintiff as
yes, I do, my lord.
Ownership,
yes.
Landlordship, you are disputing.
Lordship. They are owners.
Also not claiming land.
Yes, I'm only saying that I was the intended transfer. It was really purchased ultimately to
an actionable claim at best, or chosen action, whatever way.
Lordship. But yes, they are the title holders of the property. There's no dispute about that.
Unless you admit that, then there's a case in the specific purpose.
Yes, my lord. Anyway. So, my lord, my submissions are recorded from page 4 internal of
your prior suit is still pending.
Prior suit is still pending.
Before a different court.
Same court. Before the same court. Lordship will kindly see, my lord, at internal page 6.
Yes.
My lord, the judgment.
Yes, settled legal.
Second paragraph, Green Band Apartments has been discussed. So I had relied on this judgment where, my lord, the honorable single judge of this court has had the opportunity to consider the effect of Order 39 Rule 10. My lord, previously there were some decisions, KK Shah and others, where it said that there is actually no power under the CPC to direct, my lord, occupation charges to be paid before decree. But in Green Band Apartments, my lord, Order 39 Rule 10 has been, my lord, considered. Honorable single judge held that, yes, when there is admission of landlord-tenancy relationship, you cannot be allowed to occupy free of charge. You have to deposit occupation charges at the rate of rent last paid. So this has been noted, my lord. Then, my lord, the holding starts from page 6 onwards. Lordship will kindly see The fourth paragraph at page 6 of the order impugned again, my lord, green band has been considered. May I just place this portion?
Yes.
The decision of the Honorable High Court in the matter of Green Band Apartments versus Mint Matrix others reported in 2021 to ICC 269 is based upon the consideration of admitted position of facts that the opposite parties were tenants in respect of the property in question, having contentions that they were entitled to reside in the property upon payment of rent, and tenancy was terminated by a notice by invoking the sooner termination clause. In the aforementioned decision, the Honorable Calcutta High Court referred to the decision of the Delhi High Court in the matter of Sanjay Gupta versus Kotahi Industry Expositions Limited, wherein it was held that civil court in exercise of powers under Order 39 Rule 10 of the Code of Civil Procedure could pass orders for payment of the last paid rent till the suit is finally decided, irrespective of whether the status of the opposite parties during the period in question was that of tenant or trespasser after determination of lease, either on account of rent or on account of damages, and it was ultimately found that the tenancy of the suit premises subsisted throughout till the vacation of the property. The amount would be adjusted towards rent, and if it was found that the lease was validly terminated, it would be adjusted towards partial damages. Thus, in view of the above referred decisions, a well-settled legal proposition can be said to have been evolved and emerged as judicial precedent with the passage of time as to effect that in the exercise of power under Order 39 Rule 10 of the CPC, read with Section 151 of the CPC, occupation charges can be fixed to be payable in terms of mutually agreed rate of last paid rent by the trial court during the pendency of the suit for eviction of tenant or lessee where the relationship of landlord-tenant is not disputed.
Order 39 Rule 10, whether this can be done, we have some doubt, but Mr. Bose will be clarifying.
There is a judgment, my lord. Single judge's judgment is there, my lord.
Perhaps, my lord, of course, this is with a lot of respect to my learned friend, but all these details are not required. Under Order 39, Rule 10, it is only an admitted amount, my lord.
And the paradigm is somewhat different from this sort of a situation.
Absolutely. And cut off all its trimmings, my lord.
Yes.
There is a property. I'm admittedly the owner of the property, 50% bought in court sale, 50%, my lord, from the other lady. I have leasehold right and interest till 2084. It is an admitted fact that he was a tenant so far as this property was concerned. Not he.
2 and 3.
Defendant number 4. Yes. And my lord, they were paying rent to him at the rate of 50,000 rupees per month. Today, my lord, that situation does not exist. My learned friend cannot expect to occupy a property 3,500 square feet on Baliganj Park Road together with a car parking space free of any charge.
Suppose, yes, we are at the risk of interrupting you. Sorry for that. But Mr. Bose, under which provision can we direct? Because you have asked for mean profits in the suit as well. This will be prejudging that issue.
But mean profits, my learned friend is absolutely right. It comes only after decree, which is calculated by a special officer.
Yes, sir. And there is the provision to.
My lord, my application was under 151. I wanted occupation charges at the last paid rent.
Mr.
My lord,
Bose,
lack
sorry.
Another figure. The learned judge said you place the last, you pay
No, but
the
there
last
is no
paid
provision under which you can claim that during pendency of the suit. Yes, we can understand under Order 41 Rule 5. Those Attaram line of cases say Order 41 Rule 5. The premises, as we told Mr. Shah, he's suffering an eviction decree, and then you have asked for eviction, not yet decreed.
My asking, putting this question to myself. Does it therefore mean that till a decree is passed, he will go on enjoying that property, my lord, without paying any occupation charges, and I will pay the maintenance charges, I will pay all other upkeep charges and everything? Well, the judgment, if I may say so with the deepest of respect, is one of the very few judgments which are so long, and if I may say so with some amount of audacity, well, extremely well considered. And my lord will see the last part of the judgment. It is very clear. Whether the principle which was laid down, in the case we relied on this, 2012, Volume 5, Supreme Court Cases 370. It is referred to.
So Shah will definitely admit the appeal. Don't worry on that. But let us hear Mr. Bose also, because if you can decide the matter. Right?
Yeah, only one thing I'd like to clarify, my lord.
Yes.
With regard to the directions in the order impugned for, my lord, payment to the plaintiff of the mean profit charges, I beg your pardon, of the maintenance charges, he has paid to the association since 2019, my lord. There is no appeal. I will pay that. And with regard to the further direction for me to pay, my lord, maintenance charges to the association directly henceforth, again, I will pay that.
Oh.
Because I say I am the intended transferee, I am in occupation, I am supposed to pay the maintenance charges. So my,
And what happens to me?
What high and dry, we said.
my lord, since
Till the decree-
2013 to
till you obtain a
2019,
decree.
The rains come down a little at least.
After the decree, you'll get all rain, monsoon, everything.
After the decree, my lord.
Before
it is
decree,
giving- it
we
is giving
there's
a
some doubt.
fillip, my lord, it is giving a fillip to the to my learned friend's client, my lord, to enjoy a property. I will pay for maintenance. I will pay for this. I will.
No,
pay for that.
maintenance has been taken care of. Shah is very sharp on that.
yes,
Point is, my lord, in these multi-storied buildings, maintenance is not the only expense.
all expenses I will pay. Electricity, water, maintenance, whatever is required, I will pay. I have made that avowment in my appeal.
The occupation. What about the occupation? You will occupy.
Occupation,
3,000.
Mr.
2013 to 2019, my lord, they
You
never
get
even
main profits,
demanded
you'll get
from me.
occupation for the entire period, not only for.
No, my lord, let it. I'm not. If
There's
he
no
doesn't
problem.
want
We
to
don't
pay
find
it
any
to me,
provision to.
If he doesn't want to pay it to me, let him deposit it.
My lord, they have not asked for the title deeds back from 2013 to 2019. They have not asked for, my lord, rent to be paid from 2013 to 2019.
I realize, my lord, there are certain constraints on both of us. We will have to go through the paces of both our suits. And my learned friend will correct me. His suit, I think, is lying stayed by some order, which I'm not aware of. So
That's
he is
perhaps
not
not
taking
correct,
any
my lord.
steps, my lord, so far as his suit is concerned.
He's also not aware of.
No, my lord, interrogatories were prayed for. Interrogatories not allowed. I have come up in civil division from that. That is the status of my suit as far as I am aware.
And so far as, my lord, occupation charges something. No, no, just let me read paragraph.
Please place it here. This judgment. Mr. Shah, take your seat. We'll come back to you. Yes. So you did well in clarifying that maintenance part, because that would be a problem otherwise.
But just the principle, 89. But I'm aware of Atmaram and all, but that is all after the decree. Market rate has to be paid.
On the premise that he's already has suffered an eviction and his position is illegal.
And it's continuing
In this case, it would be premature to say so.
Well, the court can also direct.
Sir, both, sorry, which paragraph you're?
Paragraph 89.
Which judgment?
2012 5 SCC 370.
The court can also direct payment of a particular amount and for a differential, direct furnishing of security by the person who wishes to continue in possession. If such amount as may be fixed by the court is not paid as security, the court may remove the person and appoint a receiver of the property or strike out the claim or defense. This is a very important exercise for balancing equities. Courts must carry out this exercise with extreme care and caution while keeping pragmatic realities in mind and making a proper order of granting mean profits. This is the requirement of equity and justice. So today, my lord sees the portion of the judgment where this is referred to.
Mr. Bose, before we move away from this judgment, please come to the previous paragraph also, the context of this judgment. That is very important. There an injunction was sought to secure that this was passed.
The court, my lord, may I just read it?
Please do, Mr. Bose. 88,
The court, while granting injunction, should broadly take into consideration the prevailing market rentals in the locality for similar premises. Based on that, the court should fix ad hoc amount which the person continuing in possession must pay, and on such payment the plaintiff may withdraw after furnishing an undertaking and also making it clear that should the court pass any order for reimbursement, it will be a charge upon the property. So let him keep it there. If I want
So
to.
while granting injunction, they have not asked for an injunction here. This is while granting injunction. So always this case for granting injunction in those line of cases, Attalam line, as a condition of stay. So if he wants anything, he has to secure. Like injunction is often secured.
Actually, my lord, I respectfully submit, will take a pragmatic view. If he wants something, he will want to enjoy a free property. My lord, if somebody gives me a property 3,500 square feet on Baliganj Park Road, my lord, I will also want to.
No, he's running a case in his specific offense suit also.
Yes, he does.
So that cannot be overlooked altogether.
But the fact remains, today the defendant numbers 1 and 2 are enjoying the property without paying any occupation charges. There are two rates mentioned here. Earlier, he says at one stage it was 5,000, and in the plaint we have specifically averred that it was 50,000.
They deny any juror relationship with you. Why should they pay you?
I don't think they are denying the juror relationship because they say that this property was bought for their benefit.
Yes.
It is when we have bought the property and there is no discussion or opposition to that, my lord. Why should I not, if I may put it in the form
If you
of question?
bought the property for their benefit, then why are you entitled to anything from them?
That is what, if I have bought the property for their benefit, it will be decided at the time of the suit, then I will not get the money. But he cannot enjoy the property, my lord, without paying any money. Very often it happens, my lord, we deposit monies with registrar and we make an application saying we want to withdraw the money, and your lordships always say, furnish a bank guarantee. So today, if he's depositing, my lord, occupation charges month by month with the association or with such body that he may seem fit and proper, if I want that money, I will not, like him, enjoy it free. I will pay something or put in a bank guarantee and then go. But my lord, encouraging him to enjoy occupation of a property without paying anything and just offering, my lord, maintenance charges is, in my very respectful submission, my lord, not permissible. And in any event, I say, my lord, this is not an appealable order. My lord will kindly see the provisions of Order 39, Rule 10 with me once.
Yes, we saw it, yes. But apparently the court has invoked that provision.
I do not see it there.
Let us see.
I may be wrong. I may be wrong.
Page 6 of the order impugned, I showed your lordship, my lord.
Just
Green band has been relied on, which in turn relied on 3910, lordship.
may have been, but today your lordship sitting in the division bench, my lord, will have to consider whether it is permissible when ordered.
Mr. Bose, we'll ask you the law on that, Mr. Bose. What is your take on that? Suppose an order is passed erroneously or without jurisdiction under a particular provision. By invoking, we pass an order invoking a particular provision of law. Even if that's excess of jurisdiction or that provision would not be maintainable, if I pass that order by invoking that provision, wouldn't the remedy be determined by what lies against that provision? Suppose if I pass an order erroneously under 39(1) and 2, or say under section 9 of the Arbitration and Conciliation Act, erroneously, that is not maintainable. But I invoke that provision and pass that order. Wouldn't an appeal be maintainable even on the ground of lack of jurisdiction against that?
With respect,
Yes. Why do you say that?
Reason, just because, my lord, the court has passed a wrong order, that does not mean that wrong order should be sustained in subsequent stages.
No. We'll set aside the order, even if you set aside by saying that it did not have jurisdiction. But since the exercise was under that, now order 43, the relevant provision says an order passed under this provision. So if the order is passed under that provision is specifically invoked erroneously, then what would be the remedy?
Today, perhaps all these details which my learned friend submitted before your lordship is not required. Here is an order where my learned friend actually says that was passed under Order 39, Rule 10. Kindly take Order 39, Rule 10 with me.
3910 is not applicable. Admitted, it has to be admitted. Subject matter of suit is money.
So
neither of the, no yardstick is applicable.
How does the appeal lie? He says that the learned judge depended on Order 39,
Yes.
Rule 10.
Yes.
So how does an appeal lie? Today, my lord, if he goes and files a revision application or he takes such other recourse to law as might be open to him, but that does not mean that when he's saying something which is not permissible in law, your lordships will be pleased to ratify that stand just because somebody else has said so.
But if I may respond to lordship's query.
No, later on. Don't be overzealous. Let me suppose complete. Yes.
My lord, when the basic premise of preferring the appeal is something which is not maintainable and not permitted under Order 43, why should your lordship, I ask this question to myself, enter into the other arena, my lord, at all? In fact, for that matter, if I ask your lordship to sustain that order for 50,000, that should also not be done. Simply speaking and simpliciter, my lord, his appeal should be dismissed. Because today, if my lord says, instead of 50,000, you pay 25,000. Instead of depositing 50,000 with me, as has been directed, you deposit with the owners association. That power or jurisdiction will be achieved by your lordship only if my lord entertains the appeal. The order can be passed only in an appeal.
Yes,
When
definitely.
the appeal itself is not maintainable.
No, if you say the appeal is not maintainable, then he can take whatever recourse.
He might take, and he might succeed there.
Yes.
But today, my lord, going into these details, here is I'm making it even more simplistic. Here is a property of 3,700 square feet on Baliganj Park Road. He is enjoying that property. My lord, once upon a time, the pro forma respondent was a tenant. he would be paying the respondent numbers 1 and 2 would be paying 50,000 to him. So that is where the learned judge got the figure. That figure is also
That can be a valid ballpark figure for this purpose.
Yes.
Maybe.
So, my lord, today if the appeal itself is not maintainable,
Yes.
perhaps your lordship should not.
No, then we
interfere.
cannot go into these questions. We cannot adjudicate on anything. We have to decide that first.
Yes, that is the only point which I'm
So
making.
you say that Order 39 Rule 10 could not be invoked and was not invoked by the trial court.
Therefore, the
it was
question
under
of referring
151. If that be so, then if you hold that, then no appeal lies.
Absolutely.
So let us hear Mr. Shah on that appeal first. Mr. Shah, please, before proceeding further, we'll hear you on other things. Apart from the merits, page 16 of the impugned order, if you please come.
Yes.
At the bottom is the pagination. Now, whatever Green Park is on 3910, whatever else.
Yes.
Let us come to page 16.
Yes, ma'am.
No, please come to the third paragraph. Finally, question remains as to what reliefs. Then the court proceeds on the premise what reliefs does a plaintiff entitled, or the language forget, what reliefs are the plaintiffs entitled to get at this stage out of the reliefs as sought for, as to whether the plaintiff is entitled. Complicated sentence was as sought for in application filed under section 151 of CPC.
Yes, my lord.
And then ultimately also court proceeds without referring to Order 39 Rule 10 once. Finally, orders filed by the plaintiff under section 151 is thus considered and allowed. So it's 151 all through by the court. Only in Green Park, which was cited by one of the parties, either by you or by them, Order 39 Rule 10 was resorted to.
Yes.
Agreed.
Yes, my
but
lord.
that was only one of the citations. That's a part of the ratio of this judgment. But the court invokes 151.
My lord, with respect, if your lordship will come back to paragraph 6, yes, application nomenclature.
Application nomenclature, we are not going by that.
Lordship.
Court also invoked because court treated it to be an application under section 1 and court specifically says, finally question remains as to what reliefs plaintiff are entitled to in application filed under section 151.
In application filed under 151,
No,
not under section
Court
151.
never
Kindly
says
see
that
this
I am
distinction.
invoking 3910. Where
It
do you
does
get
not say, it
3910?
does not, it's invoking 151 also, my lord. In the application under
If
151,
the application is under 151, court says that whether they are entitled to this relief in that application under 151,
yes,
without ever referring to 3910, you are discovering 3910, you are reading 3910 into this.
No.
And in the same breath, you are arguing that 3910 is not applicable here,
May.
which we agree with.
May I
This
try
is
to
not
respond?
a 3910 scenario. Application under 151, court deals with it as application under that provision and allows it under that provision.
I appreciate what is following from my lord. Let me
Yes.
try to respond to the question.
Take out to 227.
No, my lord,
Whatever. We should not add.
I have two responses. Let me try, my lord, to satisfy your lordship. The first question is, my lord, if there is an erroneous application of the provision, appealability will be.
There is no application of 3910 at all.
Let me place the decision once more and show your lordship on how many instances, my lord, 3910 has been referred to. Lordship has seen paragraph 6 of the page 6 of the judgment.
Page
Kindly take-
6 is the reference to a judgment which invoked 3910.
Kindly see page 6 once again, my lord. May I invite your lordship
Yes,
kindly
yes,
see
yes.
once more to page 6.
Yes.
It's relevant. Kindly see, my lord, the heading in the middle of the page, page 6.
Settled legal
Settled legal position. So, my lord, this is not a submission of the parties that is being recorded. The learned trial court arrives at a finding of what is the applicable law on consideration of the authorities cited. And he arrives at, my lord, a second settled legal position considering green band. And, my lord, carries on at page 7, second paragraph. Thus, in view of the above referred decision and well settled legal.
You forget that he also takes into consideration under settled legal person order 41 rule 5. So then you will say this is under order 41 rule 5.
My lord,
Attaram, he says.
Yes.
Attaram 41.5. So all these decisions, settled legal position, he does not refer to the provision. He refers to the courts granting this occupation charge. Under order 41 rule 5 in certain cases, 3910 in certain cases.
Henceforth, also, my lord, he is referred to order 39.
Thus, in view of, you read the second paragraph, page 7, as you are doing, Shah. Thus, in view of, before decision.
Yes. কোথায় ছিল? Paragraph 6. Kindly allow me one moment, my lord. Settled legal position. The next. Thus, in view of the above referred decisions, and well settled legal proposition can be said to have evolved as emergent judicial precedents.
Yes.
With the
Here,
passage of time as to
your
the effect then.
provision.
In excess of powers under Order 39 Rule 10, read with Section 151 CPC, occupation
Yes,
charge.
this
can
is
be
in your
fixed
favor.
To be
In your,
payable into-
this proposition.
Yes, my lord. So this is he's arriving.
He says the legal settled legal position is under 3910, read with.
Lordship. That is why I'm saying, my lord. He has invoked all the provisions. He's considered all the provisions. And he has ultimately said that, my lord, this is not the relief that you are entitled to under Section 151 of the CPC. The reliefs that you're entitled to in the application preferred under 151 are these. So,
He also says it also emerges that occupation charges can be fixed at the post-degree stage under 41.5.
So, in this circumstance, my lord, my humble submission is this. Wrong invocation of a power is an error within jurisdiction, not an error of jurisdiction.
It doesn't invoke any power at all. I mean, the 39.
In that case, my lord, appealability, it is either appealable or revisable.
By default, then it's inherent power, then 151.
If that be the case also, my lord, I have judgments to show that in such a case, my lord, I will be put to undue prejudice if I am required to, my lord, withdraw this and file a 151 application. Lordship can simply say, convert it. My
Mr.
appeal
Shah,
within
if
time.
it was a revisional application, we could have converted it easily to appeal.
Yes.
Because the revisional application, you have to state the facts also. In appeal, only memo has to be filed.
My lord, stay petition is there. All the facts
Stay
are stated.
petition, that
Entire
will be
trial court
complicated.
recorded before your
It
lordship.
will be much more easier for you believe us if we permit you to file a 227 application, and 227 will not be time barred in any event.
The lordship will kindly see, my lord, here I have a Supreme Court judgment which says, my lord, both revision to appeal and vice versa. Appeal to revision can be done if the appeal is within time.
We are at the practical level, Mr. Shah.
I appreciate, my lord.
We can permit you, because then we'll have to say that the pleadings in the stay application will be treated as the pleadings in the 227 application, and the grounds in the memo, these are scattered. Grounds are
I
in the
can
memo.
withdraw and file again, but my lord, kindly see if he has discussed all the provisions and ultimately said, you have paid for these reliefs, this is what I am giving you. He has
But
not
then
said.
decision with reasons. He repeatedly refers to preferring the instant application of 151.
Because that is the nomenclature, and lordship have
Confusion of
repeatedly
law.
held, my lord, nomenclature will not govern the power exercised.
Exactly. Even if he gives the nomenclature of 3910, then Mr. Bose is right. Even if he gives the nomenclature of Order 39 Rule 10,
yes,
he does not have power under 3910. Both of you are saying that.
So, my
and
lord,
rightly so.
Error within jurisdiction, not error of jurisdiction. Appealability will be determined
Does
on the
not
basis of
invoke Order 39 Rule 10 in terms, Mr. Shah.
My lord, if I were to file a revision, the alternate argument would come from the other side, that this is appealable and not.
After our order, after we record their argument on this, they cannot.
If your lordship is, my lord, inclined to send me back to revision, I will have to go, my lord. But I think in this circumspect, my lord, in the manner in which the order is worded, where they have this, my lord, considered all the provisions available.
Yes, exactly.
At least arguable, my lord, that order and power under Order 39 Rule 10 is in fact, my lord, invoked. And my lord, in green band.
Very arguable. You have argued, you are deciding.
Very good.
A threshold issue is raised at the outset by learned senior counsel appealing for the plaintiff stroke respondent number 1 as to the maintainability of the appeal. Fusab, learned senior counsel points out that although Order 39 Rule 10 of the court has been referred to in one of the judgments cited before the learned trial judge, comma, which was taken note of, comma, ultimately the power invoked by the learned trial judge in passing the impugned order was section 151 of the Code of Civil Procedure, comma, under which the application from which the present order arises was also captioned. Full stop, next para, as such, comma, since an order under section 151 of the code is not appealable, comma, the present appeal is not maintainable in the eye of law. Full stop, next para, learned counsel for the appellant, comma, in reply to the maintainability objection, comma, places reliance on the reference to the judgment of green band apartment in the impugned order, comma, where learned single judge of this court had invoked the power under Order 39 Rule 10 of the code to pass directions as to payment of occupation charges, comma, although distinguishing the ratio laid down therein on other grounds. For the next para, learned counsel also takes the court through the findings of the learned trial judge at page 7 of the impugned order, where it was recorded that in view of the therein above referred decisions, comma, a well-settled legal proposition can be said to have been evolved and emerged as judicial precedents with the passage of time as to the effect that in exercise of power, italic say, under Order 39 Rule 10 of CPC, read with section 151 of CPC, italic stop, occupation charges can be fixed to be payable in terms of mutually agreed rate of last paid rent. For the next para, hence, comma, learned counsel for the appellants argues that the learned trial judge invoked the jurisdiction under Order 39 Rule 10 of the court, comma, albeit erroneously, comma, which determines the remedy available against the impugned order. Full stop. Next para. Since an order passed under Order 39 Rule 10 of the Code is applicable under Order 43 of the Code, comma, this the present appeal is maintainable. Full stop. Next para. On a careful perusal of the impugned order, comma, we find that although the learned trial judge referred to Order 39 Rule 10, comma, read with Section 151 of the Code, apparently to invest the court with the powers to direct occupation charges even during pendency of an eviction suit, comma, the power ultimately invoked by the court was specifically not mentioned to be Order 39 Rule 10. Full stop. Next para. Although the judgment of Green Band Supra has been referred to in the context of the ratio of the impugned order, comma, where Order 39 Rule 10 was invoked by the learned single judge of this court under similar provisions, comma, in subsequent portions of the impugned order, comma, the learned trial judge also observed that finally the question remains as to what reliefs the plaintiff is entitled to get at that stage, or as to whether the plaintiff is entitled to get all the reliefs as sought for in the application filed under Section 151 of the Code of Civil Procedure. Full stop. Next para. In the operative portion of the order as well, comma, the learned trial judge categorically refers to the application being filed under Section 151 of the Code, comma, thus belying the perception that the learned trial judge invoked powers under Order 39 Rule 10 of the Code. Full stop. Even otherwise, comma, as submitted by both parties, comma, Rule 10 of Order 39 of the Code does not apply to the present case, comma, since under the said provision, comma, only where the subject matter of a suit is money or some other thing capable of delivery, and any party thereto admits to italics, that he holds such money or such thing as a trustee to italics, for another party, comma, or that it belongs or is due to another party, comma, the court may order such amount to be deposited in court. Full stop. Next para. In the present case, comma, during pendency of a suit for eviction and mean profits, comma, the plaintiff stroke opposite party respondent number 1 sought a direction on the defendant stroke appellants to pay occupation charges in respect of the suit property, comma, which takes the prayer entirely out of the paradigm of Order 39 Rule 10 of the Code. Push up. Next para. Thus, comma, it is under Section 151 of the Code and not under Order 39 Rule 10 thereof that the impugned order was passed by the learned trial judge. Full stop. Next para. Hence, comma, appeal being a creature of statute and no appeal being provided for statutorily under an order passed under section against an order passed under Section 151 of the Code, comma, the present appeal is not maintainable on such count. Pushed up. Although both parties have advanced arguments on the merits of the case, comma, in view of the threshold objection having been entertained, comma, we abstain from commenting on the merits of the case, comma, since it will tantamount to an act beyond the jurisdiction of this court and prejudging the issues. Full stop. Accordingly, FMAT 271 of 2026 is dismissed as not maintainable, with liberty to the appellant to prefer an appropriate to take appropriate legal recourse against the impugned order. Full stop. Next para. Liberty is granted to the learned advocate on record for the appellant to take back the certified copy of the impugned order upon furnishing a photocopy thereof for the records. Full stop. Consequentially, Can 1 of 2026 is also dismissed. Full stop. It is made clear that this court has not entered into the merits of the matter at all. Full stop. No rest to question.
With some hesitation, I'm instructed, my lord, may I request for a return of the court fee?
How much court fee did you pay?
50,000 rupees court fee was paid as a
Misappeal is only, you have to pay only the
No, your lordship,
fixed court fee. It's a fixed court fee.
100 rupees court fee. The stamp reporter, my lord, raised an objection. And 50,000 rupees court fee has been paid in this case, my lord. It's been paid already. Yes, my lord. At the outset, my lord, I asked.
Stamp reporter asked for 50,000.
That's a suit value is 5
The suit value is 5 crores, my lord. That is right.
So what? No. No, you have not paid so much. What are you saying?
They don't give me incorrect
No,
information.
no.
We paid Chana must also give it.
No, it is, then it has to be attached to the affixed to the memo. No.
দেখুন চালানটা তো
আছে আলাদা?
না চালান দিয়া
আলাদা চালান দিয়ে 50,000 টাকা চেয়েছি। Yes, we'll direct that to be refunded.
Please, my lord, grateful.
We also permit the appellant to withdraw the excess court fees of rupees 50,000 which have been deposited. This 50,000 is over and above that 100 rupees.
Yes.
50,000 which has been erroneously deposited in connection with the appeal, full stop, as and when so approached by the appellant and or the learned advocate record for the appellant, comma, the said court fee shall be refunded to the appellant.
I'm grateful.
I feel like putting a spanner in the wheels and saying, if otherwise refundable.
No, it's very much refunded. 50,000 for misappeal. Suppose the stamp reporter is, wreaking havoc in other cases also. We are
Grateful, man.
We have to have a talk with him. 50,000. Misappeal, you have never heard of this. Misappeal?
But please,
You have also paid 50,000?
yes. Lordship, as per Lordship direction, we have already first appeal, Lordship, we have already corrected.
You have corrected whatever.
Yes.
Yes,
Whatever
what is the matter? That is the misappeal. কোনটা লাস্ট মিসঅ্যাপিল না এফএটি?
এফএমএটি করা হয়েছে।
এফএমএটি হয়েছে?
স্যারের
ওহো আচ্ছা।
হ্যাঁ, now it has been converted to FMA.
What are the court fees you have paid?
250.
250?
200.
Within our pockets. Yes. Yes, what is that?
I think probably Mr. Rohit Das is on virtual.
Who is appearing virtual?
My lord, I'm praying for your lordship's leave to appear
yes,
online.
Mr. Das is there, yes. Yes, Mr. Das. Yes, what is that?
My lord, this is there was a decree in the year 1982 against one AC Vasu, the tenant.
There is a leave application, Lord, that leave application.
I'll tell you, my lord, all the applications, my lord, they are on the same facts. So just, my lord, 1 minute to just recapitulate the facts.
97 to 101, rule 97 to 101, not 21.
Yes.
Yes.
So, my lord, here what happened is, my lord, in 1982, there was a decree against a tenant by the name of AC Vasu. My lord, after that, this execution case was instituted in the year 1983. Now, my lord, our cases, my lord, after that, this AC Vasu, there was a fresh tenancy. He started again paying rent. Till 97 here, the rent has been paid. After that, the rent was not accepted. The rent was being deposited in the rent controller. That's on management. I'm not there right now. So what happened, my lord, after this? Nothing happened in the execution. This gentleman by the name of AC Vasu, he executed a general power of attorney in favor of the appellant. It is a registered general power of attorney in the year 25th March 1996 because he was getting old, my lord. He wanted this gentleman to look after the current appellant, to look after the premises on his behalf. Also, my lord, in 1997, my lord, there was a registered deed of adoption. He adopted him as his son. And there was a, my lord, will, which was executed, again, leaving everything to him, to the appellant. Now, my lord, after that, he retired and he went away to Kerala. Now, my lord, from 2001, the appellant, along with his wife, is running a restaurant by the name of Shere Punjab on this, my lord, property in Shakespeare Sharoni. They are running this restaurant. Now, my lord, in 1997, this application under Order 21, Rule 97 is filed by the...
Could you take a matter against Shere Punjab? You're one of the...
that Shere Punjab, not otherwise
you're one of the sponsors of Shere Punjab.
No, blood, it is not that Shere Punjab that we blood patronize. Blood.
This is a different one. Yes, right.
So, my lord, In 97, this miscase is, my lord, lodged for order of police help under order 97 rule. Interestingly, my lord, it is against AC Vasu himself, the judgment debtor, not against me, the appellant, who is in actual physical possession of the property.
No,
right?
that previous execution case was revived.
My lord, that execution case, my lord, is
number remains the same.
It remains same. We do not know what happened in between, because, my lord, we came into the picture later. We
So
had
now
no
order
notice
21
of this execution case.
Now police help application filed
Fine.
against AC.
That also, my lord, we had no knowledge. What they did, my lord, they published notice in the paper for substituted service on AC Vasu. That is when we come to know of the pendency of this, my lord, miscase against AC Vasu in respect of the same premises. So, my lord, as the power of attorney holder, the appellant files his wakalatnama before the court. My lord, now this wakalatnama is, my lord, filed sometime in the year 2024. After that, my lord, there is, my lord, all connected properties. There was some dispute in the year 2025. My lord, the appellant got arrested in connection with another adjoining property. There was a dispute, my lord. They filed a criminal case. He got arrested. At that time, my lord, suddenly this order 21 rule 97 is heard, and an order is passed saying that had the Mr. AC Vasu must have died by now. He would have been 104. Therefore, this wakalatnama is to be rejected. They had filed an application saying this is not a valid wakalatnama. Power of attorney cannot be valid. Power of attorney cannot be valid because, my lord, the person is dead. It is their application in this. There is no substitution of the dead, my lord, person in the miscase. Simple application is this wakalatnama is not valid because he would have been 104 years old. He would be dead. So, my lord, while I am behind bars, this order is passed, which says that this wakalatnama is not valid. Now, my lord, I come up before this honorable court in civil revision against that order, because that is not, my lord, the final order under order 21 rule 97, my lord. That stage I could not file an appeal.
What was the exact order? What was the order?
My lord, may I place the order?
Just tell us, not the exact order. I mean,
yes,
what
my
was directed?
17 January 2026, this order was passed saying that the advocate who was then representing the appellant, he came and said that I have no instructions. Obviously, my client was, my lord, behind bars at that time. And he said, I have not seen the original AC Vasu. I have only relied on the power of attorney. Court said this power of attorney cannot be valid now because AC Vasu would have been 104 years old.
Acha, court did what exactly?
Court cancelled the wakalatnama. They said I have no right to represent.
Cancelled the wakalatnama. Court cancelled the wakalatnama. Very. So you preferred 227 ultimately.
Cancel the wakalatnama. Rejected the wakalatnama. Rejected
that is
the
what
wakalatnama
exactly.
And said that is the order.
Very well. Then what did you do? Challenge.
So, my lord, I came up in civil revision.
What happened?
The civil revisional application was being heard. My case was that this 1996 is the date of the general power of attorney. 97 there are registered documents. 30 years, my lord. Then under the Evidence Act, presumption of life within 30 years. In case of death, my lord, 107, 108. Now it has become 110, 111 of the Bharatiya Sakshya Adhiniyam. So my case was based on that. This presumption could not have been made. It's a question of fact whether a person is alive or dead. And, my lord, in this, they also said we will not take some steps in the execution till this is resolved. So that matter was going on. Finally, my lord, the matter was heard. And, my lord, on that day, after the arguments, the court was pleased to dictate an order that order is set aside. The impugned order, which was impugned before the civil revisional application, that was set aside. But, my lord, after that, subsequently, my learned senior friend, he mentioned the matter in the second half. And he informed the court that already after that, the order has been passed and the matter has been disposed of. So now, my lord, the civil revisional...
what has been disposed of?
My lord, the order 21 rule 97 petition itself has been disposed of. So all previous orders now merge with that.
They have got possession. They have got possession.
They did not get possession, but the final order for police help was granted at that stage.
All right.
At that stage, my lord, that's still not granted.
So revision becomes infructuous.
So this is all recorded that the order was passed saying that the matter should be remanded back. Order 21 rule 97. First, that issue is to be heard whether that person is alive or dead. This is
that
all
order
recorded.
could not have been recorded if it's ultimately dismissed as infructuous.
It is dismissed because it was dictated in court. That observation was recorded, and my lord is not bound by. No one is bound by that observation.
Yes, exactly. We cannot go by.
Now, anyway, my lord, what happens after that? We find out that these orders have been passed. We immediately on same day apply for certified copy of those orders, and my lord, at the earliest we file this appeal before this honorable court. We, my lord, have, because we are a third party. Today, my right to represent him is not being recognized. So I have to take leave to appeal as a third party appellant. Second, my lord.
Thus, we don't find any locus standi on your part. I mean, if you are claiming through either your only claim was through him as his power of attorney, that has been disbelieved, that has been cancelled. Even
No,
if
my
you
lord, that
proceed on the
cancellation-
premise, suppose that cancellation is doubtful, we agree to that. Then also you are claiming through that person only.
Yes, my lord. My lord, but my case on merits is there is a fresh tenancy. That has to be considered. That could not be considered because I was never allowed. Now, my lord, how the proceeding has been conducted, kindly see from those orders. First, he says this person is presumed to be dead. On the next day, that person's name is called out. That person doesn't turn up, so it has been made ex parte. Then, my lord, against assuming that this person is dead, therefore I don't have a right to represent him. Then, my lord, subsequent orders could not be passed against the dead person. They are all a nullity. Now, my lord, today I am neither being allowed to represent him, nor I am being substituted as his legal heir. Or if they do not accept me as legal heir, whoever is the legal heir has to
Mr.
be
Das, it's a
substituted.
catch-22 situation
Yes,
for
my
you.
lord, I am in a serious difficulty because of this.
Maybe catch 44.
Yes.
Because you understand why. Because
Yes,
if he is dead, then power of attorney is invalidated automatically. If he is alive,
well,
if
I
he is
have an
alive,
adoption deed in my
produce
favor.
him.
Then I'll step in as the legal heir, legal representative. But kindly consider, today I'm shut out. The judgments are, my lord, nobody represented.
The Roman Catholic.
But Roman Catholic cannot be
And the
adopted.
gentleman who adopts him is a Hindu. And he bases that on a adoption deed.
No, but Mr. Mukherjee, is there any bar to adopt any other?
But, being a foster father is a different thing and legal adoption is a different thing.
Yes, it has to be Hindu.
But as I understand, Lord, the adoption happens, Lord, in case of a secular, Lord, nature under the JJ Act. The
Yes,
Juvenile
this is not a
Justice.
JJ Act, yes.
And
You're
Lord,
confusing.
Hindu adoption and maintenance. So, Lord, if my learned friend places about the adoption, Lord, I can answer in a different
My lord, may I place two things?
Under
If my
the
adoption
Hindu
is
Adoption
doubtful, if my
Hindu
adoption,
Adoption Act, under the Hindu Adoption Act, you could not be
my
adopted.
lord,
Mr.
takes
Mukherjee
my
is right.
adoption as doubtful, my lord. Today, my lord, the definition of legal representative in the CPC is, my lord, much wider than mere, my lord, heirs. Today, my lord, I am in possession.
So wide as to
Claiming through him, I am not being recognized.
take within its fold third parties, entire strangers
Now,
to the.
now my lord, consider a situation that everything my learned senior friend is saying is true. I have no right to represent him. He is dead. My lord, then it is their affidavit before the civil divisional court that they have traced his relatives, his class 2 heirs. Now, then, my lord, they should have been today in execution of an order.
Before entering into that question, Mr. Das, what
ma'am.
is your client's locus standi?
My
How
lord,
can it
my
not be you?
locus standi is, today I say that I have a valid power of attorney. Whether he is dead or not is a matter of fact which ought to have been light of the provisions of the Evidence Act. That's a, my lord, factual inquiry ought to have been done. There is no presumption of death. Within 30 years, there is presumption of life. Presumption of death arises only after the fact is established.
Can you produce any proof of his I mean any current transaction done by him or that he's alive? Anything? We are not asking you to produce him personally, but can you do anything that has to accompany then or he has to swear an affidavit or something like that? We have to have a proof of his being alive today for your power of attorney to be valid. If your power of attorney is not there, Mr. Das, you may have some independent right, but not a leave to prefer an appeal against an order passed against Mr. AC Das. Mr. AC.
But my lord, I am the person who is aggrieved. I had gone up in civil division against that order where there should have been this. I can't produce a proof that he is alive. David saying they have done some inquiries in Kerala. They may also
agreed by
by that also is now merged.
You are agreed. Mr. Das, we cannot speak together. We cannot speak together because of the disruption in a video we are
there's a cross purpose speaking. We are asking you
I'm
that
sorry, my
whether
lord. My lord.
we are asking you whether you are in position, on the strength of your position, you are saying that you are affected. How are you affected at all?
Yes, my lord. My lord, I'll tell
On the
you.
basis of
My
your
first
position.
grievance is an order has been. My lord, I was not allowed to file a written objection even to their application that my power of attorney is invalid. It was disposed on the same day on the basis of a presumption of death. So that order has now merged with the final order. So I'm aggrieved by that order first, which I was already challenging. And only reason, my lord, that challenge finally came to light that it has been disposed of. My second challenge is assuming that I have no right as the power of attorney holder. In, my lord, by taking an order against a dead person, Order 21, Rule 97, they cannot dispose as a third party like me. They have done that. Taking that order. So today I am, my lord, when I filed this appeal, I had an apprehension of being dispossessed. Today I am dispossessed because that order, my lord, has been given effect to, and I am on the streets. Today an order is passed against a person which that same court presumes to be dead. And my lord, my learned junior will hand over a copy of a full bench judgment of this honorable court that an execution proceeding against a dead person is nullity. Once the person is dead, his legal heirs have to be substituted. Without substituting, no orders for even delivery of possession can be passed. This issue was considered by, my lord, the full bench.
Yes. Yes.
So, my lord, that is this is I am in catch 22 or catch 44 rather, as my lord put it. I agree. But in both situations, my lord, this kind of procedure cannot be, my lord, permitted to be taken by the executing court. On the one hand, they presume that the judgment debtor is dead and do not allow the attorney.
Is it evident from any of the papers that you were in possession?
My lord, I have filed, my lord, my CAN 4, my lord. All the documents that I have since 2001, I have filed, my lord. Trade license, everything. And my lord, my employees were found by the bailiff to be there in possession. That is why, my lord, that is their case, that they went there and they found us in occupation. My employees were there in the restaurant. Their names are recorded in the bailiff's order that they are in occupation, and that is why Order 21, Rule 97 was filed, my lord.
Very well.
And my lord, I can show previous documents where they have filed
of this
caveat
judgment?
charges. My lord,
Which paragraph
para
of
4
this
to para 12, this entire issue was considered. My lord, para 4 onwards, para 4 to 12. Well, we are concerned with a case where a decree is passed against a living person. Obviously, the decree may be executed against him during his lifetime. The difficulty arises when the judgment debtor dies before the decree is fully satisfied. How and against whom and under what conditions is further execution of the decree to proceed? On the death of the judgment debtor, the decree can no longer be executed against the dead man. He who was a person when he lived is no longer a person when he dies. The dead man owns no property. A temporal judge has no power over him. He leaves all his estate behind him. The moment he dies, what was formerly his estate vests in his legal representative. The decree holder who seeks to execute the decree after the death of the judgment debtor must execute it against some existing person. Order 21, Rule 11.2.1 requires him to name the person against whom.
Mr. Das, we have seen that
Yes.
proposition has been
So
held.
this is, my lord, 20, my lord, order number 27 is the order by which my right to represent Mr. A.C. Vasu was, my lord, cancelled. Without, my lord, I said that order itself is bad in law. That is not the way an inquiry is contemplated under the Evidence Act to find out whether a person is living or dead. If proof is required, my lord, absolutely, I have to give proof. They have to give proof. That fact has to be ascertained. Now, having come to that, my lord, I say erroneous conclusion that that person is dead, that the court proceeds against that dead person, passes further orders, and finally disposes of the case against that dead person. And in this, my lord, order which I say these orders are all null and void, my lord, these orders were given effect to, and my lord, assuming I have no right, I have to claim through him. I am a third person, rank, my lord, outsider. I cannot be, my lord, thrown away without due process of law. And my lord, use of null orders against me to throw me out of possession, my lord, is where I am aggrieved. So I am, my lord, for appeal, my lord, it is not only a party, but also any person aggrieved by the order or decree, my lord, can file an appeal. So, my lord, that is where I'm praying for leave to appeal. And I am also praying for condonation of delay of 35 days in filing the bill, because I was totally unaware I was diligently pursuing civil division. It was only after final order in civil division was dictated that the fact came to light that further orders have been passed and the matter has been disposed of. So, my lord, these are the two leaves I'm praying for. I had a stay application. Now it is, my lord, stay application is infructuous because now I'm outside. So I have filed another application, my lord, CAN 4, for status quo ante, for restoration of my position.
Let
That,
us
my
hear,
lord,
hear Mr. Mukherjee on the
Yes.
leave application and this section.
I'm-
Yes, yes.
I'm
Mr.
good.
But my learned friend's client, my lord, he bases his claim, my lord, based upon, my lord, 3 documents. One of the document is, my lord, the power of attorney. The other document is the adoption deed, and the other document is, my lord, a will. So, my lord, the will is in respect of this, my lord, tenanted shop room, which is the subject matter of the suit. I got a degree against AC Vasu, who was, my lord, my recorded tenant in the year 1982. I put the degree into execution in 1983. I could not execute, and accordingly, my lord, I had to, my lord, file a case under Order 21, Rule 97 for police help. In course of hearing of that application, my lord, when we pursuant to our, my lord, notice in the newspaper under Order 5, Rule 20, my lord, this gentleman came and said that I am the power of attorney holder and I am entitled to contest. Now, my lord, on the inquiry by the learned judge, my lord, the learned lawyer who appeared, my lord, she said that there is no direct instruction from Mr. Vasu or Mr. Clayton on the score that whether he is entitled to, my lord, represent Mr. AC Vasu or not. But that is an order which your lordship will find, my lord, at page, my lord, 47 of the stay application, order number 27, dated 17/1/2026, which was, my lord, the subject matter of the civil revision. But in the stay application, it is there. And leave to appeal stay application.
Page 47.
Page 47 of the stay application.
Yes, yes. Yes.
But
But the presumption of death is taken.
yes.
First of all, he is not given an opportunity of written objection. His point is that, Mr. Das.
No, I will come back to, my lord, that point. If he is
Absolutely.
now, my lord, now say that I have an independent right, because he was, my lord, saying that I am in occupation of the property and I have documents in annex to CAN 4. But the question is that whether he can be allowed to prefer an appeal or he has to establish his, my lord, right title in a separate proceeding under Order 21 or 47, as the case may be. Therefore, instead of, my lord, doing that, he is before your lordship trying to assail, my lord, an order passed, my lord, in a police help application.
But Mr. Mukherjee, he may have a parallel right of doing that as well as this.
Lord, why I say, my
Because
lord,
he's agreed by this order also, and he can independently establish as the first forum, not exactly Order 21. If he claims independent position,
that is what he says. That is what he also tries to, my lord, by way of a CAN 4, which has not been served to us. Therefore, until unless, my lord, he goes back to the court below to establish his independent right, not, my lord, flowing from, my lord, the degree hold judgment data, he cannot come and say that I am in possession on the strength of my own right.
no, but still he may claim that, as well as he may have a an axe to grind regarding this order also, impugn order.
Here, my lord, kindly see his leave to appeal is based upon, my lord, if he is, my lord, the power of attorney holder of, my lord, the judgment data,
Yes.
my lord, then he doesn't seek a leave. He doesn't need a leave.
No,
because in the
power of attorney has been cancelled by the learned trial judge, by executing court.
No, that
So
has not
therefore
been
now
cancelled. Lord, that was
he's also assailing, rather his representation
that
was
has not been
turned down.
cancelled. Lord, the question was whether, Lord, the constituent was, Lord, available or not. That again, Lord, I can put this question. Your Lordship has also put this question to
The
him.
power of attorney is of no significance, it was held.
That is.
And is not valid. If that be so, that finding is arrived at, that
Yes.
merges in the final order in the order.
No, that doesn't merge. This order was independently assailed, Lord, in the civil division. Now,
That
before your
became
Lordship also,
infructuous.
this order is not the subject matter of challenge. Even in 105, they could have done so. They didn't not challenge this order.
No, but in the order 2097, in connection with that only, his participation was closed.
No, he is challenging the final order by which the police help was directed.
Yes,
and I've already got possession pursuant here.
No, Mr. Mukherjee, at the same time, this order was passed in connection with the very proceeding which has culminated in finality, which has been now challenged before us.
Right.
So, why shouldn't the principle of section 105 probably?
105 has not been resorted to in his memo of appeal. I've checked that. As your lordship knows, there must be a mention of the interlocutory order, which is a part of the appeal.
Yes,
he is
it's
only
not
agreed
there.
by the 18th April order.
Permit him to amend the memo.
No, there are other points, which I will. Now, the other point is
We have
before
to
your
protect
lordship.
him from you also.
My lord?
We have to protect him from you also. your stature. So we take up the brief for him regarding that ground.
Well, as of now, he says that the police help application that has been allowed, that is a subject matter of appeal before your lordship.
Yes.
Now, he is trying to say that there cannot be an execution because I am independently occupying the property on the strength of the whatever the rent that he has paid in 1997, as I understand.
No, AC Basu paid.
No.
Oh, achha.
AC Vasu has given him the power of attorney long back. I can show him the
96,
power of attorney.
96 he said.
Yes, 96. He is talking about 97.
He said a fresh tenancy was created in favor of AC Basu only. That was his submission. In favor of AC Basu, not in his favor.
But that is not the case that has been made out here, as I find, subject to correction by my learned friend.
Oh.
But I did not read it anywhere.
My lord, I have also annexed the rent receipt of 91, issued in the name of AC Basu by the trustees of the respondent trust.
No, Mr. Mukherjee says you have not made out a case that you have made out an independent case here. That you are a tenant.
No, my lord, I have not.
But he
made
was
out an
appearing
independent
as a constituted attorney.
For-
of AC Basu.
sorry.
Then, if he is appearing as a constituted attorney, there is no necessity of a leave. Because the leave is only by a person who is not independently agreed by an order.
No,
and who is not a party to a procedure. And if he says that I appear in the capacity and file the appeal as a constituted attorney, he is representing AC Vasu. Then
the appeal should have been by AC Vasu and he would be there.
Then, the question comes whether the AC Vasu is alive or not, and I resort to the provisions of the Civil Procedure Code that he can be directed to appear before your lordship to ascertain his whether he is there or not. Having regard to his age, that much I can say.
At least some proof of his being alive.
That is. And if
we can have a commission on that also. No, we can appoint a special officer to ascertain. Go to his residence.
Yes, but if he's not there, the commission will be a bit futile, that way.
No, it will have far-reaching effect.
Yes, very far.
No, but then they have to disclose.
Yes, that is.
Sure, Mr. Das won't be liking that.
But he said that he cannot. He said not subject to subject to clarification by him.
No, do you say? Yes, Mr. Das.
My lord, my submission is this. My lord, I take the best case. I take the worst. My worst case and best case is Mr. AC Vasu is dead. Let us, my lord, for 1 second. Can, my lord, after 27, this presumption was made by the court that he is dead, and I am not entitled to my validity of my power of attorney was also
formally
decided.
put a query to you, Mr. Das, because we'll record that in
Yes,
your order also, as to whether you can furnish any proof, not any proof, whether you can furnish his address to ascertain whether he's alive or not. What would be your answer to that? We are putting that question formally to you.
My lord,
We want
I
to
will have
appoint a
take
special
instruction,
officer.
but perhaps, my lord, from what I have heard, he doesn't know. My client doesn't know present whereabouts. This is a fact, my lord. I cannot, my lord, improve the facts that his whereabouts because he went away to some ashram. That is what information he has after retirement. After that, my lord, from their affidavit, what I find that they have traced a present relative of Mr. AC Vasu.
No, then you fall back upon your other point in the name
Yes,
of a
my
dead
lord.
person. We'll be coming to that. Very
Yes,
no, first you have to cross the hurdle of leave. That is what we are worrying about.
Yes,
In
my
respect
lord,
of
the leave is, my lord, if I was accepted as the constituted attorney, I would not require leave. The appeal would have been in the name of AC Vasu. Now,
but you have
the
never
same
made out any
order-
case of a third party, right? You have
Yes, my
not taken
lord.
out any application under Order 97 to 101.
No, if I don't have a third party right, my right is through him. I have a right to come and propound that if he is dead, these orders are a nullity against him. If he is dead, they are a nullity. If my power of attorney is valid today, then my grievance will be that the same proceedings which culminated in this order also shut me out by holding that my power of attorney is not valid. So in either case, my lord, I will have a, my lord, interest or grievance against the order to appeal
Power of
before this
attorney holder cannot have an independent right to prefer an appeal, Mr. Das. We have some
But my
difficulty
lord,
there.
this is a
Mr.
situation
Mukherjee
where
has a
the
point.
impugned order
Initially,
itself also holds that
because
my
you
power
are
of attorney is
here,
not valid.
no, here, Mr. Das, whether it holds it, your power of attorney is not valid on, it can be either on the premise that you are representing AC Basu or on your independent right. Your independent right, you have never asserted anywhere, you have not taken out in order 20 not even taken out in order 97 101, and you cannot take that out now because all along you had represented AC Basu and was representing him. In that capacity, you have appeared.
Yes.
One. Secondly, then if you in your independent capacity don't have a right to prefer an appeal. Mr. Mukherjee has a point there.
No, man. My lord, the difficulty is
Because
this,
the appellant
that
here
I
is
am today
you.
good, bad, indifferent,
Power of
claiming
attorney,
through a
it has to be in the
person.
name of the principal. Then you had to define, make Esibasu as an appellant, and you describe yourself as the power of attorney holder, constituted attorney of that
Yes,
person.
man. And this is
You
what
don't
the,
have a right in your independent
yes, man. The
capacity.
problem is the impugned order also bars me from doing that.
Not
The impugned order
necessarily, not
holds that I.
necessarily. Not necessarily,
Well,
because if you are
kindly
challenging
sees.
that, no, Mr. Das, the impugned order says that power of attorney executed by him is of no significance and is not valid. If you say that the impugned order debars it, then you are acceding to the impugned order and you are not challenging it. But if you are challenging it, then you have to assert your right in the capacity of power of attorney holder and make AC Basu the appellant. AC Basu has to be the appellant, you have to be the power of attorney holder. If you assail that, then you are challenging that on the strength of your power of attorney being valid. So then you cannot have it both ways. If you the moment you claim an independent capacity, then you are admitting that power of attorney is invalid. And we have to observe
My
that
lord,
your power of attorney is invalid to permit you to do that. This appeal is
my
not
lord,
maintained by
kindly consider one thing, my lord, only that the appeal is considered to be a continuation of the suit. Now, in the suit, it has been held. I am aggrieved that it has been held. I cannot represent AC Basu.
If appeal
So
is
today,
was
my
a
lord, when I
continuation of
filed
the
the
suit
appeal,
for all purposes, Mr. Das,
Yes.
that's that's a legal fiction only for the sake of convenience in certain aspects of the matter. But if appeal was really a continuation of the suit, then by stretching that logic, then the suit passed, the degree passed in the suit could never be assailed in the appeal against that.
my lord,
It
I
would be a
appreciate. But
peculiar
technically, my lord, the
proposition.
cause title should have been AC Basu, represented by his
So this is not
constituted attorney.
technical. This is not
This is not
technical
technical, but
because
my lord, if my
not
lord,
technical, Mr. Das, it is not technical because if AC Basu was the appellant, you would not require any leave application, as Mr. Mukherjee is right on that.
yes, my lord, then
Then
in
the leave
that case,
application
my
is
lord,
not
then they
maintainable.
will challenge the maintainability of the appeal on the ground that it has already been held. I cannot rely on the power of attorney. But then either case, my lord, the real controversy is this: whether I was entitled to, my lord, represent him and be heard on that power of attorney. If that was, my lord, properly decided that he is dead,
No,
then my lord, I
Das,
have other remedies.
if you cannot furnish any proof of Mr. AC Basu still living, then we are unable to, because we are also a court of equity. You have to look at practical and be pragmatic. We have to look at the practical situation. A person who is no longer alive, the power of attorney cannot establish that he is alive. Then we have to consider that he is no
Then my
longer
lord,
in the living
now
world
my
of
lord,
the
then
living.
kindly
You don't
consider
have
the
a right.
consequence will be then I have to take leave because if he's dead, my power of attorney is not valid. Then I'm
No.
claiming in my own right.
You
Then
cannot
I have
claim
a
in
right
both
to, my lord, take
capacities.
leave and
See,
challenge.
your only right which you claimed throughout was as the power of attorney, as the agent of AC Basu. You never
Yes, ma'am.
claimed any independent tenancy right, any right of occupation, any legal right in the property. After the demise of the principal, the agent's power lapses. So you don't have any right to stay in the property, Mr. Das, your client.
My lord,
So your
but
client was
that has
rightly
to be I'm a rank trespasser. But even then, there has to be a due process of law. They cannot take orders against a dead person to throw me out. Well, that is where I am going. The entire difficulty has been created because this fact ought to have been ascertained, whether he is alive or dead. Two different consequences flow from whether he was alive or dead. My lord, my only submission is this: that assuming he is dead, can they take orders against him and execute it against him?
is saying something.
Mr. Das,
Sorry.
if
Yes,
you
ma'am.
if you intend to challenge the impugned order, then
Yes,
that
ma'am.
application will have to be supported by Section 108 of the Evidence Act.
Now 111.
Now, whatever the change
Yes,
unchanged circumstances, that is, you will have to rely that within 7
Well,
years
if my
he was
lord
alive.
sees I have disclosed registered documents. Yes, my lord. Within 30 years, he was alive. That I can prove, my lord, in 97. Good, bad, indifferent, my lord. The
7
deed
years.
of adoption may be invalid, but it shows he has come to the registry office and
You will
registered a
have to
document
you will
in
have
97.
you will have to rely upon Section 108 of the Indian Evidence Act. But
Yes, ma'am.
burden of proving that person is alive who has not been heard of for 7 years.
My lord, that my lord heard of for 7 years by his relatives, those who should have heard from him. My lord, that
No,
inquiry has not been made.
if you intend to challenge, then it will have to be supported by 108 of the Indian Evidence Act.
My lord, well, my submission is first, my lord, 107 applies in this case because today, my lord, I have a document that he has executed within 30 years. Now, my lord, to establish 108, the burden lies on them to first show that those who would have ordinarily heard from him have not heard from him within 7 years. But they say they have contacted some relatives, but that is, my lord, that evidence, it's a question of evidence whether his relatives have heard from him within 7 years or not. That is my submission. This inquiry, which should have been done properly, has not been done. I am not, my lord, saying one way or the other anything, my lord.
Leave is very difficult to grant leave, Mr. Das. Either way, AC Das could have been, AC Vasu could have been an appellant, but then you had to establish that he was alive. If you don't know his whereabouts, then we cannot. It's very difficult for us to grant you leave.
Well, then consider, my lord, my alternative submission. If the presumption is he is dead, and that is the presumption held by the learned court below, against which I had to come in revision during the pendency of the revision without substituting the legal heirs, this order has been obtained, and I am aggrieved by that order. Today I am on the street because of this order, my lord.
Yes, but we cannot open the window of entering into that query unless we grant you leave. The appeal is
Yes,
not
my lord,
maintainable at
kindly
your.
consider the threshold issue of leave. My lord, kindly consider this situation which I have been placed in. Either way, my lord, my appeal
You
will
are not
be
an
made.
agent of the. You are not an agent of the. You are an agent of the judgment debtor. You don't have any independent right there. So you have been
My lord,
evicted.
my independent right arose the day the court took a presumption that I am not his agent.
Here
Court
there
held that I cannot represent
no
him.
heir of AC Vasu has come up saying that we were in possession and we have been dispossessed. If some heir was there and they had come up and said that we have been dispossessed, we could have understood that they are the heirs of AC Vasu and they could have validly taken this point that in the name of dead person and all. There is no heir residing there. You are his power of attorney. He is not there. Your power is gone.
My lord, kindly
can you
consider
help
this, that even if I have overstayed my right, for the last, my lord, whenever he is, my lord, found to be dead, 2001 or 2000, I am there in the physically. And my lord, today, against the dead person, an order is taken to evict me. My lord, when an order is a nullity passed against a dead person, my lord, as an aggrieved person, my lord, I can appeal. This is my humble submission.
No, Mr. Das, we cannot permit you. We are deciding it. Yes. We are dismissing the leave application. The present appeal has been preferred against an order whereby an application under Order 21, Rule 97 of the Code of Civil Procedure for police help to evict the judgment debtor in an eviction suit, one AC Vasu, was allowed. Push up next para. The application is accompanied, the memorandum of appeal is accompanied by a condonation application and, more importantly, an application for leave to prefer the appeal. Push up, the application for leave has been filed, as has been the appeal, by a person claiming to be the constituted attorney of the judgment debtor. Push up next para. learned counsel appearing for the appellant stroke leave applicant submits that the eviction decree was passed against the said AC Vasu, VASU, AC Vasu in the year 1982 and execution was levied in 1983. Full-stop, it is argued that in 1997, a fresh tenancy was created in favor of the said AC Vasu. Full-stop, AC Vasu, in the year 1996, it is alleged, executed a registered general power of attorney in favor of the appellant stroke leave applicant. Full-stop, that apart, a registered adoption deed was also executed, whereby the said AC Vasu, within bracket judgment debtor, bracket closed, formally adopted the present appellant. Full-stop, next para, that subsequently, a will was also executed in favor of the present appellant. Will was probated, Mr. Das? Will was probated?
No, my lord. Because, my lord, we don't know today also whether he's dead. Our case is he's still alive. We don't have information
Conveying a
that he's
tenanted
dead.
property in any event, my lord, it doesn't work.
No, we are just asking. Yes.
Beneficial interest of the tenancy.
Yes, will could not be transferred posthumously also. No, we are just asking whether it was probated. He has anticipated the reason. That's evident from his answer. Yes. Next para. Learned counsel for the appellant submits that by dint of an interlocutory order passed in connection with the miscellaneous case arising out of the Order 21 Rule 97 application, being order number 27 dated January 17, 2026, the executing court observed, inter alia, that if alive, the said AC Vasu would be now more than 100 years of age and it is still not clear as to whether he is alive. On such premise, and on the basis of the submission of the learned advocate for representing the judgment debtor that he has no contact with the judgment debtor AC Vasu directly, it was held by the executing court that the power of attorney executed by him in favor of the present appellant was of no significance and was not valid. Next para, learned counsel submits that since the said order has merged in the final order passed in the Order 21 Rule 97 application, which is impugned in the present appeal, borrowing the principle of Section 105 of the Code of Civil Procedure, the present challenge also incorporates a challenge to the legality of such interlocutory order, whereby the power of attorney was deemed to be invalid. Next para, learned counsel submits that within the contemplation of sections 107 and 108 of the Indian Evidence Act, within bracket now sections 110/111 of the Bharatiya, what is that? Saksha Adhiniyam. Yes. Within bracket BSA, thank you. BSA, bracket closed, the onus lay on the party who asserted the death of AC Vasu, that is the respondent stroke decree holder, to establish the fact of his death. Without entering into such factual inquiry, the order dated January 17, 2026, invalidating the power of attorney of the appellant was illegal. Next para, that apart, it is submitted that the appellant was constrained to file the present appeal himself with an application for leave to prefer the same, in view of the executing court having invalidated his power of attorney. Thus, in the teeth of the said order dated January 17, 2026, passed by the executing court, the appellant does not have the locus standi to represent the appellant, judgment debtor otherwise than in his independent capacity. Next para, although the said order is assailed, it is submitted that unless the same is set aside, the appellant has no option but to preferred the appeal with a prayer for grant of leave to prefer the same in his own name. For the next para, secondly, learned counsel for the appellant argues that the impugned order could not survive in any event, since the executing court proceeded on the very premise that the original judgment debtor A.C. Vasu was no longer alive, as recorded in the order dated January 17, 2026, on which basis the very power of attorney executed by him in favor of the present appellant was invalidated. First up, if that be so, it is argued that all further orders, including the order impugned herein, were passed in the name of a deceased person. First up, by placing reliance on Shanti Devi versus Khandubala Dashi and others, reported at AIR 1961 Cal 336, rendered by a full bench of this court, learned counsel submits that unless the heirs and legal representatives of the judgment debtor, in whom the estate of the judgment debtor vests, are impleaded in the execution case, no order can be passed in such execution proceeding in the name of a dead person. For sub next para, thus, the impugned order, in any event, was a nullity in the eye of law and ought to be set aside. For sub next para, learned senior counsel appearing for the respondent stroke judgment debtors submits that the alleged irregularity stroke illegality of the order dated January 17, 2026, sought to be urged by the appellant before this court, has not been set up as a ground in the memorandum of the present appeal, thereby precluding section 105 of the Code of Civil Procedure being attracted. Footstep, in any event, learned senior counsel submits that the appellant has failed to prove before any forum that the original judgment debtor A.C. Vasu is still alive. Footstep next para, it is contended that under the provisions of the Code of Civil Procedure, the court has ample power, if it so opines, to ascertain whether A.C. Vasu is still alive, direct his personal presence in court. For sub next para, however, seen from any perspective, the appellant does not have the locus standi to prefer the appeal in his independent capacity. For sub next para, it is contended that all along, the appellant was representing A.C. Vasu as his constituted attorney in the executing court. Full stop. Thus, it is only the said A.C. Vasu who could have preferred the appeal, if he was alive, represented at best by his constituted attorney. Full stop. However, the constituted attorney, on the demise of the principal, cannot have any independent locus standi to prefer any appeal. For sub next para, learned senior counsel further points out that if the appellant was to assert any right independent of the judgment debtor, it was for him to prefer and to take out an appropriate application under the provisions of Order 21, Rules 97 to 101 of the Code of Civil Procedure, which has not been done in the present case. For sub next para, with regard to the alleged adoption deed executed in favor, executed by the judgment debtor A.C. Vasu, thereby adopting the appellant, it is submitted by learned senior counsel for the respondents that the same deed, even if there be any, is invalid in the eye of law. Full stop. An adoption deed executed allegedly under the Hindu Adoption and Maintenance Act, it is submitted, can only be in case both the adoptive father and the adopted child are Hindus by faith. Full stop. The present appellant is Christian by faith. is admittedly Christian by faith, and as such, there could not be any adoption between the two. Full stop. Next para. Insofar as the purported will is concerned, since the appellant asserts that the judgment is still alive, there could not arise any question of relying on the will. Full stop. Even otherwise, learned senior counsel submits that there cannot be any transfer, unilateral transfer by the tenant of a tenanted property, either inter vivos or posthumously without the consent of the landlord. Full stop. Thus, bequest of a tenanted property by way of a will is not tenable in the eye of law. Full stop. Next para. Hence, the appellant, it is argued, does not have any locus standi to take out the present appeal or seek leave to file the same. For some next para, upon hearing learned counsel for the parties, this court formally put a query to the learned advocate for the appellant as to whether the appellant was in a position to disclose the current address or whereabouts of the original judgment debtor AC Vasu. Upon such query, learned counsel for the appellant, on instructions, candidly submits that the appellant does not have any idea about the whereabouts or the present residence of the judgment debtor. Thus, it is clear that the appellant is also not in a position to establish that the judgment debtor is alive. Even otherwise, if we construe the presumption under section 108 of the Indian Evidence Act and or the corresponding provision in the BSA, we do not find that the judgment debtor AC Vasu has appeared at any point of time before the executing court, at least for the last 7 years. Hence, primarily it is for the appellant to establish, since he asserts that AC Vasu is alive, the factum of the said factum. Since the appellant admittedly does not know the whereabouts of the said judgment debtor and court does not have any instruction from the said judgment debtor, we cannot give a premium to the assertion that the said AC Vasu, who would be more than a century old if alive now, being alive. Next para. Thus, seen from such perspective, on the demise of AC Vasu, the power of attorney has automatically ceased to operate. Next para. Even if we were to presume that AC Vasu is still alive, it is him that had the locus standi to prefer the present appeal, being directly aggrieved if alive. Next para. However, the present appeal has not been filed by AC Vasu, represented by his constituted attorney, but directly by such alleged constituted attorney, the present appellant, in his individual name and capacity. Next para. Having not claimed any third-party rights at any point of time before any forum, but all along claimed as the power of attorney of the judgment debtor, in the capacity of an agent, the appellant cannot now seek an independent right to prefer an appeal as an aggrieved party, the quote-unquote aggrieved party, vis-a-vis the said impugned order. Next para. Thus, the leave as sought cannot be granted. Next para. Although the leave, if granted, would be the window for the appellant, window for the court to look into the illegality, if any, in the impugned order, still, in order to satisfy our judicial conscience, we record the fact that we might have taken a different view in the event any of the heirs and legal representatives of AC Vasu had come before us claiming leave to prefer the appeal by being candid and admitting that the said AC Vasu is no longer in the world of the living. it is only such heirs and legal representatives who had the right to urge that the further proceeding in the execution case and the impugned order was a nullity in the absence of impediment of such heirs and legal representatives. Full stop. However, comma, no such heir stroke legal representative, comma, if any, comma, has ever come up either before the executing court or before this court, taking up the cudgel on behalf of the deceased AC Vasu, comma, if he is no longer alive. Full stop. Next para. Hence, comma, in the absence of any proof as to AC Vasu even having left behind any heir or legal representative, comma, we cannot permit the appellant, comma, who was merely the power of attorney, merely the constituted attorney of the judgment debtor, whose power ceased with the apparent demise of the judgment debtor, comma, to agitate such point before us. Full stop. Next para. As such, comma, we are not inclined to grant leave to the appellant to prefer the appeal. Full stop. Accordingly, can 3 of 2026 is dismissed on contest, comma, thereby refusing to prefer refusing to grant leave to prefer FAT 232 FMAT should.
Yeah, FMAT.
FMAT 277 of 2026. Full stop. Next para. Consequentially, comma, FMAT 277 of 2026 as well as can 2 of 2026, can 1 is also there. Can 1 of 2026 and can 2 of 2026 are also dismissed. Can 4 is also there.
Yes,
It's appearing. As well as can 4 of 2026 are dismissed. Full stop. There will be no orders to cause urgent certificate copies. Thank you. And 4 is for what? The
They were asking for restoration of possession.
That is for the restoration.
Great. It was due to here.
No, 53, my lord, I am for the appellant. My lord, this appeal is against the application disposal of the application under order 39 rule 1 and 2 filed by the respondent without any speaking order.
Injunction granted.
Granted, disposed of without any findings. Kindly see, without any findings. The plaintiff says so, the defendant says so, so this I dispose of. Kindly see the order impugned. What is the basis of granting? Accordingly, it is decided. Directed the parties to the suit, both the plaintiff and the defendant shall maintain status quo. First part, what they have said. Second part, what I have said.
Mr. Rai, you give a copy of the memorandum as well as the application. Will dispose of the appeal itself. We'll make that clear in our order today. As rightly argued by learned counsel for the appellant, comma, on a bare perusal of the impugned order, it is evident that the learned trial judge, comma, while disposing of an application under order 39 rules 1 and 2, comma, read with section 151 of the Code of Civil Procedure, comma, did not attribute a single line of reasoning for coming to such conclusion. Full stop. Next para. The appeal is admitted to be heard on the above ground and the other grounds taken in the memorandum. Full stop. We intend to decide the appeal along with the application. Full stop. Accordingly, the appellant shall serve copies of the application as well as the memorandum of the appeal on the respondent, indicating that the appeal and the application shall be taken up on the papers already on record on September 7, 2026, when the matter shall next be returnable under the heading Specially Fixed Matters. Full stop. Next para. Along with the copies of the application and the memorandum of appeal, comma, the appellant shall also serve a server copy of this order.
Grateful.
Thank you. We are Astonished.
Absolutely no findings. What they have said, what I have said, in application is disposed of.
That has also been not been totally said. You have said many other things also.
Section, actually it is a suit 2G.
You have never seen such an order. 2G?
2G. She is not staying here. The original.
What injunction did you ask?
Not
they asked for injunction.
They asked for injunction.
No, this is their suit.
It is their suit. And the
2G, you have filed a counterclaim.
No. I have not.
Why are you saying
because the actually the son is in possession.
Go and file the counterclaim.
Yes, I have decided to file.
Why are you taking so much time?
The copy has
not been already filed.
Yes. I will file. I was thinking on this because she never resided. That person died at Bihar. Not ordinarily resided at the tenancy, even this petitioner. Grateful.
Next. Yes.
My lord, this appeal is directed against the order refusing my ad interim order of injunction. Well, on the ground that the agreement between the appellant and the respondent is hit by Section 25 of the Indian Contract Act. No consideration, no contact. My submission is, my lord, learned trial judge failed to consider the nature and character of the transaction made between this plaintiff and the defendant. Because as a matter of fact, my lord, the appellant is a club, is in occupation for long period. And the respondent is the owner of the property. The respondent wanted to raise a multi-storied building on that land. Well, there was an agreement between
but these are individuals in individual names you have filed.
There is a secretary, my lord.
Is it a registered as? Yes, it is.
Yes, registered.
Very good. So then,
my lord, there was an agreement between the parties that on the ground that the appellant club will vacate the premises, hand over the possession, and the appellant respondent will construct a building, and after construction a multi-storied building, they will hand over and delivery of possession of 750 square foot area
to the club.
To the club. My lord, first agreement was in the year 2024. Then, my lord, it was, my lord, at a second, first supplementary agreement. My lord, those two agreements are not with me, my lord. But when a second supplementary agreement is with me, and in the second supplementary agreement, my lord, kindly have a look to the second supplementary agreement. The condition. Page, my lord.
19.
13.
19 is the typed copy.
Type copy, my lord.
Yes.
13. Page 13. Page 13, my lord.
Paragraph 13, yes.
Fifth paragraph. And whereas it has been principally agreed by and between the parties herein in the terms in the agreement and the pursuant to the principal agreement and the supplementary agreement referred to herein above and entered into by and between the parties herein, that the owners of the first part herein shall provide to the said club of the other part, including Mandir, Puja room, herein a total super built up area of 750 square feet, comprising a super built up area of 500 square feet, more or less, within the sanctioned covered area under the superstructure of the building, and the balance super built up area of 250 square feet, more or less, outside such superstructure of the building, but within the precinct of the building on the land upon which the superstructure will be raised or constructed. My lord, now the building has been constructed. My lord, now they are not giving possession to the club. And that's why, my lord, they are trying to dispose of that area. And so, my lord, the club has filed this suit.
No, but where is the consideration actually? There's justification in
Consideration, my lord, because it is there is no consideration is here, my lord. The flat, I mean, their structure of 750 square feet will be
contract act
will be delivered in terms of the vacating possession. I have handed over the possession.
So that is the consideration.
That is the consideration. I have handed over the possession in turn that he will give deliver the possession of 750 square feet. That is the consideration. My lord, it is the exception. There is the exception, my lord. There is section 25 of the Indian Contract Act.
This was natural love and affection between
My lord.
parties. Natural love and love affection.
No, not love and affection. No,
love forcibly making him enter into.
No, not forcibly. Not forcibly.
Unnatural love and affection.
No, well, that is no forcible. It is not forcible. Their possession, the club is possessing for a long period.
Maybe two. It is a promise to compensate wholly or in part a person who has already voluntarily done something. No, you have not already done. Anyway. Consideration দয়া করে ছেড়ে দিয়েছি
এখন বাড়িওয়ালা বাগে পেয়েছে
বাড়িওয়ালা 14 বুঝে বুঝে পাচ্ছে
সত্যি ব্যাপার
arguable. Consideration can be in various forms. Let us see the impugn order once.
notice is required.
My lord, only that ground, my lord, kindly
Yes, we have seen.
operative part, my lord.
What injunction did you ask for?
My lord, restraining them not to transfer the 750 square feet to any third party.
You have mentioned that in Schedule B of the injunction.
My lord, my lord.
Which page do you find that? The injunction application reliefs.
My lord, injunction application, I have annexed the injunction application.
Yes, just the page number. The agreement.
Agreement 4.
Which page?
My injunction.
Plain to have
two.
Plain to have annexed.
Yes, plain. In the plain.
Achha.
Schedule B.
Shall provide to the club a total super built as per the agreement, a total super built up area of about
750.
You can't read that. 750. Very well.
In the
The present appeal has been preferred against the refusal of ad interim injunction in a suit for specific performance filed by the appellants, in the capacity of portfolio holders of a registered club. Full stop, next para. Portfolio holders of a club registered under the Societies Registration Act must be. Societies Registration Act. Full stop, next para. The learned trial judge refused to grant ad interim injunction only on the premise that prima facie the agreement on which the appellants rely on comma, dated June 22, 2024, comma, is hit by the provision of Section 25 of the Indian Contract Act, comma, since there cannot be said to be any concluded contract as there is no utterance of any consideration amount. Full stop. Next para, we find from a perusal of the agreement relied on by the appellants that
outside such superstructure.
that that as per the same comma, the defendant stroke respondent apparently agreed to provide the club with an accommodation of 750 square feet, comma, out of which 500 square feet would be comprised of super built up area more or less within the sanctioned covered area under the superstructure of the building, and the balance super built up area of 250 square feet more or less outside such superstructure of the building but within the precincts of the building on the land upon which the superstructure will be raised or constructed. For sub next para, from a perusal of the agreement, comma, it prima facie appears that the consideration of such grant was that the club, comma, which has been referred to as a tenant in respect of the said property, comma, would vacate the premises for the purpose of such construction being made. For sub next para, it is not necessary that construction must be in monetary form. Full stop. Hence, comma, we find that a prima facie case for grant of injunction has been made out. Full stop. Accordingly, the appeal is admitted and shall be heard on the above questions and the other grounds taken in the memorandum. The defendant stroke respondent shall remain restrained by an order of injunction from transferring, alienating, and or creating any third-party interest in respect of the suit property. Now, in respect of the Schedule B property as described in the plaint of the suit till disposal of Can 1 of 2026. Which of the appellants shall serve a copy of Can 1 of 2026 as well as a copy of the memorandum of appeal on the respondent indicating that the application shall next be listed for hearing in the monthly list of September 2026 when an affidavit of service to that effect shall be filed by the appellant. Full stop. The appellant shall also put in postal costs and requisites for service of notice of the appeal on the respondent. Full stop. The trial court records need not be called for at the present moment. Full stop. The appellant shall also prepare informal paperbooks without comparing with the records within 6 weeks from date. Thank you.
One construction, your lordship dictated construction, it should be consideration.
Achha. We'll take correct. Thank you. Thank you.
I'm getting.
Now 55.
Yes.
Matter, my lord, the appellant being the plaintiff in a suit for declaration and permanent injunction.
Right.
My lord, on the premise, my lord, may I state the fact in brief, my lord. I am the owner and occupier of 22 sotaks of land in plot number 462 and 462 Bata plot. Now, in 462 Bata plot, some portion has been recorded as Rasta for Jonosadaroner, that is recorded in the Now, in 462 plot, 1 shotok has been recorded as Devosthan for public use. Now, in the plaint, I have stated that I want to leave that 1 shotok, but my lord, the 14 defendants, the 14 villagers, they are trying to disturb my peaceful possession. That is why I have filed a suit for declaration. And
disturb your peaceful possession regarding the rest also.
Regarding the rest also. Regarding the rest also. Now, my lord, trial court decreed in my favor.
No, Rasta and Devasthan are two separate portions.
Rasta is in Bata plot, 462 Bata plot.
Yes.
In plot number 462, 1 Shatok has been recorded as Devasthan. There is 10 Shatoks of land in plot number 462.
Bata plot as well as the main plot, you are that's the subject matter of the suit.
Uh,
So you want to leave the Rasta as well as the Devasthan.
Rasta as well as the Devasthan.
You want to enjoy the rest.
Enjoy
You
the
seek
rest.
a declaration of your title regarding the entire property.
With regard to plot number 462, 10 Shatok, not the Bata plot. Now, Bata plot is out of the suit property. Now, my lord, trial court decreed in my favor. Appeal court, my lord, reversed the
judgment of remand.
Remand. My lord, appeal court, my lord, on the premise that I have not made all the villagers as a party respondent.
All the villagers?
Villagers as a party, my lord, defendant, my lord, remanded back the matter to London trial court below and directed to make
All
paper,
the villagers?
make paper publications also.
Before making paper publication, you have to implead all the villagers.
I have to implead all the villagers.
It's a large village. Let us please show us that relevant portion of the.
Now, my lord, the observation of the appeal court, my lord,
On
is
which
that,
ground it has been remanded? Let us see that.
my lord, on page 10, my lord.
There's an epilogue also. মারা যাচ্ছে নাকি? Page 16 appeal court. Epilogue this.
Portion.
এই ফিউচারে চালাবে কিন্তু জুডিশিয়ারি। কি বললো? Quoted.
No, inner page 10 of the, my lord,
Of the
appellate court's judgment, my lord.
This is in a page 10. 10, then written at the top.
My lord,
Submission of appellant starts from page 7.
the
Points 1 to
observation, my lord, kindly sees, my lord, inner page 9 onwards, my lord, points number 1 to 4.
Yes, points 1.
1 to 4.
Now let me pave through the findings, that is decision with reasons. Order 8, order 1
Order 1
8
to
has
8.
been quoted.
Yes.
So where is the observation that
Observation starts from, my lord, page 10, bottom portion. Thus, any suit instituted under the provision of Order 1 Rule 8 of the Code of Civil Procedure, which is known as representative suit, is filed by or against one or more persons on behalf of themselves and others having the same interest in the suit. As a general rule, all persons interested in the suit ought to be joined as the parties to it, so that the matters involved therein may be finally adjudicated, and upon fresh litigations over the same matter may be avoided. Rule 8 of Order 1 is an exception to the general principle. It provides that when there are a number of persons similarly interested in the suit, one or more of them can, with the permission of the court or upon direction from
have annexed a copy of the plaint?
Yes, I have annexed.
Let us
Page, my lord, 14 onwards. My lord, my grievance, my lord,
your
starts from
specific grievances against these 14
persons, my lord, page, paragraph 4, my
You
lord.
have not sought for any relief against the entire village.
No. Against this specific 14 persons, my lord, kindly sees, I have stated হালে 1 নম্বর হইতে 14 নম্বর মূল বিবাদীগণ সেটেলমেন্ট কর্মচারীগণ তথা
No, you have in the plaintiff pleaded উক্ত সম্পত্তি কোনোদিনই দেবস্থান সম্পত্তি বা হিন্দু জনসাধারণের সম্পত্তি ছিল না, এখনো নাই বা থাকিবার কোনো কারণও ঘটে নাই. Probably for that reason.
Only for that reason, against these 14 persons. Lord,
court says that the instant suit must be deemed to be against the entire Hindu residents of the Krishnapur village.
Yes. In my pleadings also, I have stated that, my lord, may I read out, my lord, বাদী উক্তরূপ রেকর্ডেও অকুশী হন নাই, তিনি সবসময় উক্ত দাগের 100% সম্পত্তি দেবস্থান হিসেবে ছাড়িয়ে দিতে রাজি ছিলেন এবং এখনো আছেন। কিন্তু মূল বিবাদীগণ কিছুদিন হইতে আস্ফলন করিতেছেন যে তাহারা উক্ত নালিশি 462 নম্বর দাগের 10 শতক সম্পত্তি দেবস্থান সম্পত্তি হিসেবে রেকর্ড করাইছেন এবং উক্ত রেকর্ড মূলে তাহারা বাদীপক্ষকে গায়ের জোরে সম্পত্তি হইতে উচ্ছেদ তথা বেদখল করাইবেন।
The present challenge has been preferred against a judgment of remand. First up, in the trial court decreed the suit for declaration of title and permanent injunction instituted by the present appellant. First up, being aggrieved, the defendants preferred a title appeal, in connection with which, by the impugned judgment, the learned first appellate court held that since the suit was in the nature of a representative suit, the reliefs being deemed to be against the entire Hindu residents of the Krishnapur village, whereas only 14 random persons were selected as their representatives and named as defendants in the suit, the suit ought to be instituted in representative capacity within the contemplation of Order 1, Rule 8 within bracket 2 of the Code of Civil Procedure. Accordingly, the matter was remanded to the trial court with the direction that the learned trial judge, on completion of formalities mentioned in Order 1, Rule 8 within bracket 2 of the Code of Civil Procedure, would then proceed with the trial of the case afresh by hearing all interested parties and allowing them to adduce evidence afresh. Next para, however, the scope of the suit apparently was limited to rights in personam between the parties. The appellant claims title to the property by dint of a deed of purchase, whereby one particular plot of land was purchased. Adjacent to the said plot and through the same, a portion was recorded in the records of right as, what was the recording?
দেবস্থান হিন্দু জনসাধারণের
দেবস্থান, হিন্দু জনসাধারণের জন্য, double inverted close, full stop. Next para, learned counsel for the appellant argues that the plaintiff stroke appellant categorically made it clear that he does not claim any right over the said portion, said 1 shatok, which was so recorded in the records of rights, but asserts title in respect of the rest of the property, thus precluding any apprehension that any right was being claimed against the Hindu community of the locality. Even otherwise, although it has been averred in the plaint that the entire suit property never belonged to the Hindu community as a whole, ultimately the relief sought pertained to cause of action against the defendants in their personal capacity and not as representatives or members of the Hindu community or the representatives of any particular religious sect. Next para, thus, prima facie, it transpires that the learned first appellate court erred in law in remanding the matter instead of adjudicating the appeal on merits, on the erroneous assumption that the suit was filed in representative capacity against the entire Hindu community of the area. Thus, this appeal is admitted and will be heard on the above questions and on the other grounds taken in the memorandum of appeal. What sort of injunction? Stay of that. There shall be stay of operation of the impugned judgment and degree of the first appellate court till disposal of Can 1 of 2026. The appellant shall serve copies of Can 1 of 2026 on the respondents, indicating that the application shall be listed for hearing in the monthly list of September 2026, when an affidavit of service to that effect shall be filed by the appellant. The appellant shall also put in postal costs and requisites for service of notice of the appeal on the respondents within a fortnight from date. Push of the trial court records shall be brought by special messenger at the cost of the appellants, to be deposited within a fortnight. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant.
Great.
But the application is pending. You do this in the meantime, and the application will appear in the month.
Smart. Great. Thanks.
Lord, I am for the Lord, appellant is the Lord senior citizen, Lord. Appellant and Lord pro forma respondent one Minal Sarkar is the Lord joint owner of a residential house. Lord, due to need of Lord urgent money of Lord daughter marriage, Lord they decided to Lord sold the residential house. So Lord they intimated some broker.
Whose daughter's marriage? Your daughter's marriage.
Yes, Lord.
Their number 3 is your husband.
Husband.
Right.
Now, my lord, broker, my lord, communicated through my husband.
Who is Pinal Kanti Sarkar?
My lord, he is the my lord, joint owner of the brother of the appellant.
Very.
My lord, now, my lord, broker through my lord, communicated through the my lord, this plaintiff, my lord, respondent. There are some negotiation. My lord, petitioner, my lord, husband communicated through WhatsApp. Then, my lord, Milan Kanti Sarkar, my lord, co-owner, he have no my lord, connection with this communication or negotiation. Now, my lord, no agreement has been signed. Agreement prepared, but agreement has not signed. No earnest money has been paid. Now, my lord, this respondent, my lord, plaintiff, he filed suit for specific performance of contract. And
on the basis of oral agreement.
My lord, they stated my lord oral agreement, but my lord,
they state oral agreement.
Oral agreement. Then, my lord, ad interim order has been passed. Then, my lord, we file objection and my lord, order 13 rule 4. My lord, both are taken together hard and my lord, pass order that there will be not to transfer the property till the disposal of the suit. That order against my lord, I filed this.
No, some documents court says that it appears from documents filed on behalf of the plaintiff that indeed there were negotiations for transfer of suit property.
That is my lord, husband of the appellant, not my lord, appellant or my lord, other brother of the appellant. So joint.
No, but you are joint owners. Even if one of you and all of you, you have been added as defendants together.
Yes. Well, no agreement has not been signed. No earnest money has been paid.
What sort of documents you have produced?
Well, WhatsApp communication through broker, my husband.
What was the last communication? Let us see. You must have annexed it. That was a part of the injunction application.
That is plain my lord, they have my lord mentioned.
No, have they annexed those documents? Those WhatsApp communications?
No, my lord, I have annexed the my lord plain my lord, only. Page 14.
No, please annex those also. The annexures to the plaint or the injunction application, there were annexures to the plaint. Page 20, we see photocopy of the search slip. Other documents were annexed to the plaint. Photocopy of emails have been annexed. We want to see those documents also. Please just file a supplementary affidavit.
Yes.
We'll keep it next week.
Yes.
We'll take it up along with this.
Yes.
Since we find at the outset that the annexures to the plaint and the temporary injunction application filed in the trial court have not been made a part of the stay application, leave is granted to the appellant. Now, the appellant is directed to file a supplementary affidavit to Can 1 of 2026, incorporating the complete copies of the plaint and the injunction application, and a complete copy of the pleadings in the trial court. Full stop. The matter shall next be listed. Can you do it in 1 week?
Yes, my lord.
Be listed on August 11, 2026, next Tuesday.
Yes.
We just look into those documents to ascertain whether there is interactions.
Yes.
Thank you. Consensus had identified.
I'm for the appellate.
Yes, please.
See, originally petition is lossy.
Can we just take the microphone a bit closer to you?
Yes, lossy.
Yes, yes.
Original petition is lossy. The preemption petition. Preemption petition allowed to 12/2019. Then The respondent file.
Preemption under Mohammedan law,
No, Lordship, Hindu law.
the preemption suit,
Preemption suit.
I mean Succession Act.
Succession, no, Lordship, preemption suit, Section 8. Land Reforms Act.
No, Section 8, no appeal lies. First appeal lies before the forum.
Lordship, the appeal stage, petition file, the appeal stage, appeal petition.
Section 8 of the Land Reforms Act.
Reforms Act.
Against that appeal lies before the district court.
Yes, Lordship, we allowed the coming before Lordship the Order 22 Rule 4 petition here.
Passed in a preemption case.
Preemption case.
Appeal is not maintainable. It's not a suit. You have to prefer a 227 application.
Appeals, petition file, appeal stage, Lordship, the Order 22 Rule 4 and Section
Order 20 Rule 4 or
and Section 5.
Understood, but it's not a suit. Appeal does not lie because against the main matter, appeal does not lie.
Main matter, no, Lordship, the case petition.
The present appeal.
Appeal 22 2019, Lordship, appeal.
Section 5 in connection with the case has.
Appeal, preemption, appeal, connection with Section 5 and Order 22 Rule 4 petition.
So that Section 5 in connection with misappeal has been dismissed.
Dismiss.
227 lies. I will permit you to take back the certified copy. And the present appeal has been preferred against an order whereby an application under Section 5 of the Limitation Act, for condonation of delay in preferring a preemption appeal under the West Bengal Land Reforms Act 1955 was dismissed. Full stop. Next para. However, the said order is not appealable. Full stop. Accordingly, FMAT 125 of 2026 is dismissed as not maintainable, with liberty to the appellant to prefer an appropriate challenge before the appropriate court / forum. Full stop. Next para. We make it clear that the merits of the matter have not been gone into, and it will be open to the appellant to canvass all points in the challenge which may be preferred on the self-same grounds against the impugned order. Full stop. Can 1 of 2026 is consequentially dismissed as well. No orders to cost. Leave is granted to the learned advocate and record for the appellant to take back the certified copy of the impugned order upon furnishing a photocopy of the same. Thank you.
Because in this matter, I am for the respondent, same problem, but you know, the application, page 119.
Legeche? 1 minute. We have to save our officers first. কি হচ্ছে আজকে? হ্যাঁ, সাবধানে করো। এমবারেসড হওয়ার কিছু নেই, সবারই হতে পারে। কি হয়েছে? টুলটা কোনো প্রবলেম হচ্ছে? হ্যাঁ? দুটো টুল আছে ওখানে? দুটো তুলে দুদিকে পা দিয়ে তুমি উঠছো?
আমারও 119 কিন্তু এখানে মনে হয় বন্ধ
করো। Sorry. Yes, Mr. Shah.
This is revisable order, but
revisable.
But one problem is there.
First, let us hear the problem, then we hear the solution. Yes.
Last annexure of the application, Justice Umrai's order.
Yes.
He moved the revisional. Justice, I said, this is applicable. This is not applicable. This is revisable. In misappeal, the order was.
In misappeal, it has been passed.
One thing, your lordship can convert it and revision and send it matters.
Yes, but then we'll have to.
This order
stands in the way.
Justice Sumir Mukherjee initially told this is misappeal will lie. Then that is reversed by the other benches. Because main order is not appealable.
Exactly. What will you do with this order then? দিয়ে বসে আছি তো। করা যাবে না। You did not appear at
At that time, today also I do not appear. My Lani Junior said, "You please come and tell your lordship."
Mr. Mentos must not have been
He
there
was
also.
not there at that time.
He was not there. Then he would have pointed out. You should have told the learned judge.
Lordship, I have told. My submissions are also recorded, Lordship.
করা যাবে না। ওমের অর্ডারটা সেটা সেট করতে পারবো না আমরা এখানে। We're at a loss what to say. We are not getting in appeal over this judgment, this order. If as precedent, we could have overruled it as division bench. But it is between the same parties.
In one case, on one of my cases, Justice Biswit Basu told us to file an appeal. It was not revisable. Then Justice Tandon said, "No, this is single judge will say." Question is, who will hear this? Either single judge or division bench. Justice Basu said, "This is division bench will hear it." I could not persuade Justice Basu. Then Justice Tandon said, "No, this should be heard by the single bench." The lordship said this will be heard because of this law.
No, the appeal is not maintainable.
Appeal is not
non-maintainable thing cannot be converted to converted to a revision if you can do that.
The lordship can convert it.
Then also then the learned single judge has to hear it.
Yes, Lange single judge has to hear.
No, we have to overcome this order of justice, right? That is the difficulty. There is no other problem. You could have just passed a one-liner and said,
Problems recalling it.
So recalling ki bhave thi usko
please come back tomorrow. We'll just think it over once. We can keep it as to be mentioned. We'll keep it as to be mentioned so that we'll surely call it. Let it appear as to be mentioned. We'll just think it over for a day. Give us a day. Hey, yeah. Thank you. এটা না একটুখানি ফাইলটা একবার পাঠিয়ে দিতে হবে, উঠলেই পাঠিয়ে দেবে। হ্যাঁ, মানে ওঠার পরে একটুখানি ইয়ে করে নিয়ে পাঠিয়ে দেবে। কালকে টু বি মেনশনে দেবে। একটা লাইন রেকর্ড করে না অর্ডার, the in view of a question regarding maintainability of the appeal having arisen, comma, let the matter be listed tomorrow for passing orders under the heading to be mentioned. Department, it will be lost here, Mr. Yes.
Item number 59, Your Lordship, I am for the appellant petitioner.
অর্ডারটা হচ্ছে এই ম্যাটারই তো জেনারেল একটা অর্ডার হতো ওটা ওভার রেট করে দিতে পারতাম, করতে পারতাম। কিন্তু এখান থেকে এই পার্টিদের মধ্যে করে এই রিভিশনটাই পাঠিয়েছে। আবার তখনটা উমেশ বাবু কথা নেই, এটা একটু অর্ডার। সরি, ওয়ান মিনিট। Yes, sorry, please.
So I am for the appellant petitioner.
You're for the respondent.
Respondent number, yes, Your Lordship, 1 and 2 have filed caveat, so we have served to them.
Yes, yes.
It's a partition suit. Your Lordship, I am the son of Your Lordship, one of the daughter. Now, the ancestral property, Your Lordship, they have demolished, Your Lordship, and they are constructing a multi-storied building. So I filed a partition suit. The ad interim order of injunction was refused, and finally, the injunction was also refused on the basis that I could not, Your Lordship, submit a document for possession as well as title. These are the two things, Your Lordship.
Title document you could not produce.
Title, Your Lordship, the title document, Your Lordship, the father's property, Your Lordship. That's why, Your Lordship, I could not produce any title document.
The father must have had a title deed.
Yes, Your Lordship, the development agreement, if I show the development agreement, Your Lordship, clearly says that my father, Your Lordship, has suppose 4 sons and they excluded all the daughters. I can show Your Lordship the...
Your suit is simply seated for partition, or also you seek you are the son?
I am, Your Lordship, the son of Your Lordship, the daughter.
Oh, but you have challenged the development agreement also.
Your Lordship, kindly see, Your Lordship, the plaintiff, Your Lordship, has not mentioned the development agreement. Your Lordship, may I...
What document of title did you produce? You produce a genealogical table.
I produce the genealogical table as well as, your lordship, my PAN cards, my Aadhaar cards, where my mother's father, your lordship, is mentioned. And as your lordship, the document, government document, where shows that, your lordship, the person, your lordship, the common ancestor, his father, and my, your lordship, the maternal grandfathers are same.
Do they deny that relationship?
No.
Do they deny title?
No. The father's title cannot be denied.
The father's title, yes.
Yes,
That's not-
in development agreement, it is admitted. So she may just.
They are relying on the development agreement.
Yes, because on the basis of the
So they are
development
developing
agreement, they are developing.
Let us see the impugned order first.
Yes, your lordship. Kindly take, your lordship, the order which is under challenge.
75.
21st of February 2026.
What sort of injunction did you ask for?
Not to make any further construction about the document and not
Changing
to
nature, character, yes.
nature and character.
No, you also asked for not disturbing a joint position. For
Possession, your
injunction,
lordship, the possession, your lordship, is they are constructing a building. So therefore, your lordship, the possession, I am, your lordship, the son of, your lordship, the daughter.
that does not automatically mean that your son of a married daughter may not have possession, physical
No,
possession.
no physical possession can't be, your lordship, but through
Functional
them.
possession you have, but how can
Yes.
we how could the court grant injunction regarding your joint possession?
No, not regarding joint possession.
You also asked for that.
Yes, I asked
So
for that.
possession, even without possession, you are at least the.
At least, your lordship, there has to be some protection in connection with my share.
Yes, what do you say, Mr. Vas?
So far as the genealogical table I have denied it, means in my written objection to the injunction application, if my lord may kindly comes to page 38 once. Entire genealogical table has been given. The entire genealogical table has been sought to be disputed. My lord, if my lord may kindly take.
Do you deny that the relationship is denied, that they claim they are heirs of that?
I tell you, lordship, my lord, if my lord kindly turns to page 38 once. The genealogical table of the entire family has been given.
Yes.
But all the family members are not the entitled to inherit the property. Madam Bimala Sundari's Devi's husband was the original owner. His name is Hiralal something. He executed a will in favor of Bimala Devi. Will was probated. Thereafter, Bimala Sundari Devi executed a will in favor of the son of Jagabandhu, that is the grandson, Gautam and Siddhartha. Your lordship will get Goloknath, and the extreme left, the Gopinath is there. Thereafter, the Gopinath and Goloknath are the two sons who inherited the by way of a will. Thereafter,
from Bimala.
From Bimala. Now, will was probated. That will of Bimala was probated. Now, Gopinath died without any living any heirs. Goloknath became the 50%, and 50% of Gopinath also devolved upon Gopinath. Manas Goloknath's son is Gautam and Siddhartha, who are the defendant number 1 and 2, being the respondent number 1 and 2 before lordship. But this entire property of Gopinath and Goloknath, pursuant to the will executed by Bimala Devi, virtually devolved upon Gautam and Siddhartha, who are the defendant number 1 and 2, in exclusion of plaintiff and all the defendants. But that
Shormishta comes in.
Shormishta has not been given because Goloknath executed a further will.
Goloknath also executed
A further will. But that I have taken in my written objection. If my lord may kindly take to
those
the
wills are probated.
wills have been probated. Those
that is your defense. You have stated that.
Yes. In my written objection to the injunction application I have given, I have only one copy. May I hand over to your lordship because I will be annexing those documents.
Choose one of the judges and whoever seems better. I mean, in your favor, give it to him.
I tender unqualified apology, my lord. Only today.
No, you can choose one of them. We'll get a clue, and the other one will pass the judgment.
May I, your lordship, assist only one thing?
So if that is stated in the object.
I'm coming to that. Lordship, may I just hand over, your lordship, the copy of the development agreement once? Development agreement, I was not there at that particular point of time. That has to be mentioned regarding the title of the development
To
agreement.
annex it or did you crave leave?
It's a mistake, your lordship.
Have you craved leave to file that?
Lordship,
Anyway, let us see. Development agreement was a part of the trial court records.
Yes.
They produced.
No, we produced, your lordship, the copies of the development agreement where, your lordship, everything was mentioned that Jagabandhu Bormon, he has only 4 sons, Gopinath, Goloknath, Poreshnath, Devnath.
We'll continue tomorrow. We have some other engagement. The matter cannot be concluded due to paucity of time. Full stop. Let the matter stand adjourned till tomorrow.
Great.